of the Legal and Constitutional Affairs Legislation Committee inquiry into the Privacy and Other Legislation Amendment Bill 2024. I acknowledge the traditional custodians of the land on which we meet, pay my respects to their elders past and present. I'd also like to acknowledge and welcome other Aboriginal and Torres Strait Islander people who are participating in today's public hearing. The committee's proceedings today will follow the program as circulated. These are public proceedings being broadcast live in Parliament House and via the web. For the benefit of those participating remotely, I'm the chair of the committee, Senator Nita Green. I'm also participating remotely today. Thank you for allowing me to do that. I joined today by Deputy Chair of the committee, Senator Paul Scarr, who is in the Canberra hearing room today, and Senator David Shoebridge will be joining us. I remind witnesses that in giving evidence to the committee, they're protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Senate as a contempt. It is also a contempt to give false or misleading evidence to the committee. The committee prefers evidence to be given in public, but under the Senate's resolutions, witnesses have the right to request to be heard in confidence, and this is described as being in camera. If you are a witness today and intend to request to give evidence in camera, please bring this to the attention of the Secretary as soon as possible. If a witness objects to answering a question, the witness should state the ground upon which the objection is taken, and the committee will determine whether it will insist on an answer having regard to the ground which is claimed. If the committee determines to insist on an answer, a witness may request that that answer be given in camera. Such a request may, of course, also be made at any other time. A witness speaking for the first time should state their full name and the capacity in which they appear, and witnesses should speak clearly into the microphones to assist Hansard to record proceedings. Mobile phones and other electronic devices should be switched off or turned to silent mode. And I now welcome representatives from the first panel today. Joining us via video conference, we have representatives from the Uniting Church in Australia, the Synod of Victoria and Tasmania, Children and Media Australia, and the Alana and Madeline Foundation. Thank you all for taking the time to meet with the committee today. Information on parliamentary privilege and the protection of witness and evidence has been provided to you and is available from the Secretariat. For the Hansard record, can I ask you to please state your full name and the capacity in which you appear, and we might start with the Alana and Madeline Foundation.
My name is Ariana Kozim. I'm the Director of Policy and Prevention at the Alana and Madeline Foundation.
My name is Jessie Mitchell. I'm the Advocacy Manager at the Alana and Madeline Foundation.
Thank you. And Children and Media Australia, Professor Hansley.
I'm Elizabeth Hansley. I'm the President of Children and Media Australia.
And from the Uniting Church, Dr. Zinzak, if I pronounced that correctly, is that
Dr. Mark Zernzak, Senior
Social
Justice Advocate. That's okay. Senior Social Justice Advocate for the Uniting Church in Australia's Synod of Victoria and Tasmania.
Thank you very much for joining us today. Now, I'm going to invite you all to make a brief opening statement, but I have to stress the word brief because I know that all senators have questions for you, and they're of probably from on different issues and different parts of the bill. So if I can invite you to make a brief opening statement, we're sort of trying to keep those to 2 to 3 minutes today, but we'll have an opportunity, of course, to ask you plenty of questions and for you to take those questions on notice if you don't get a chance to fully answer them. So if we start again in the same order, the Alana and Madeline Foundation, do you have a brief opening statement?
Yes, I do. Thank you. I'm here today representing the Alana and Madeline Foundation as a leading national for-purpose charity dedicated to keeping children and young people free from violence and trauma. We have a strong focus on upholding the rights of young Australians in digital environments. We're proud to work with the Commonwealth Government to make our eSmart program freely available to all Australian schools to empower students to become positive digital citizens. While education is crucial, it's not enough on its own. We also need to see changes to legislation and regulation. Digital technologies are a huge part of children's everyday lives. They use it to connect, communicate, learn, create and play. These technologies bring many benefits and opportunities, but they also come with risks. Like an iceberg, the visible concerns of the digital environment are above the surface. Things like cyberbullying, scams and exposure to harmful content, such as pornography, misinformation and violence. These are the immediate concerns that affect Australian families and have led to calls for change. But there's a bigger issue lurking beneath the surface that is the root cause of many of these risks. That is, children's personal information and how digital platforms are collecting and using it. When children go online, they're entering a data economy, where many platforms profit by collecting and sharing or selling highly personal information, often to advertisers. To maximise data collection, many platforms are designed for compulsive use to keep users engaged with features like frequent notifications, autoplay, and endless scrolling. They also use algorithms, predictive analytics, and low privacy settings to push content and keep users hooked. These risky features can lead to harmful consequences such as disruption to children's concentration, mood and sleep, contact with strangers, and exposure to inappropriate content. To fix this, we need age-appropriate design and safety by design in digital products, and we must reform what platforms do with children's personal information. That's why we welcome the introduction of the Privacy and Other Legislations Amendment Bill 2024, especially its provision for a Children's Online Privacy Code. A Children's Online Privacy Code, if well designed, enforceable and appropriately resourced, would provide a strong foundation for change. For example, it would prohibit trading in children's personal information and prohibit direct marketing and targeting to children unless it is in the child's best interests. These approaches were proposed in the report to the Privacy Act review and were agreed in principle by the Australian Government. A code could also require industry to set children's accounts to private by default. We welcome the bill's provision that the Commissioner consult with the community before drafting the code, although a consultation period of at least 60 days would allow for more meaningful engagement, especially with children, than the 40-day period currently proposed. The bill will apply to social media services, relevant electronic services and other designated internet services likely to be used by children. This is essential since children do not only use platforms aimed specifically at them, their digital experience spans a wide range of services. However, we do have some concerns. Focusing the code on social media, designated internet services and relevant electronic services will not fully address the risk of children's data. We urge in-depth engagement with the Privacy Commissioner as to whether this is sufficient to capture threats to children's personal information in other digital environments such as search engine services and app distribution services. There's also the exception for health services, where while we agree that children's access to healthcare shouldn't be reduced, we're concerned about the proliferation of commercial platforms marketing health products and services of varying quality to children, including nominally free products, presumably based on handling personal data. We believe that protection should extend to all digital spaces where children's personal information is at risk of exploitation or misuse. Finally, we support the bill's inclusion of the definition of a child as anyone under 18, aligning it with both the Online Safety Act 2021 and the UN Convention on the Rights of the Child. This is crucial as we've seen efforts by the tech industry to limit protections to younger age groups, for example, the first round of the industry codes under the Online Safety Act. We see these reforms as a once-in-a-generation opportunity to reduce the risk to children in digital environments, protect them from exploitation of their personal information and other intrusive practices, and uphold their rights. Thank you.
Thank you very much. Professor Hansley, do you have a brief opening statement you'd like to make?
Yes, I do. Thank you very much. Thanks for this opportunity to contribute to the advancement of privacy law in Australia. I doubt I'm the first to comment to the committee that these reforms are long overdue. CMA is particularly pleased to see the priority being placed on children's rights and interests in this tranche. Obviously, as a child-focused organisation, we believe that all law reforms should proceed in this way. Children have a right to privacy under Article 16 of the UN Convention on the Rights of the Child, but more generally, and perhaps more importantly, they have a right to access the internet safely. Given the business models of most companies that provide access to content and experiences online, that safety is heavily dependent on protection of their data. Another important but often overlooked angle on children's rights in all areas, but especially in relation to new technology and powerful corporations, is that parents have a right under Article 18 of the Convention to support from governments in raising their children and protecting their rights. These reforms are in line with the government's obligation under Article 18, and that obligation should guide any further developments. Earlier this decade, CMA engaged in a research study on the way that popular children's entertainment apps collect and use data. We found that at the time of checking, 59% of those apps had some level of problematic data collection behaviour, be it transferring data in an insecure manner or transferring information about a user's device to ad-linked companies. These precise findings might no longer be reliable, as those individual app developers may have improved their practices, but there's no reason to think that the landscape overall has improved for children doing something as simple as playing on an app. This is just one piece of evidence as to the importance of introducing robust laws to create an incentive on all those responsible for creating and disseminating online content and experiences to take children's privacy seriously. As stated in our written submission, CMA is delighted at the prospect of a children's online privacy code, and I could say yes to all the above from Ariana's comments. We note also that such a code could take many forms and could contain or omit many different kinds of provisions. So we've got quite a way to go before we can say, yes, this is absolutely what we want to see and what works best in children's interests. The fact that the code's development will be in the hands of an independent government body rather than an industry body gives us some hope that it will have real teeth. However, we also trust that bodies like us will be given rich opportunities to contribute to the development of the code, and that children's rights, as understood in light of documents such as General Comment 25 on children's rights in the digital environment, will be at the centre of all decisions. We also look forward to the second tranche, hopefully in the not too distant future, and hopefully to cover other vital matters such as the definition of personal information, the fair and reasonable test for processing data, and a prohibition on targeting children. That concludes my opening statement.
Thank you very much. And Dr. Zernek, do you have an opening statement?
Very quickly.
Thank you.
From our synod, we've had a long engagement around trying to see the online world be a safer place. We recognise there's a balance to be struck between privacy rights and other measures that are needed to provide safety. The bill before us provides welcome steps forward on addressing some of those privacy rights and the risks of exploitation of children through breaches of privacy. And particularly, we've had a focus in the schedule on the doxing has been an area where we think there could be a little bit of strengthening taking place there. On the other side, we also recognise, while not in this bill, there are always risks with enhancing privacy rights, that you can make an environment less safe, particularly if those privacy rights can be misused by predators in the online environment. But happy to open to questions at that point.
Yeah, thanks very much for those opening statements, and thanks for keeping them relatively brief. We'll hand over to questions now, and I'll hand the call to Senator Scarr to kick us off. We'll probably get around 10 minutes each between the three of us, if that gives you a good guide.
Oh, that's fine, Chair. That's certainly enough. Can I first ask Dr. Zernsak, and good to see you again, Doctor. I think last time we saw you was in relation to modern slavery. So thank you for engaging in the committee process. You raise in your submission questions around the definition of vulnerability. What is your concern in that regard? Don't you think the plain, simple English meaning of vulnerability is sufficient? Why do we need to go to the next step and expand the definition as you suggest?
The concern I've got that I've raised here is that courts might take a fairly conservative view of what constitutes vulnerability. And we've certainly seen that in our experience in the area of gambling harm. So often when cases have come before courts addressing people who have been vulnerable to gambling harm, the courts have taken a very high bar on what would constitute vulnerability. And in those cases have often allowed the gambling providers, so even where a person may have said, I've got a gambling problem, I need you to help me stop doing that, and then the venue has targeted them with further marketing to get them to lose more money, the courts have tended to take a view that that doesn't constitute sufficient vulnerability, that the venue have had a duty of care. So in this case, we feel the Act would be enhanced by offering some guidance to the courts about where that line on vulnerability exists.
Right. So the definition that you proposed is whereby a person is in danger, under threat, experiencing health challenges, at risk or requiring support or protection. Can I just ask you, was there any other law or source that gave you the inspiration for that definition? Is there anything we can refer to where a similar sort of definition has been applied? So any context?
The references that I've provided in the submission pointed to the laws of other jurisdictions. Vulnerability is defined under a range of different acts in other jurisdictions globally, and that was drawing on them. But look, there are a variety of definitions of vulnerability used. They will vary depending on the context in which, whether it's a mental health act. So, it was suggesting there that was being offered to you as a broad definition that did come out of some of that research. Those references do actually point to other acts, and some of those acts have a more narrow definition. For example, I've given you the one there used by vulnerability by the UK Department of Health, which is a person may be in need of community care services by reason of mental or other disability, age or illness, or who may be unable to take care of themselves or unable to protect him or herself against significant harm or exploitation. So that's clearly taken from another jurisdiction. It's a more narrow definition about vulnerability, but it's at least offering, in my view, it would be at least offering some guidance to a court about how vulnerability might be considered.
Okay. Are there any examples in a privacy context that you're aware of? You may not be. I mean,
No, I didn't find any in that context. So my apologies within the. No.
No need to apologise. It's a good issue you raise, and I thank you for it. If I can just stay with you for the moment, Dr. Zernsak. You make a point on page 2 of your submission that, and you provide this in the context of some case studies, and you reference the work of a journalist, Ginger Gorman. So you suggest that harassing someone, especially a vulnerable person, to urge them to take their own life should be regarded as harassing or menacing the person. So again, on the face of it, I would consider that to be a prime example of harassing or menacing a person. Does the fact that you're proposing that specificity indicate that you're concerned that that sort of egregious activity might not be covered by the phrase?
Look, I mean, the view there was it was highlighting that is a particular risk. I think if the committee was confident that that would fall within the category, there may not be a need to specify it. Again, it was probably just adding further safety in case a court might take a narrow view. But I probably am inclined to agree with you on this one that it would be. I would hope that the court would see that someone being harassed for the purposes of trying to encourage them to take their own life would constitute harassing or menacing. Although, some of the language that the trolls use, it's about targeting vulnerability. So whether it doesn't need to be menacing, the question might be, is there a grey around harassing? So if I'm not actually applying menace, we're then into the definition of what constitutes harassment towards encouraging a person to take their own life.
Look, and I think that's a point well made. The engagement Gorman had with some of these people is particularly disturbing, and there's obviously a real malicious cunning underpinning some of this activity. So I'm certainly open-minded to it. It's very disturbing, to be frank. You then urge the addition, and this is on page 3 of your submission, under section 474.17D, you propose the addition of people who were survivors, victims of serious crime, and their immediate families. And again, I can understand the reason, I think, underpinning that. again, is there a particular concern that there are examples of such people being targeted?
Oh, absolutely, and the references I've given you there do highlight that is the case, that in the online world, people who are either victims of crime or the families of can be targeted, and that's particularly in relation to child sexual abuse. So, as highlighted in the evidence given there, you do have perpetrators who will try and hunt down even once a child's been sexually abused, when they become an adult, networks of perpetrators may try to hunt them down and hunt down their children as well and target them for harassment or abuse. So I think having that as the specific categories would be a welcome addition to the bill, as an addition that isn't complex to add, I wouldn't have thought, to the bill.
Yeah, no, it's quite horrifying, actually. It's deeply disturbing. Can I ask the other witnesses if they've had a chance to read the Uniting Church submission and those proposals, and whether or not they agree to those recommendations? So I might go to you first, Professor Handsley. No, the Children and Media Australia, are you there? Can't hear me?
Yeah, I think she's lost.
Might just be a technical issue, Senator Scarr, if you want to put your question to one of the other witnesses as well.
Okay, the representatives of the Alana and Madeline Foundation, can you hear me?
Yes, it looks as if there may be a slight tech glitch at Elizabeth's end, but I have read the United Church submission. I will say it's not a space that the Alana and Madeline Foundation has worked in detail in the past, so I'm reluctant to say much specific about that, other than to obviously share those concerns for children's safety online. I do wonder whether the International Centre for Exploited Children's Australian branch has had the opportunity to comment to this inquiry. We are a member of one of their networks, and it strikes me that a group who probably haven't.
Oh, sorry, your audio's just breaking up. That's not your fault. It's the technology, as we call it. Who was that? Who was that organisation you were referring to? I just think that's important to get that on the record.
The International Centre for Missing and Exploited Children. They have an Australian wing that's recently become very active in this space. I do apologise for my tech. That's not good. Okay,
thank you very much. Professor Handsley, can you hear me now?
Yes, I can hear you, but you did cut out during the question. I gather that we're being asked if we are able to comment on the Synod's submission, and
correct.
I have to advise I haven't read that submission, so I would really prefer not to offer any comments other than to say that what I was just hearing during Dr. Zernsak's comments was indeed troubling, and I very much hope that the committee will take all of his comments on board and work them into the legislation as necessary, or work them into your recommendations as necessary.
Okay. The next question I had is this concept of services likely to be accessed by children to which the code would apply. We have received a submission from the Interactive Games and Entertainment Association, which are concerned about what likely to be accessed by children actually means, and the potential vagueness of that definition, and they proposed that the code should apply to sites which are or services targeted at or directed to children, end quote. So just in terms of some preamble on this, this phrase likely to be accessed by children, on one analysis you might say nearly every service is likely to be accessed by children, at least a number of children. Some sites are more likely to be accessed than others, But I'm very interested in the thoughts of the witnesses in relation to this phrase, likely to be accessed by children. Why you think, if you do think, that it's necessary to cast the net as wide as possible, and whether or not there are any other iterations of that phrase which are used perhaps in other jurisdictions, including the UK. So I might start with you, Professor Handsley.
Thanks very much, Senator. Yes, I do have some thoughts on that. I have quite a long history as a legal academic engaging with and analysing and critiquing legislation on a range of matters that are supposedly trying to protect children's interests and rights. And this is a fault line through a lot of different areas, that distinction between targeted at and likely to be accessed by. If you're really serious about protecting children, you look at where they are, not at where people want them to be. The intentions of the person putting out the information or the content or the online experience are irrelevant to whether a child accesses them or not. Now, I think there would be some services out there that would be unlikely to be accessed by children. I can't name any right now, but if we all thought for a few minutes, we could probably come up with some ideas of things that are just not of interest to children, unlikely to cross their radar. But yeah, children are curious, and they do have a right to go online and find information and get experiences, and they need to be kept safe in all of those places. So if we really are serious about keeping children safe, then we apply the legislation and the regulations where the children are, and we limit their exposure to the relevant risks rather than cutting it down to be a matter of what the aim was in putting that information out. I can't stress this enough, actually. I'm so glad that you raised this point because it's a really, really fundamental one. And I'll just say it again, if you're serious about protecting children, then you apply the regulations where the children are and you make predictions about where they're likely to be, which I don't think is a terribly difficult thing to do. I'll leave it at that.
Can I ask you, especially given your academic background, are there any other...
Senator Scarr, I'm going to have to share the call. I know that you had a follow-on question from this. I've let you go a little bit longer because you're actually asking similar questions to what I had intended to ask, but I do need to share the call with Senator Shoebridge.
Sure.
I'm not sure if you want to ask these questions to be put on notice, perhaps.
Well, maybe, Chair, so Senator Shoebridge has an opportunity. If I could ask all the witnesses to take on notice and perhaps give some further thoughts with respect to this issue of, or fault line, as it was described by Professor Handsley, between likely to be accessed by children as opposed to what the Interactive Games and Entertainment Association's proposing, target at or directed to children, end quote. And in the context of answering that question on notice, if you could also provide any information you've got with respect to other formulations of that test in other jurisdictions and what the learnings are, if any, from those, I'd find that most useful. Thank you.
Yeah, thanks, Senator Scarr. That would be very useful to the committee, so thank you for taking that on notice. Senator Shoebridge, you have the call now.
Thanks, Chair, and thanks everyone for your engagement and your submissions. You all broadly support the Children's Code, and I think that's kind of echoed across submissions. But pretty much every submission says, apart from some from the industry, that you need to have a kind of broad definition of what the code will apply to. If you narrow it only to services directly targeting children, then you'll probably miss most of the large social media platforms. And that would be a very dangerous narrowing, wouldn't it? Would make it ineffective. Does anyone want to comment on that?
Other than just to nod my head, no, I don't think I need to say any more.
Yeah, and I miss... Yeah, does anyone else want to comment? Ms. Mitchell?
I was just going to say, I think one of the other challenges here, of course, is that in the online environment, you actually don't know who people are. or their age. So in the current way the environment works, a child can enter adult spaces without much, and as someone who plays some online games, I'm always very conscious that, I'm leading a group of 20 people in one of these games and I've got no idea what their ages are, and sometimes I have to remind some of the adults in the group to, behave accordingly.
Yeah. If I can add something to that as well, Senator Shepherd, you've mentioned the social media companies. One figure that caught my eye recently from the global data and business intelligence platform Statista observed that about 90% of Instagram users in Australia are aged 18 or over. Instagram, for example, Meta, could very plausibly claim they are not a children's service, and yet we know that Instagram in particular is highly popular amongst under 18s, and while there's a lot of positive experiences there, it's also historically been a site of very significant risk to children. We think it is very important that the code capture all digital environments where children's personal information is vulnerable to misuse. And in terms of what likely to be accessed would mean in practice, the UK Children's Code does provide format, if you like, of what that guidance would look like. They say it's a digital environment where the probability of children accessing it is higher than the probability of them not accessing it. And they do provide some guidance to services as to how to make that assessment. I do agree it can be a challenging point for a service to assess, and that is a space where we'd want to see the regulator, the Office of the Australian Information Commissioner, being adequately sourced to provide that expert guidance.
Of course, the proposed definition of services that will be an APP entity bound by the proposed Children's Online Privacy Code is quite narrow. It talks about the entity being provider of a social media service, the service likely to be accessed by children, not providing health service, etc. That excludes a number of spaces where children's privacy is already at risk. And I might start with EdTech. It seems to exclude EdTech. Do you see any rationale for excluding EdTech from this code?
No. That was something I was hoping to get a chance to bring up in the course of this hearing, that the exclusion of EdTech is...
Ms. Consider this an open door to discuss why EdTech should be roped in. Yeah.
Well, I can just start with what you just said, Senator. That's absolutely true. There is no justification, and I can draw the committee's attention to the fact that there has been a law centre or a law firm set up in the US for the sole purpose of suing EdTech companies for the way that they treat children's data in that country. And the outcomes of that litigation will hopefully be beneficial to other jurisdictions such as ours. But I think the existence of a law firm solely dedicated to dealing with EdTech's breaches of children's privacy tells you there is a major issue there that this legislation really should be addressing. And CMA would be delighted to see that added in at this stage.
Well, during COVID, we saw Google Classroom literally march through our entire education sector, suck up huge amounts of data about kids, and now they wouldn't be covered by the Children's Online Privacy Code. How have we got to this point?
Yeah, I couldn't answer that. I don't know how that got excluded, nor do I know, why we are dealing with these few recommendations from the big privacy review in this tranche of reforms. There are decisions that are made somewhere along the line that people like us don't have any control over. But if there is any opportunity to reverse that one, I think we'd all be very pleased to see that.
Ms. Kozem?
Thanks, Senator. We would also like to raise our concerns around EdTech not being included. I think in our original submission to the Privacy Act review, we did talk about that, and specifically a piece of research that's come out from the Human Rights Watch, which raised some significant concerns about EdTech products not being used here in Australia, and they profiled some, I think, being used by the Victorian Department of Education and another Department of Education. Jessie will be able to remind me. But yes, I'm glad that it was raised because we have got concerns around EdTech, and I guess the example of how there was a loophole that was created with the UK Children's Privacy Code, and I think that that's now been closed off, but it would be good to learn those lessons from the UK example.
You see, this in some ways shows why putting off a number of important reforms to tranche 2 actually leaves children's privacy incredibly vulnerable. And one thing we could do with this bill is actually drag forward some of those tranche 2 reforms, such as fixing the definition of personal information to include geolocation data and tracking data, and also putting a fair and reasonable constraint on the use of people's data. And we could do that in this bill, and that would provide significant safety benefits for children, wouldn't it?
Well, that would depend exactly what is done. And I guess, while I would be, again, really delighted to see extra things added into this bill that would provide further protection to children, I would have some slight concerns about the process of adding things in that would otherwise be tranche 2 that haven't been subject to the same consultation process that these particular reforms have. Because, for example, we wrote a written submission, as you know, about what's currently tranche 1. We've been able to provide our comments on that. And if these extra things that would otherwise have been tranche 2 were added at this stage, then we wouldn't have had the opportunity to comment on them, and we might not agree with what the Parliament was proposing to do. So it might have some reservations about that, even though it's a nice thought that we could get even more through earlier. And I do take your point, Senator, that there might be a period of shaky protection because there are so many gaps in it. But at the same time, I think we've taken the view that it's best to just get on with what we can get on with at this stage, and not allow the perfect to be the enemy of the good, as we keep on saying in this field. Yeah,
well, of course, this reform commenced 10 years and 50 days ago. I don't think we could suggest that we've been lacking consultation. A reform that began on the 3rd of September 2014 has had multiple layers of consultation, and pretty much everybody says personal information should have an extended definition. That's been discussed in the Law Reform Commission, the review, the response to the review, the submissions to this inquiry. Does the Uniting Church have a view on those amendments, extending the definition of personal information and a fair and reasonable test on data use?
And before you answer that question, Senator Shoebridge, you've got one more question after this, and I'll hand the call around. Thanks. Sorry, Doctor, for interrupting you.
That's all right. Look, we are supportive of broadening this out. Our concern at this stage, though, is given where we are in the parliamentary cycle, the fear would be if this gets held up, whether it would actually still pass before the election is. I guess that's the thing that weighs on all of us now with any bill that's before the parliament, and therefore it feels politically more realistic to hope that the committee might make some recommendations about strengthening that are likely to be agreed to without much further. And I'm also very conscious that the go-to that industry always has is we haven't been consulted on it. We both know that often gets used even if they have been consulted for 3 years, and really what they mean is we don't like the outcome, and therefore we'll keep arguing that we weren't consulted.
Yeah, well, I think 10 years and 50 days is not a bad period of consultation on privacy reform. Some might suggest it's a little long. Could I just ask Uniting quickly on the proposal to expressly prohibit harassment and the urging of someone to take their own life? All of the examples you put in your submission are horrific, and you could see how we would want to take legislative action to prohibit it. But could I ask you to take on notice, unless you're able to respond to it now, the UK made a number of these changes, I think, a couple of years ago, about 18 months ago. And then there was very real concern from some of the support organisations, mental health support organisations, including the UK National Survivor User Network, that the UK definition was overly broad and potentially criminalised peer-to-peer support about self-harm. Would you mind having a look at that and responding? If you're able to now.
Happy to take that one on notice. No, look, I wouldn't be in a position to respond now, but thank you for raising it, and I'll have a look and try and get back to you on that as quickly as I can.
Yeah, because we wouldn't want to prohibit that peer-to-peer support being provided online, would we?
Completely agree. I think, the intention here is where someone is urging someone else to engage in serious self-harm, I'll be interested to look at why that would somehow impact on peer-to-peer support.
Yep.
Thanks, Senator Shoebridge. I just have a couple of questions, and I'm conscious of time, and some of the issues that I wanted to raise have been covered. I just want to really understand clearly a lot of the positions that your organisations hold will be either opposed or, there might be an attempt to water them down by some of the other witnesses or submissions that we receive. So I just want to be really clear about your views on the definition of a child. I know we raised this and some of you raised it in your submissions. Some submissions have called for the age to be lowered, but I just wanted to get really clear from your organisations about what your views were on defining a child as someone who is under 18. Might go to the Ms. Mitchell or Ms. Yip.
Thank you. We strongly support the inclusion of a definition of 18. This would align with the definition that's in the Online Safety Act and also with the United Nations Convention on the Rights of the Child's definition. It would also be in keeping with the definition used by the UK Children's Code, which was put forward as a potential model Australian code, and which we see as unfortunately, it has been our experience that where industry has been permitted to set a lower age definition of childhood, this results in lower default protections for children. One of the examples that my colleague had talked about occurred in the first phase of the development of industry safety codes under the Online Safety Act. These codes were drafted by industry and they introduced a definition of what they called a young Australian child, meaning a child under 16. And it was only for that category that social media services were into the new code to introduce high privacy settings by default. That's a lower threshold of protection than a number of other countries have. So, no, we think that children up to 18 should have a right to these inbuilt protections for their personal information and the flow-on effects that has for their experience and safety on this.
And CMA, do you have a view on that as well?
Yes, I could just basically agree with everything that Ms. Mitchell just said and point out that developmentally, human beings aren't fully mentally mature until 25. And so if we were going on the science and not the politics or the social aspect of it, then we might even put it higher than 18. We would see that people even older than that could do with some support. But as a realistic and politically palatable age, then 18 seems to be a very good place to land.
Yeah. Thank you. We had a discussion previously with Senator Scarr about the term likely to be accessed by children, and thank you for your evidence there, and I think you're going to take a little bit more on notice and get back to us, but I just thought I might ask so it's clear, is that your preferred definition or the preferred term for the bill to use? Because I imagine that is something that we will have evidence to the contrary. So I just want to really understand if that is the preferred term that the bill should have. There's lots of nodding, but we might need to get that on hand. So unfortunately,
I will go on the record.
Yeah, thanks.
For interrupting. I will go on the record as saying yes. That certainly that concept. Whether that is the absolute perfect way of expressing the concept, I'm not completely sure, but it certainly captures what I think is the key relevant concept, and that is what children are likely to be exposed to, because we are protecting them from exposure to something. We're not protecting them from having things aimed at them. We're protecting them from being hit by things. And therefore, that kind of concept is really, really key, and it would drastically weaken this legislation if we were to move to a targeting or directed or aimed sort of concept.
The Foundation would strongly support that position as well. If we limited these protections only to child-specific products and services, it would only capture a fraction of what children actually experience.
I mean, ideally, sorry, I was just going to say, ideally in this space, you would want the regulator almost to be checking what kind of things children are accessing in reality. So just because a provider says, oh, well, my content is targeted at adults, like it's an adult game or whatever, does not mean children are not accessing it. So you'd almost want this sort of checking to sort of say, well, is this really a product that children are not accessing, or in this case, are they likely to be accessing?
Yeah. And I could just add one more thing, which is that in other fields, like, say, advertising regulation, there's plenty of precedent for companies that are putting out information and content being very clever about how they design things to make it so that they get access to the child audience, but they can put their hand on their heart and say they were aiming it at somebody else. So I would really strongly urge the committee to stick to what's currently being proposed.
I think every time I have banana bread for breakfast, I think I'm really just eating cake. This is just cake. And it's a similar concept. Really quickly, sorry, I have one specific question for the Uniting Church. Your submission notes that you welcome the creation of 2 new doxing offences in the criminal code. Can you just talk to us about how you think that it's important to have those specific doxing offences? You might have touched on the concept a little bit earlier with other senators, but those specific offences will come up a few times today, so I thought I'd invite you to talk to those.
Look, it did feel like it was those offences were filling a gap that exists, and the risk always is the danger that someone is being targeted for harmful behaviour, and the legal team who are defending the perpetrator will try and argue the existing offences don't cover it. So the more that we can make sure there aren't gaps in the law, the better it is. And our view was that this was filling gaps to make sure that even if others want to argue, well, possibly you might be able to use another law on some of this, this just makes it really crystal clear and ensures that on these matters of doxing, there will be a very clear and specific piece of law that will allow that behaviour to be addressed.
Thank you very much. I appreciate that. That's all the time we have, but we have asked you to take some questions on notice, so thank you very much for doing that as well, and thank you for your submissions and for your time today with the committee.
Thank you for the opportunity.
Thank you.
Thank you.
Thank you. We're going straight into our next panel, and I believe our witnesses are joining us in person. Am I right? Yep. So I now welcome representatives from AUDA, the Domain Administration Limited, and the Tech Council of Australia. If you could make your way up to the table, that would be great. Thank you. Wonderful. Welcome. Thank you for taking the time to speak with the committee today. Information on parliamentary privilege and the protection of witness and evidence has been provided to you and is available from the Secretariat. For the Hansard record, can I ask you each to please state your full name and the capacity in which you appear today? We can start at one end of the table if that's helpful.
Hello, my name is Erica Lee and I'm a Policy Manager at the Tech Council of Australia.
My name's Harry Godber and I'm the Head of Policy and Strategy for the Tech Council of Australia.
Good morning, my name is Jordan Carter. I'm the Internet Governance and Policy Director at OUDA, the .eu Domain Administration.
Annalise Williams, Specialist Policy Advisor at the .au Domain Administration.
Thank you very much for joining us today. And thank you for your submissions. They're very helpful. We're asking witnesses if they wanted to make a brief opening statement today, stressing the brief as part of that statement, just because we do have a lot of questions to get through. But I'll start with the Tech Council Australia, if you have a brief opening statement you'd like to make.
Thank you, Senator. Privacy reform is one of the highest priorities for the Tech Council and our members. This is because privacy laws are fundamental regulatory settings that guide tech companies in their product design, growth, risk mindset, and engagement with consumers. We have consistently supported the need to modernise Australia's privacy laws. Well-designed privacy laws need to build the necessary security, confidence, and trust for our digital age in protecting the personal information of Australians. Australian technology providers are the building blocks of our digital economy, the gateway for our nation's future economic growth and complexity. It's vital that we provide certainty, international alignment, and interoperability to ensure that Australian companies are well positioned to serve customers with high-quality products, grow into global markets, generate investment, and create jobs in a leading and competitive digital economy. The Tech Council is supportive of a number of the key provisions in the proposed bill. This includes amendments to recognise the public interest in protecting privacy, for reasonable steps in the context of the Privacy Act to include both technical and organisational measures, in clarifying the factors that determine a serious interference with privacy, as well as the provisions that enable a mechanism to prescribe countries that offer similar protections to the APPs. However, we have significant concerns regarding this bill. This committee has been tasked with considering a first tranche of measures that introduce a range of new rights, obligations and penalties, but we're doing so in a context where the government has committed in whole or in principle to substantively transform the framework in which these measures should be viewed, such as introducing distinctions between controllers and processors and introducing GDPR-like rights to be forgotten. It is very challenging for the committee to consider any law reform in a piecemeal fashion, but particularly where the second tranche of proposed reforms are both unclear and such a significant step change in the nature of privacy law. Our concerns principally, though, lie in four key areas of this bill. The first are the provisions on automated decision-making in APP 1.7 to 1.9, which we believe are vague and uncertain, which will render them difficult to understand and implement for tech companies. The second is the introduction of the statutory tort, which risks introducing duplicative provisions into the Privacy Act and needs to incorporate a serious harm threshold to ensure that the efficient operation of the legal system in facilitating claims can be achieved. And it also poses significant constitutional risk, which we're happy to go into more detail with the committee on if desired. Thirdly, the infringement notices regime for minor contraventions of the Privacy Act abrogates the principle-based nature of privacy regulation in Australia, and it does not reflect the need for privacy law to be adaptable to evolving technology and ways of interaction with it. And finally, the new powers of the Information Commissioner to develop APP codes are unclear in their scope of applicability, and they don't necessarily reflect the way in which technology companies manage data in practice, particularly in respect of temporary codes. We want to make it clear to the committee that we're not opposed to reform. We believe that privacy law reform needs to be designed in a way that enables Australia to be a leading digital economy, and we are encouraged to see the government taking steps forward with this first phase. However, we believe the proposed bill is not sufficient on its own to modernise Australia's privacy laws, and it's imperative that they be systematically reformed and modernised to ensure that our framework as a whole is fit for purpose in the digital age. We implore the government to move forward with the second tranche of privacy reforms as a matter of urgency and to consider these matters in the context of that updated regime.
Great. Thank you very much. Mr. Carter, do you have an opening statement you'd like to?
Thank you, Senator Green. I'll keep it very brief. The ADA is the organisation that operates the .au domain name space under a terms of endorsement from the Australian Government. So we bring a perspective to this legislation that is based on that expertise. Our overall view about privacy is that privacy law should encourage organisations to minimise the collection, retention and utilisation of data because then breaches will have less of an impact. And so we welcome the efforts in this bill and in the overall review to strengthen the privacy law of Australia. We welcome the addition of provisions related to automated decision-making because the increased use of such processes does mean that where AI is used in that way, consumers or users of services should be made aware of it. And we've done research in our Digital Lives research which shows that consumers are increasingly concerned about the security of their data, would feel more comfortable with AI tools if there was stronger regulation around them. Secondly, efforts to increase clarity around the privacy obligations that businesses face, such as the proposed overseas disclosure regime, would also be helpful to businesses who may need to regularly exchange data overseas to provide critical services to their users. And thirdly, while we await more detail on future tranches of privacy law reform, we acknowledge the complex interweaving of legal, commercial, and individual rights and interests that plays in. There has been a long period of review here, but often the devil is in the detail, and it's not until you see the specific legislation that you can actually come to meaningful grips with what is required. So where that complexity arises, sometimes it is worth taking the time for a really robust debate, and it's good to see the committee engaging that today. Thank you for your time.
Thank you very much for that brief opening statement. I appreciate them, both of them. We have a lot of questions for you, so I'll kick off with Senator Scarr.
Thank you very much, and thank you for you both appearing. Do you think this needs, Mr. Godber, do you think this needs more time to be considered? I'm sort of getting to grips with submissions that we're receiving from a range of stakeholders. I've just received the Law Council of Australia submission, which is quite concerning. Just to quote, I'll seek your views on this. Paragraph 19 of the Law Council of Australia submission says, this truncated process is highly problematic from the perspective of broader public scrutiny of the making of Australia's laws as part of a democratic process. This is a regrettable and increasingly prevalent consequence of the parliamentary inquiry timeframes during this parliament. This trend also undermines the Law Council's role as a membership-based peak organisation in which we have an obligation to consult with our constituent bodies, end quote. So they're raising red flags in relation to the timing. The timing is out of this committee's control, to be frank, as I've repeatedly said. But do you think this needs more time, especially given the materiality of many of the issues you've raised?
I do, Senator, and it frustrates me to say it because we're, as Senator Shoebridge pointed out earlier, approaching the end of a 10-year process. Parts of this bill have been considered for far longer. However, privacy law is fundamental to the way that tech companies hold data, and changes to privacy laws will force tech companies to change the way in which they manage their operations in a fundamental manner. And so the risk of proceeding with haste and in a piecemeal fashion is that we require companies to make multiple updates to systems that will disincentivise the development of further technology and engagement within Australia, and that will cause economic cost for the sector.
Mr. Carter.
I wouldn't advance a view about whether it's been rushed or not, but just to reiterate the point that where the complexity is revealed in the legislation, sometimes it does take people time to get to grips and to tease out all of the implications of it. And with the tranching of this work, can be more difficult to foresee the full implications of the first tranche, because they will depend in some ways on what the second or later tranches do.
Absolutely. I think you put it extremely well. So to some extent it would be preferable to see the whole scheme, or at least have a roadmap to the whole scheme to know where we're going, so that we're not considering these amendments on a piecemeal basis. Would you agree with that?
In a perfect world, it would always be easier to see the full set of policy. Unfortunately,
maybe in a good world it would be possible. Mr. Godber, you make a very strong point around the need for the APP codes to be, at the very least, disallowable instruments, and I sit in the Scrutiny of Delegated Legislation Committee, so that committee has a scrutiny process. I haven't had a chance to go through and track technically as to whether or not the codes are disallowable. Are they disallowable or not disallowable at the moment?
It's unclear, and I think that the lack of clarity around the implementation of particularly temporary codes with a smaller period of consultation required, the scope in which those temporary code provisions could be enlivened remains unclear.
Okay. I'm not a tech head. Might come as a surprise to the witnesses. But you raise, I think Senator Shoebridge is being sarcastic. You raised an issue around this concept of controllers and processors, and you say that it's a fundamental concept in privacy legislation. And you say, I quote, the government has agreed in principle to adopting the controller-processor distinction. It has not been reflected in this proposed bill, end quote. Do you know the reasons for that?
Our understanding is it will be part of the Tranche 2 provisions, which we also understand are reasonably advanced. And the introduction of a controller and processor distinction is just one of a number of fundamental reforms that we are expecting in Tranche 2 that critically will make Australia's privacy regime interoperable with key regimes overseas. I think it is a challenging position for the government to put forward a small number of reforms without giving us the full picture. And it's challenging for the principal reason that we want to ensure technology companies can create products that are export ready, and indeed to ensure that companies that operate technology platforms overseas are able to operate them in Australia and offer a wider, higher quality, more personalised range of services to Australian businesses and consumers.
So are there specific issues that arise from the context of these Tranche 1 amendments from the fact that this tranche doesn't adopt that controller-processor distinction? Does that in itself, in terms of the application of this tranche, cause issues of interpretation, issues with respect to application?
It changes the way in which we are considering any privacy provisions and the sorts of obligations that will be placed on businesses from a technical standpoint.
So ideally, you would have had this. You would have this distinction between controller and processor as part of this tranche. Is that correct in your view?
Indeed. Do you want to add to that?
Yeah, I might just also add to that. To give you a really good sort of example of this, and to the point about fundamental and long-standing concepts within privacy and good privacy regulations, the controller process distinction has been in existence all the way back to the 1980s, to the OECD privacy guidelines, to the EU Council, also in the 1980s, as well as Apex privacy frameworks in the early 2000s. The controller and process distinction is a very helpful one. I know Harry mentioned earlier just the sort of vagueness around the automated decision-making proposals. When we're starting to think about how we may necessarily sort of apply privacy obligations in the context of automated decision-making, being able to clarify the roles of controller processes of folks who are operating across the technology stack becomes very, very important. Because it clarifies the appropriate entity that then will apply the disclosure notices for automated decision making. At the moment, sort of our read of those particular provisions, it is fairly unclear.
So can I reflect this back to you and just see if I understand? Is it correct to say that one of the reasons why you need to have this clearly defined distinction between controller and processor, is it correct to say one of the reasons for that distinction is to make clear who has responsibility for doing what?
That is right. And the fact that a number of these proposed provisions will not apply to a large number of entities in a controller-processor distinct environment. And so what we don't want to do is to introduce unnecessary new obligations on all businesses that will not necessarily be relied upon in the long term by those businesses.
Right. So the concern is that if Tranche 1 goes ahead without embedding an appropriate distinction between controller and processor, it could mean that a broader range of persons, organisations are bearing obligations which, from a practical perspective, they shouldn't have to bear that legislative burden. Is that correct?
Indeed.
And is it also correct to say that it will also be unclear as to who bears particular burdens?
Correct, and it will also go into thinking about how we may be able to also operationalise the tranche 2 obligations as well.
Right. You raise a concern that the statutory tort that's proposed doesn't have a serious harm threshold. What's your particular concern in that regard, and how would you define serious harm?
Yes. So the proposed tort is actionable per se in the same way as torts such as assault and battery. And I think it is important to consider these proposals in light of what the purpose of a tort is, which is to complement statute and common law, to complement existing provisions in criminal codes and elsewhere in the Privacy Act, and provide redress for individuals that may not be available elsewhere. And these principles were set out in the report by Professor McDonald, who I understand is appearing later today. I think it is at once unclear that those gaps still exist today or will still exist in a tranche 2 environment. And furthermore, it is difficult for new rights that will allow individuals to commence causes of action in the legal system to be introduced if there is not a kind of barrier to entry that will ensure that the system is not overrun. If you look at the nature of the tort, the nature of an invasion of privacy, we would suggest that it is more proximate to something like nuisance, another tort for which there is a requirement for seriousness of impact of harm to be established, or torts like defamation, where the introduction of a serious harm provision has done a lot to ensure that courts are not filled with backlogs of people or classes of people pursuing defamation matters that often will not pay out in any significant way. Put simply, if a tort of privacy is introduced that is actionable per se, that does not require demonstrated significant loss in order to be actionable, then you would risk having large classes of action against any company at any time where a data breach might have occurred. So the crux of the proposed tort is that a serious breach has occurred, a serious invasion of privacy, but does not necessarily require an individual to have experienced any loss in order to pursue what would be nominal damages, but in a class action environment could pose a significant threat to the just, quick and cheap operation of the legal system.
Okay, you referred to, this will be my last question, Chair, you referred to Professor McDonald, and I've read Professor McDonald and Professor Rolfe's submission, and one of the things that surprised me from that submission is it seems that the formulation of the tort is different from that which was proposed by the Australian Law Reform Commission after it conducted a very rigorous one-year inquiry and tapped into the knowledge of experts both in Australia and the United Kingdom. Is that your view?
Indeed. I'll let Professor McDonald speak to her own submission later today, but what I would note is that it is important that we create an environment of certainty for businesses, and in that context, it is important that we're proceeding on the basis that any provisions in this bill, but particularly provisions in relation to statutory tort, are watertight, particularly from a constitutional risk perspective, where we believe there is no head of power that would support the operation of this right. Briefly, the Privacy Act generally relies on the corporations and trade and commerce powers. In other words, the ability for the government to make laws in respect of businesses. Where a right is attributable to an individual, that power cannot be relied upon. We note that a position has been put forward that it would be possible to rely on the external affairs power. because we are a signatory to the ICCPR, which includes a broad right to privacy, there is a clear line of High Court authority that indicates that you could only rely on the external affairs power in respective treaties to the level of abstraction that that treaty provides for. In other words, if a particular law does not implement the full scope of a treaty or of a treaty provision, or goes beyond the scope of a treaty provision, the external affairs power could not be relied upon. What we risk here, particularly in creating a right to litigate, where the consideration of this tort and its constitutionality will almost certainly be challenged rapidly because actions will be appealed. We risk creating something that will not stick around in the long run. And generally, and I think this is a comment that goes to the bill as a whole, we risk creating settings and putting obligations on both entities that are required to comply and regulators that are required to enforce that will be inconsistent with the long-term state of the Privacy Act.
Okay, thank you very much. Thank you, Chair.
Thanks, Senator Schubert. You have the call.
Yeah, thanks both for your submissions. I think, Mr. Godby, you said that there should be a threshold for a statutory tort not dissimilar to nuisance. Is that your position?
Indeed. And the reason for that is, and in fact, one of the elements of the proposed tort, which is invasion or intrusion on seclusion, is the crux of the tort of nuisance.
Yeah. Well, nuisance is basically standing outside or being external to someone's property and causing them grief.
That is one example, yes.
And the grief that you cause them under nuisance, I think, has to be serious and unreasonable. That's, I think, in nuisance, or actually substantial and unreasonable. So you have, the grief has to be substantial and unreasonable. That's the threshold, the comparator you're talking about. Is that right?
Indeed, and we would suggest that a similar threshold should be adopted in this case.
But there is a threshold. The invasion of the privacy has to be a serious invasion of privacy. In some ways, it's got a similarity to that threshold in nuisance, doesn't it? Nuisance, the interference has to be substantial and unreasonable. And in this, the invasion of privacy has to be serious. So it adopts not exactly the same threshold, but fishing in the same pond, isn't it?
A serious invasion may not necessarily give rise to a serious loss. And that is the distinction that is important to ensuring that the legal system is not essentially overrun by large classes of complainants.
Nuisance doesn't require loss, it just requires substantial and unreasonable interference.
We would also
here, the threshold for the tort is a serious invasion. I'm suggesting to you that your proposition that this is different to nuisance and substantially different to nuisance, actually, on close scrutiny, it's not true. It actually mirrors a similar threshold to what happens in nuisance.
The introduction of similar thresholds in relation to defamation law would be another good reference point, where a person can suffer hurt feelings, emotional distress in relation to something that a person has said about them, in a similar manner to a person suffering emotional distress or hurt feelings as a result of a disclosure of information. It has been demonstrated that the introduction of a serious harm threshold has made the operation of defamation law significantly more efficient.
There are a significant number of submissions that say, far from this being a floodgates problem, that in fact the series of quite stringent elements that need to be proven and the thresholds that exist actually make this quite a narrow tort. In fact, you've probably read the series of submissions that say some of those thresholds should be lowered. To accept that there's a significant number of submissions that say, far from this being a floodgates problem, it's actually probably litigation just for the wealthy.
I accept that that is a point of view that has been advanced. I would point out that particularly in relation to technology companies where data breaches might occur and the future use of data that has been disclosed to third parties as a result of a breach might be uncertain, that it would be open to a court to find that a breach is quite significant despite no harm being created in respect of an individual. And the second thing I would emphasise is that the nature of a tort in complementing actions that are already available to regulators or individuals or entities through other areas of law, including existing provisions of the Privacy Act, including the penalty provisions for which the OIAC can commence actions, risks creating a duplicative environment that is not merited.
Yeah. Given the very modest funding that goes to the Office of the Australian Information Commissioner that can barely keep the lights on while they run their FOI applications, FOI reviews, let alone do all the additional work here. Do you accept that the duplication argument, given how starved of funding the OAIC is not really your strongest argument? That they can barely afford to run one prosecution?
I wouldn't quite agree, Senator. We would support significant resourcing for the OAIC. In fact, would note that the efficient and effective operation of the proposed regime will require a much better resourced regulator.
I agree with you there, but this government hasn't shown any intention to do that. This government, like the previous one, have starved the OAIC in truth.
I will leave the political commentary to others, but I would note that
you describe the adequacy otherwise of their funding in your own words then.
I would note that the fact that a regulator may not be sufficiently funded to enforce existing law should not be the reason that additional law is created.
One area where I recognise your concerns is what this bill does is it puts in place a statutory tort to allow actions to be taken for damages for breach of privacy without putting all of the architecture in place to ensure that corporate Australia, your members and others have an adequate response to people's privacy. That's probably not a bad argument, that putting the tort forward before tranche 2 is put in place kind of sets you up for a fall.
Indeed, and I would also note that there are provisions in tranche 2 that may reduce the gaps for which the tort is required.
Well, one way we could address that would be to try and bring forward as many of the important reforms that have otherwise been pushed to tranche 2 are. That would include mirroring some of the provisions in the GDPR, which no doubt I assume your members largely comply with in other jurisdictions. Is that right?
In many cases, yes.
Yep. The extension of the definition of personal information. What's your organisation's position on that? And I might go to both of you.
Well, I think broadly we are highly supportive of the idea of bringing forward the tranche 2 measures because, as you say, we are considering whether or not we should advance certain proposals, but I'm not sure whether that will be in a GDPR-like environment or an environment that provides part of the way there. Did you want to add anything on the provision itself?
Yeah, and I think being able to clarify definitions around personal information becomes really, really important, and it's very, very important that they are clear and we have the appropriate sort of period and consultation period to respond to those definitions.
But at some point, if not in this bill, then very soon, it should include tracking people's data, geolocation. That you're not pushing against that as an endpoint in reform, are you?
No, and of course that would be the importance of making really good privacy and strong privacy laws that enable Australian industry to continue to...
Indeed. Our members are calling for certainty and for clear guardrails in the way that they are able to deliver and develop products.
Ms. Williams?
Thanks for the question. We made some comments about this in our submission to the AG's report in 2023, but not in the submission that's on the table today. And simply coming back to the point around, we're sort of open to that extension because it reflects today's modern reality. So slightly extending that definition. But again, the exact specifics of how it is defined then is what creates all of the concomitant consequences. So it would be something to do and to engage on to understand all of the implications before it was legislated.
Well, I mean, one thing that's urged by a number of submissions is to put a fair and reasonable constraint on the use of people's data. It can't be used beyond what is fair and reasonable. Do you have a position on that?
We don't have a position on that, no.
Yeah. Mr. Goodman? Ms. Lai?
I will have to check.
Happy to take my notice.
Yeah, it's hard to speak against fair and reasonable, isn't it? Like, it's
Indeed.
tough to come up with an argument about why you shouldn't have that constraint.
That sounds like a sensible position.
It sure does, doesn't it?
Very happy to consider it in more detail, but I would say that it also sounds like a proposition that is consistent with the privacy principles in general.
Yeah. The question about the codes being disallowable instruments, the bill is strangely silent on whether or not the codes, the substantive codes are disallowable instruments, but I assume you stand by your position that they should be disallowable.
Indeed.
So they can have parliamentary oversight?
That's right. And also I would question whether a temporary 12-month code would reflect the reality of what is required for tech companies to comply, which typically, depending on the nature of the reform, could include restructuring the way that data is collected, managed, held, and would require systems reforms that would take potentially longer than 12 months to implement.
The bill actually expressly says that temporary codes are not disallowable instruments, and the argument for it in the explanatory memorandum is that if they were disallowable, then tech companies may be discouraged from complying with them in the hope that they would be disallowed. I'm assuming your members have a general sense of complying with the law as it is from time to time.
Indeed.
Do you think the argument that if they were subject of if they were able to be disallowed, what do you make of the government's argument that the fact that they could be disallowed means that you wouldn't comply with them even though you were legally obliged to?
I would disagree with that proposition. I would not say that it's a matter of compliance. It is a matter of the effectiveness of the codes. It is possible that, for example, given the lack of definition of when these codes could be instituted, a code could be implemented in an inappropriate manner, and it would be and in a manner that is not subject to parliamentary oversight. But it is not a question of whether or not members would be complying with the law in that instance.
And Mr. Carter and Ms. Williams,
you just have one more question.
Thanks, Chair. These temporary codes could be incredibly disruptive and seem to have fairly potentially broad application. Given they haven't gone through any kind of preliminary process, some form of parliamentary oversight seems sensible, doesn't it? That's to you.
Sorry, we haven't engaged in the codes in our submission.
Yeah. Mr. Godbert, the absence of any preliminary process probably makes parliamentary oversight more important, doesn't it?
We agree.
Thanks, Senator Shoebridge. Thank you very much. I just have a few questions for AUDA. I think that's how you abbreviate your title, Mr. Carter. Your submission refers to the Digital Lives of Australians 2024 research report. Is that a report that your organisation puts together, or is it one that you're part of?
Yes, it's a research report that we commissioned from SAC Newgate and published on an annual basis to start generating a sort of longitudinal look at attitudes about tech issues from the Australian public.
Yeah, great. Okay, and some of the key findings of the report were pretty interesting because you do ask some questions about personal information and privacy and attitudes towards those. The report found that 74% of small businesses surveyed feel that the failure to protect personal information of customers should result in penalties. Have you seen the attitude towards that finding change over time?
I'd have to come back to you, Senator, on notice with that one. I haven't got the historic trends in my head. I apologise.
Yep. Okay. Sorry, just to be clear, I guess some people suggest that small business shouldn't be included in privacy protections, but the report found that 79% of small businesses believe that companies should be doing more to protect personal information of customers. And small business feel more comfortable with AI if there were stronger regulatory safeguards. Maybe not from the report directly, but is that the feedback that you get from your customers and your members around the introduction of AI leading to more concerns about regulation or privacy protection?
The main evidence point that we've got is the research that you are referring to, and that is why in our submission we sort of made that point. That strengthened regulation of privacy and including disclosures around the use of AI decision-making would be beneficial.
Okay. Well, thank you. I think that's actually really helpful information. There's always people that put forward the views of small businesses, but we've got their actual views on protection of personal information from your report, so we appreciate you including that in your submission. I just wanted to ask the Tech Council Australia, just to be clear, who makes up your membership?
The Tech Council membership comprises over 150 tech companies that include smaller Australian-based companies that have scaled, and larger companies that may be offshore but have large operations within Australia.
So like the big ones like Google,
Indeed.
eBay, yeah. But not social media companies?
That's correct.
Okay, that's helpful to understand the distinction. You've also got Optus as one of your members. They're not necessarily, they're a telecommunications company, but they're involved in the Tech Council. Do you know why?
They are a large operator of technology services. For example, I believe they're the largest operators of satellites in the Southern Hemisphere.
Right. Okay. That is good to know. I just have a couple of questions about something that Senator Shipbridge was asking you about around your recommendation around the serious harm threshold for the statutory tort, whether that should be included or not. The Australian Law Reform Commission didn't make that recommendation, and that's because they considered that the tort should be actionable per se. That's in recognition that an interference of privacy is about interference with someone's dignity rather than the alternative. What is the Tech Council's position on the interference on privacy? Isn't it the case that that's actually what the harm is, that someone's dignity is being interfered with?
In our view, the purpose of the tort goes to the efficient operation of society and the operation of businesses in a manner that does not infringe upon individuals' privacy. We believe that those sorts of harms are already sufficiently addressed through the existing penalties regime, and in fact note that this bill goes much further, in our view inappropriately further, to extend those penalties to things like administrative errors or breaches that are nominal breaches that do not cause harm. To create an additional right risks creating a situation of double jeopardy, particularly in cases where serious harm has not occurred.
Okay. When I had a look at the clause that's being included in the bill, and I apologise if you don't have it in front of you, but there is a reference to harm and to the seriousness of the invasion of privacy in what is being proposed. So subclause 7.1d ensures that an element of the tort is a requirement for the invasion of the privacy to be serious. Why do you say that doesn't go far or isn't far enough?
We have no concern with the proposition that the invasion should be serious. However, in the event that a serious invasion has occurred, which may be defined by a court because it is left open to interpretation as a large-scale breach, but a breach that did not have any significant effect on an individual. To give you one example, there would be a risk that unnecessary, ineffective processes would be instituted as a result of large groups of plaintiffs seeking redress, and redress that in fact would be limited, most likely, to nominal damages, given the fact that no harm has occurred.
Okay. One other issue that we haven't talked about just yet, and I'll try to cover off quickly, is the issue around cross-border data flows. I'm not sure if you've covered that off already, but there are measures in the bill that increase mechanisms to facilitate the free flow of information across national borders while ensuring that the privacy of individuals is respected. Obviously, this is something that is being discussed internationally. There are attempts to ensure that that is happening, particularly around the European Union. Do you support those measures in the bill?
Absolutely. And we're supportive of all measures that ensure that Australian tech companies can effectively transfer data across borders because it creates a strong export-ready digital economy.
Yeah, okay. And just... this is a bit of a technical one, but there's an adequacy decision from the European Union. Can you explain that to the non-tech people in the room about what that means and how that impacts the free flow of communication? Or how that's impacting Australian businesses?
I can jump in there. So the adequacy, to Harry's sort of broader points around ensuring that Australian industry is able to export and do business overseas. The adequacy requirements are quite important, partly because it enables us to be recognised under the GDPR in order to access the European markets. So therefore, the business adequacy points and the privacy adequacy points become really, really important. Also to say that, it's very much about how our Australian privacy regimes are similar or equivalent to the EU's, and that enables a business certainty and also is a vote of confidence for Australian industry that is operating over there.
Yeah, okay. Thank you very much for that. And I'll sort of finish where we started with the Tech Council of Australia, taking on board your views around the certain provisions in this bill. It is the position of the Tech Council of Australia that you support modernising the Privacy Act.
Absolutely. It is our position that the Privacy Act needs to be updated to ensure appropriate interoperability with emerging global standards. But we do support, in relation to the current form of the Privacy Act, the principles-based nature of privacy law and regulation in Australia. And one point that we have briefly touched on that I would emphasise in that context is that introducing a tier of administrative penalties for privacy breaches that do not necessarily fall under the category of being serious or creating harm, but are nominal breaches, essentially create a strict liability environment that is inconsistent with the principles-based nature of privacy law. And I believe that the intent of government is not necessarily to make that step change, but the effect of these provisions will be to create or to abrogate the principles-based nature of privacy law. And if that is something that the government intends on doing, we believe that it should be in the context of broader reform that brings our system in line with systems offshore.
Okay. All right, well, thank you. We'll have to leave it there, unfortunately. So thank you very much for your time today and for giving your submissions and evidence to the committee. I think our next panel is waiting for us, so we'll bid you adieu. Thank you. And I will welcome our next panel as we move swiftly through the morning session of the committee. I now welcome all via video conference today representatives from Reset Tech Australia, the Human Technology Institute of the University of Technology Sydney, the Justice and Equity Centre, Electronic Frontiers Australia Incorporated and Digital Rights Watch. Thank you for taking the time to speak with the committee today. Information on parliamentary privilege and the protection of witnesses and evidence has been provided to you and is available from the Secretariat. For the Hansard record, can you each please state your full name and the capacity in which you appear today? And we'll start in the same order that I read out those names if that's helpful. Reset Tech Australia.
Hello, Alice Dawkins, Executive Director, Reset Tech Australia.
Thank you. And from UTS?
Professor Edward Santo, Co-Director of the Human Technology Institute.
And Sarah Sacher, Policy Specialist at the Human Technology Institute.
Thank you. Justice and Equity Centre. Not sure if they've
Hi, it's
hi.
Ellen Tilbury, Principal Solicitor at the Justice and Equity Centre.
Okay, thank you very much. And Electronic Frontier Australia Incorporated.
Good morning, John Payne, Chair of EFA.
Thanks, John. And Digital Rights Watch, Ms. O'Shea.
Thank you, Chair. My name is Elizabeth O'Shea. I'm a founder and the Chair of Digital Rights Watch. I did also want to say that we have prepared some remarks on behalf of a few of us. If that would assist, I could start with that, but I'm in your hands.
Well, thanks very much, Ms. O'Shea. I was going to ask if anyone had a brief opening statement and then give the caveat that they would have to be pretty brief so we can get on to questions. So thank you very much. If you have managed to organise some sort of collective opening statement, that's helpful. Otherwise, I'll ask others to contribute, but I'm pretty limited, so we can start with you, Ms. O'Shea, and go to others if there's something to add. But I know that senators are really keen to ask you guys questions, so we'll try to get there as quickly as we can.
Thank you, Chair. I will be brief. Thank you for the opportunity to give evidence in respect of the Privacy and Other Legislation Amendment Bill 2024. So in the interest of time, I'm providing these opening remarks on behalf of my colleagues, some of my colleagues here today from the Human Technology Institute, the Justice and Equity Centre and Electronic Frontiers Australia. As I understand it, Electronic Frontiers Australia and Reset Tech will make some additional remarks after I've concluded. Collectively, we welcome this bill and we think that it is a good first step in the journey to improve and strengthen the Privacy Act of 1988. The Privacy Act has not been meaningfully updated in nearly 4 decades and it's simply not capable of responding to the significant technological changes we've seen in this time. We all collectively have been engaging with this reform process over the last 4 years and we see this bill as a positive development. We support the creation of a statutory tort for serious unjustifiable infringements of the human right to privacy that are intentional or reckless. This has been a well-documented gap in the law and the proposal has been considered by multiple law reform bodies over many years. Collectively, we have a number of suggestions for improvement, largely that the proposal should align with the Australian Law Reform Commission's report 123, which looked at this issue. And there are improvements that could be made with respect to the exemptions and the defence of consent. However, as a general proposition, we think it's a critically important reform that ought to be implemented. We also all strongly support the proposal for a new Children's Online Privacy Code to be developed by the Australian Privacy Commissioner. We see this as an important method for the protection of children and young people who are particularly vulnerable and are currently exposed to an array of risks and harms by being required to share their personal information without proper protections in place. Together, we're largely supportive of the other proposed changes to the Privacy Act, including the changes to the powers of the Information Commissioner and rights with respect to automated decision-making. We variously make some minor suggestions for improvements, which you can see in our written submissions. We also note that the government accepted a significant number of recommendations made by the Attorney-General's Department to improve Australia's privacy laws that do not appear in this bill. We see this bill as a first step, but that there is also much more work to be done, and it is well overdue. Collectively, with a number of civil society organisations, we are calling on the government within 6 months of the election to introduce the remaining reforms contained in the Attorney-General's Department's Privacy Act review report, which were agreed to in principle by the government. We're seeking a similar commitment from the opposition. And our suggestion is that this committee make a similar recommendation. And to that end, I wanted to highlight a small selection of these reforms to provide a sense of their importance. They include updating the definition of personal information, the introduction of a fair and reasonable test, improvements to the definition of consent, and removal of various exemptions. And in particular, the first two of these changes, updates to the personal information definition and the fair and reasonable test, these could be implemented now in a straightforward drafting manner with significant positive impact for Australians, and these would align with community expectations. And we think serious consideration should be given to moving these reforms forward as quickly as possible. But there are many others. All of the proposals have been subject to years-long consultation. Many are very, very popular with the Australian public, and would bring Australia's laws up to date with similar comparable jurisdictions. Thank you.
Thank you very much for that. Does that mean we're ready to go to questions? Yeah. Okay, thank you very much. Senator Scar, you have the call.
Thank you, Chair. If I can ask a question first of the witness, Ms O'Shea from Digital Rights Watch, and I compliment you and your organisation in relation to your passion in relation to this issue. Does it trouble you that there has been such a long period of time where these reforms have been discussed, that we're now faced with an abbreviated process to actually consider the wording of the bill itself, where numerous stakeholders, including those who aren't appearing today, from the Australian Medical Association through to business organisations and others, organisations representing journalists, have raised material concerns with respect to the wording of the bill, including the wording of the statutory tort in relation to privacy. And we only have 3.5 weeks to try and assess all of those competing interests.
You asked me if it troubled me, and the answer is that this has been a lengthy process of consultation where many different organisations and individuals have provided input into the process over multiple rounds of consultation. This also comes off the back, in particular in relation to the statutory tort, many law reform bodies considering such a proposal in various different formats over a significant number of years. The context also for this bill is extensive support among the Australian public for reform in this field. So in that context, I think this is a welcome development that comes off the back of significant work done by this government and also the previous government, numerous law reform bodies, and extensive consultation with the public through polling and other kinds of surveys to ascertain their views, which show a strong mandate for reform.
Okay.
So I think it is important to consider the bill, of course, on its terms and hear from people about particular forms of wording, but I think it is also fair to say that this is a significantly positive proposal in its format. We would like to see the remainder of the reforms introduced that have been involved, that have come out of this extensive consultation process.
Okay. Have you had a chance to read the submission from the Australian Medical Association?
I have not. I have had a look at some of them in brief, but not that specific one. So if you'd like to ask me about that, I'd be happy to respond.
Well, look, I've only had a chance to read it today because of the abbreviated time, but I'm troubled by a number of the concerns they raise in relation to the statutory tort of privacy, including issues around collecting family medical history without express consent, collecting reports from other specialists without express consent, disclosing information to family members or authorities, raising concerns about colleagues, medical research using personal data, and so it goes on. So if I can ask you and perhaps all the witnesses just to take on notice the concerns raised by the Australian Medical Association on whether or not those are issues which have been canvassed in any of your activities in terms of ensuring that we don't inadvertently, albeit through unintended consequences, impact upon Australians' ability to get health services which could be life-saving in many cases. Dr. Sento, if I can go to you, the statutory tort of privacy that's actually contained in the bill is different from that put forward by the Australian Law Reform Commission, isn't it?
Yeah, there are some differences. On the whole, it's very similar.
Right. What are the differences?
Look, I think that the principal differences that we're concerned about really relate to the exemptions for journalists and for enforcement bodies. We recognise the importance of journalism, particularly public interest journalism, and for law enforcement to be able to perform its legitimate function to keep the community safe. But we consider that the precise wording of those provisions should be improved, and that would better bring it, I guess, within the intent of the Australian Law Reform Commission's report.
Have you had an opportunity to read the submission from Professor Barbara McDonald and Professor David Rolfe?
No, I haven't.
Okay.
But I'm conscious that Professor McDonald is appearing later today, and of course she was the Commissioner in charge of the ALRC's 2014 inquiry.
Well, exactly, and that's why it troubles me that Professor McDonald raises concerns with respect to the drafting of the tort. Could I ask you perhaps to take on notice her submission and to provide your views or the views of the Institute with respect to the concerns that are raised by Professor McDonald and Professor Rolfe?
Sure.
Okay, thank you very much. Have you had a chance to read the submission from the Australia's Right to Know?
Yes.
And what's your response to the concerns that they've raised? They've raised a number of definitional concerns. They've also raised, if I can put it this way, a fundamental concern that they think the tort as drafted will have a chilling effect on legitimate public discourse and discussion. They refer to some of the experiences in the United Kingdom. They actually give specific case studies from the United Kingdom and also New Zealand. Happy to hear your comments now in relation to the concerns they raise, but also happy for you to take on notice and provide a more considered response to the concerns they raised. And I think there's a bit of crossover in terms of some of the concerns at least.
I'll make a couple of observations, also invite my colleague Sarah Sacher to add. The first thing to note is that the UK legislation, the statutory tort in the UK, is quite different from the proposal here. There is lots of conduct that we would consider to be very worrisome that has been the subject of litigation in the UK that simply would be out of scope of the statutory tort here. So I don't think all of the observations in respect of the UK and other jurisdictions apply here. I guess the second point to make is that the statutory tort has been the subject of extensive consultation, multiple rounds of consultation that started back when Prime Minister Howard was in office back in 2005. Journalists have had a lot to say, and media organisations have too. And what this genuinely does is it seeks to strike a balance. And it's not a balance of 50-50. It puts additional, I guess, protections for journalism and free press over and above a lot of the privacy protections that might otherwise exist. So there are a number of things there, including the fact that this is only in respect of serious invasions of privacy. And that doesn't even take us to the exemption that journalists would enjoy. The right to know. The last point I would make is that the Right to Know Coalition makes an observation about whether sources are covered, as in sources that journalists rely on for their news stories, and if they are right, and if sources are not covered. I guess the point that is ignored there is that sources can often rely on other legal protections like whistleblower protections and so on when they are kind of revealing sensitive information that is in the public interest. And so there are a number of other protections that others might be able to rely on that journalists that go beyond the kind of coverage of the journalist exemption.
But you recognise that those protections with respect to whistleblowers, there have been some very high-profile cases where people have sought to take advantage of those protections with varied success. So you recognise there are potential deficiencies in relation to those whistleblower protections, and that might well be something that the doubt could be removed through potentially through amendments to the bill.
I think that's a very helpful suggestion. That the Human Rights Law Centre and others have pointed to ways in which whistleblower protections could be improved, and that could happen either in this legislation or in a separate bill, and I think that would be welcome.
Was there, I know there has been a lot of consultation in relation to this issue of the statutory tort, but was there an exposure draft of this bill? Was there an exposure draft of the wording of this schedule dealing with this statutory tort to provide for a fulsome engagement with respect to this specific wording before the bill was tabled in Parliament?
Oh, I think you'd have to ask those questions of the department for a hearing later today, but I'm not aware of an exposure draft. What I would say, though, is that the elements of the tort have been on the public record for over a decade. They were set out in the ALRC's Report 123. They were then the subject of extensive consultation by the Attorney General's Department, and that consultation process was started when under the Prime Minister Morrison government. And then it was subject to even further consultation after the department released its report prior to the government finalising its position here. So there have been multiple points of engagement. And let me be very clear, media organisations have been very active and appropriately so in participating in those consultation processes, in having their voice heard, and they've been highly influential.
Okay. And just my final question to you, Dr. Santo, and that is, did you have a chance, have you looked at the doxing offences under Schedule 3? Is that something which falls within the area of your interest, or I'd personally be interested in your views with respect to the doxing offences, but if you don't think that's appropriate, I respect that.
No, we've looked at those provisions primarily by reference to whether that sort of conduct might be also actionable under the statutory tort, but others might have a view. We don't want to monopolise it.
Okay, and do you have a view in that regard as to whether or not those offences would be, or that conduct which falls within the purview of so-called doxing offences would trigger application of the statutory tort?
Look, yes. So our view is that in quite serious cases of people, particularly maliciously revealing sensitive personal information about others in the public domain, so the kind of very nature of doxing, that could be within scope of the statutory tort, and that might be an appropriate way of addressing that. We do have some residual concerns, but not a final view about the criminal provisions. Okay.
Well, if feel free to provide us some detail with respect to what you referred to as residual concerns, because I'd be interested to see if there's a way in which we can improve or enhance the schedule to take into account those concerns, especially given your experience and that of the Institute. Thank you, Chair.
Thank you very much, Senator Scarr. Senator Shoebridge, do you have questions?
Yes, I do. Thanks, Chair. Thanks all for your attendance and your very helpful submissions. I note that Senator Scarr referenced the submission from Emeritus Professor McDonald and Professor Rolfe, but just for clarity on the record, they say in their submission, the elements of the cause of action in the bill largely reflect the recommendations of the ALRC, and they have an issue with how the public interest is assessed. I think that's a fairer reflection of their position. They support the tort. They just think that some of the evidentiary ways in which public interest is proposed to be assessed in, I think, subclauses 3 and 4, they have technical issues with. Have any of you looked at that public interest issue, or is that something best addressed on notice? I'll go to you first, Mr. Santo.
No, we have not.
Well, yeah, I rather than spend time on that here, if you could look at that in answering the questions to Senator Scarr on notice, that would be useful. Perhaps we might start with some of the Doxing issues, and maybe you, Ms O'Shea, might be a good starting point on this. As drafted, the anti-doxing provisions have a potentially extremely broad application, including one-on-one private conversations and communications, potentially roping in information that's otherwise publicly available. Have you had a look at the potential breadth of coverage of the anti-doxing?
Yes. So we have made some comments that are reasonably limited in our submission. In part, that's because it's difficult to describe this as a privacy issue, I suppose. It's, to be clear, this section of the bill did not form part of the process that I talked about earlier. That's been a years-long process of consultation. So this is a relatively recent proposal that has been made public. What I would say is, in that sense, we do remain concerned, and in our written submission, we did note comments by the Law Council of Australia on this, and that there is a need to ensure balance in proposals like this. That submission was made in respect of it in a different context, I should say, but in general goes to the same point. I also think it is fair to say that the conduct that potentially this offence is directed to is arguably already covered in the criminal law through various other provisions. So what this provision appears to do is raise expand the scope and also raise the seriousness of the potential punishment that would be applied. And we do remain concerned because the examples listed, including names and account names, seem overly broad. So our view is it requires further consideration. I note that there are other bodies and individuals who've made submissions on this, and I think they're probably better placed to consider it. Our focus is mainly on privacy as a general proposition.
Yeah. Has anyone else in this panel had a review of those doxing provisions and have anything to add to what Ms O'Shea has said? Yep. Mr Payne.
Thank you, Senator. EFA shares Digital Rights Watch's concerns. One of the other concerns that we have is in relation to defined terms with regards to human rights. So there may be some individuals that are captured by this particular drafting that have protected characteristics due to gender or sexual preference or other matters, which in some instances do come under the definition of sensitive information under the current version of the Privacy Act. But we also think that a more broader solution is required in respect of Australia being the last liberal democracy in the world to have a Charter of Human Rights nationally. And we think that the two go hand in hand together. And the last point I want to make is that there's an argument that the criminal code as currently drafted, you could potentially draft in the offence of doxing into it, but from our research of policing services, we find that the actual offence itself is not very well understood, so it could be problematic.
Yes. Well, then I might just move on to one of the next points. Is we've now got multiple proposals for reform to deal with children's privacy online, and I think a number of your submissions cut across this. But Reset Tech, for example, points out that the proposals for this children's privacy code are extremely limited and don't cover things like ed tech and other places where we know that children's privacy is really at risk. Then we've also got proposed reforms for social media age limits that cut across these reforms, and how they would impact with these reforms is unexplored. I might go to you first of all, Reset Tech. The failure to include ed tech, for example, seems to be a big gap in this.
Thank you, Senator. We think there's a way to address this in the drafting. And just to give full context on what's going on here, there's some language here where there's two tests you can use. You can use the UK test, which is about, that's more international consensus, or you can use the US test, which is this services targeted at children issue. And so the proposed codes got all services likely to be accessed by children, which signals the UK test, but then clarifies, quote, all services likely to be accessed by children again. So they indicate that, as you say, that it's considered social media services, relevant electronic services, and designated internet services. And we suggest that perhaps clause A1 could be struck out. That might be the most straightforward way to handle that issue, because then the following subsections create a more appropriate scope. I would probably say that in the first instance, Senator.
Yeah, so simply say that if the service is likely to be accessed by children, that it should be covered by the Children's Privacy Code. That would be the primary threshold.
Yeah, yes.
But apart from EdTech, what are some other examples that would probably be excluded from the proposed definition here?
I might go to my colleagues, but I think another one we've considered is data brokers and that trade in general. Yep. There's obviously a lot of interplay between data brokers and edtech providers. And again, just to reiterate, it's this likely to be accessed compared to the targeted at, because I suppose the get out of jail clause for some of these other companies is, oh, well, we don't target our services at children. But it is this question of likelihood that is more important.
Does anyone else want to respond to this point? Ms. O'Shea?
Well, what I would say is I'm not entirely clear how the scope of the Act as it's currently drafted would potentially limit the scope of a children's code. But I would note that the current definition of personal information, I touched on this in my opening remarks, is limited, and it doesn't cover many forms of information that people would understand to be quite private information in this day and age. So things like metadata or locational information are potentially excluded from the current definition. So I query whether the code as it is developed would be able to extend beyond the scope as provided in the Act. I think that's something of an unanswered question, but I did just want to add that into the consideration of the scope of the Children's Online Privacy Code.
Well, I mean, on one view under this bill, you could have a Children's Online Privacy Code that was quite prescriptive, but even if you're an entity covered by it, you could still do whatever the hell you liked with data about children for their geolocation, for their metadata. That would all be, you could market that, you could commercialise that, that wouldn't be roped in by the Children's Privacy Code, even if you're an entity covered by it.
Well, that's right. That's why, in part, I think the definitional change proposed, accepted by the government, there is some urgency behind that, because it impacts then the reforms that we do have in this bill in terms of scope, yes.
So this bill gets passed, the children's privacy codes go through a 2-year process and are put in place, but then all of the entities covered by the children's privacy code can still gather, commercialise and exploit a whole bunch of data about where kids are going, what services they access, what they access online, that will be outside of the scope of the bill because of the definition of personal information. That hardly seems like a comprehensive reform for children's privacy, does it? Mr. Santo, do you have any view about whether or not the children's codes can extend beyond the definition of personal information in the limited definition of personal information? You're on mute.
I think that would be tricky, which is why we've recommended in our submission that this bill be amended in a modest but important way to expand the definition of personal information to do no more than was the subject of multiple years of consultation, which the government made a commitment to make this change, almost 2 years ago. So this would not be novel. I think that there are some claims that have been made by some stakeholders that probably bear that this should be scrutinised very carefully, that this would be something that would be, quite difficult and thrust upon them at the last minute. Actually, I think that this would be a really important reform that would make the Privacy Commissioner's function in developing that children's privacy code would be more effective.
So putting you on the spot, what do you think should unquestionably be included in an expanded definition of personal information?
Yeah, so we have proposed that technical and inferred information such as IP addresses and device identifiers should be included. We also, you mentioned geolocation data, we agree with that, and we also suggested that should fall within that kind of subset of personal information known as sensitive information. So that is that can be exploited to cause quite serious harm. So it should be within that subset. But as I say, that difference between personal information and sensitive personal information, that distinction already exists in the current Act, and so it's just updating them.
So if this bill goes through and a children's privacy code is made, there would still be no limit on the commercial exploitation of geolocation data that tracks where children go and potentially commercialises, digitally following kids as they move around using their geolocation data. Is that your understanding?
Look, I don't think it can be quite as definitive as that, because I think one could make an argument that some of these categories of personal information or sensitive information are impliedly part of the existing definition, but it's certainly not clear that they are, which is precisely why the government has formally committed to amending the definition of personal information, sensitive personal information in that way. So I think that would be a very welcome change. It would clarify the law, and it would certainly take beyond doubt that problem that you're referring to, Senator.
Yeah. Does anybody disagree with the prospect of extending the definition of personal information in the way just described? This is a process, a reform process. I'll just note that my observation of the witnesses is nobody disagreed with it. The industry, the Tech Council, says, you can't rush through a change like this, that there'd need to be further consultation on a change like this. This is a process that began on, I think, the 3rd of September 2014. I counted that as 10 years and 50 days. if we adopted a definition consistent with what was discussed in the recent review, that would hardly be taking anyone by surprise, would it? Does Ms O'Shea?
I would agree with that, Senator. Industry has been involved in this consultation process. They've had their say and they've participated in this throughout. This is not a novel proposal. They are also, I think, on notice that they require a social licence to operate, and at present, polling surveys of the Australian public support stronger privacy protections over their personal information. And so there's the element of surprise is not there, I think, from the perspective of this process or generally in terms of social attitudes to privacy.
It'd be like being surprised by a glacier. But the could I ask you then about the fair and reasonable test? How does that sort of mirror up with existing protections, say, under the GDPR? Because, again, we have industry saying, oh, we couldn't possibly implement this kind of additional privacy test without a huge amount of consultation. How would a fair and reasonable test work in practice? Mr Payne.
I can talk to this from the practical side, having been in the private sector operationalising privacy programs for 30-odd years and consulting to businesses on how to do it. It can be done. There is resistance to doing it because of the desire for business to collect as much personal data as possible in order to leverage, exploit, monetize it. So in that sense, it's not treating privacy as it should be, which is a balancing act of competing interests. In a practical sense, what the fair and reasonable test does is to mirror the provisions in the GDPR, which look at both the necessity of the collection of all the personal data and the proportionality of the collection of that personal data in regards to the intended use. So what that does stop is, I'm sure the committee is familiar with the condition known as OCD, obsessive compulsive disorder. Businesses, and large businesses, big tech, big media, have developed something which I tend to call obsessive compulsive data disorder, an obsession with capturing as much data as possible on the premise that one day all of it will become useful.
Well, such as Meta deciding without constraint to go through and mine all of our Instagram and Facebook posts over a decade and a year to train their AI. I mean,
precisely. Yeah.
And would a fair and reasonable test have put a constraint on that kind of action?
It would have, but it goes to the necessity to amend the definition of consent. Yep. With Meta, and particularly organisations that are based in the US, consent is used as a magic wand in order to, by way of contract, require consumers to agree to a range of unrelated and incidental uses of personal data.
It's kind of layered defence. Once you get through consent, it's not then just whatever the hell you like. There is still further protections in place because we've seen how consent can be, you can have bundled consent and how consent can be so abused in the current framework.
Correct.
Mr. Santo, or sorry, Ms. O'Shea.
I don't mind if Professor Santo wants to go
you
before
go now,
me, but here I am.
To...
So I would just say also the introduction of a fair and reasonable test would have positive implications for Australia's cybersecurity. In part, the capacity to collect large amounts of personal information, which is facilitated by the outdated drafting of the Privacy Act, does mean that companies are incentivised to do it because their competitors do it. The practice of corporate Australia is to do it. That is not just a risk for people who are vulnerable or who have a particular interest in their own privacy. It's also a risk for Australia's cybersecurity because it creates a source of data that criminal or other nefarious actors wish to access. So the introduction of fair and reasonable test makes sense from a cybersecurity perspective as well.
Yeah. Professor Santo?
We just reiterate the point about this being a necessary addition to consent requirements. The way that the Privacy Act privacy regime works is that it's really over-reliant on consent. It places an extreme burden on the individual to navigate consent processes, and often consent just ends up being illusory because nobody reads privacy policies and so on. But the fair and reasonable test would essentially just provide a baseline kind of minimum standard for how personal data should be used, regardless of whether or not consent is provided. That just takes into account, the reasonable expectations that people have about how their data is used and what the impact on people actually might be. So it's a pretty important baseline step that that again has been introduced in the GDPR and elsewhere that would massively improve our privacy regime.
And the concern that Ms. O'Shea puts on the table, which is without these kinds of layered protections, actually Australia becomes a global target. Is that a concern that the Human Technology Institute shares?
Yeah, that was precisely what you were alluding to before with Meta, where it has adopted a kind of regulatory arbitrage where it is not collecting and using people's personal information to train their large language models in the European Union and some other parts of the world explicitly because those other jurisdictions have stronger privacy protections, but they are doing that in respect of Australians' use of Meta products and services like Facebook and Instagram because our law is so weak that it does permit that kind of privacy intrusive practice.
Ms. Dawkins?
Just to pick up on this, I'd love to table our report if appropriate, which is a new report with a foreword from Mr. Payne called Any Buyer Accepted, where we map the unique security risks in Australia with respect to the free-for-all for personal data. And so that completely it clarifies and, I suppose, provides the evidence in part for some of these comments being made.
Was that the report that contained the kind of some disturbing statistics about the number of daily trades on average of Australia's data?
449, I think, yeah.
Yeah. And that includes children's data being traded hundreds of times per day on a kind of unregulated global market when it comes to Australian data.
That's right, Senator, and we understand that that includes live location data, and the evidence is there looking through the audience segment categories that are freely available in this sort of B2B market. It's right there. It's not a conspiracy. It's right in front of anyone who wants to troll through it. So thank you, Senator.
Yeah. Well, I mean, if you could provide that report to the committee, it would be of great assistance.
Senator Shoebridge, we do have a little bit more time with these witnesses, but I'm keen to share the call and we can come back to you. If you have one more question, we might have some time at the end.
All right. Well, just on another front, Electronic Frontiers, you raise concerns about the continuing existence of the small business exemption. I know that many, particularly young people I talk to, are deeply concerned that their real estate agent can just do whatever they like with their data without constraint. And given how much personal information they provide to their real estate agent, they find it deeply troubling. Where should we go on that?
EFA is strongly supporting of the removal of all exemptions under the Privacy Act for small business, employee records, and also political parties. And I'm realising how the last one may be unpopular.
Yeah, shame on you.
In relation to the small business exemption, it has an interesting history. It goes back to the time when Peter Reith had control of the small business portfolios and workplace relations. That's when the exemption started and it persisted. But in all privacy laws around the world that have developed since then, there's been 140. There is no similar or equivalent exception for small businesses. In fact, the GDPR also applies to small businesses. Small businesses have adapted, and in terms of economic and other impacts, there has not been any significant negative reporting in that regard. So, given that times have changed, particularly since the year 2000, when the National Privacy Principles were first drafted, we now have digitally enabled businesses that don't have a storefront or a shop front. They're all online, and so is our data. And that's why it's important to ensure that the data is protected, that Australians have rights in relation to their data, and small businesses who process and collect that data have obligations to manage it while are protected.
Yeah, they still manage to rent houses in Europe, don't they?
They would do that, yes, correct. Again, it'll be consent and in terms and conditions by way of contract. Yep. But the rental industry or the rent tech industry is one of the cowboys at the moment in terms of poor data management practices.
And without roping in small business, they'll continue to be cowboys and people's data will continue to not have the protections needed. That's your position, isn't it?
Correct. It's also consistent with polling. If you're looking at the real estate agency in regards to trustworthiness, they're typically down in the bottom, quartile of those polls. In relation to data management as well, you could make that argument.
Yep. Yeah, go, Ms.
Sorry, Senator. Sorry, Chair. But I did just want to say that there are cowboys, obviously, in some parts of the industry that enjoy the protection of the small business exemption. But there's a lot of small businesses who I think want to do the right thing by their customers and actually end up being sold substandard products from a cybersecurity perspective because they don't have that requirement to comply with the Privacy Act. And I would say that I think there's significant benefit that would come to small business from an elevation in the standards of handling personal information that would improve the experience. It would mean off-the-shelf products sold to small business and purchased by them, which they use on a daily basis, would adhere to a higher standard of privacy protection, which is a good thing. We shouldn't be creating a situation where small business has to contend with substandard products because the people selling them know that the standards are low. So I think there's a lot of benefit that would come from the removal of that exemption. It's not all downside.
And that observation also puts the lie to the argument of how disruptive it will be for small businesses, because we're not seeing small businesses, say in the real estate market, develop their own software and come up with their own schemes for mining that data or seeking data. They're largely buying off-the-shelf software and then applying it. So getting rid of the small business exemption is likely to lift the sort of regulatory environment across the board without creating individual disruptions.
I mean, I think that's largely right. I suppose I think the category of small business is diverse, and organisations that represent business and small business are do the work of explaining that and their constituents. But I think it is also interesting that a number of these organisations aren't opposed to the removal of the exemption and understand the utility of removing it, that there are benefits that come to that for sections of small business, large numbers of small business, I should say. So I don't mean to leave the committee with the impression that small business is this set of cowboys who are all misusing data. I think there's a small number of actors that potentially do that, but there's a large number of actors in the small business community that would benefit from improved quality digital products.
And of course, any reform in that regard would require
respectfully. Thank you.
Would require time.
Thanks very much. I probably will cover off some similar issues, Senator Shoebridge, and if we have time, we'll come back to you. But I just wanted to start, if I can, with Reset Tech Australia. I had a look at your submission, and thank you. It was really helpful. There's some statistics in your submission and some helpful graphs. We're not allowed props in the Senate, but I can kind of show you there's some helpful things on pages 4 to 5. And I wanted to ask you about that research. and particularly around the preference for an independent regulator to develop the Children's Online Privacy Code. That's being proposed in the bill. Can you just step us through some of those findings, particularly around the Children's Online Privacy Code?
Yes, thank you, Chair. It's always nice when we've got fans of our graphs, so it's appreciated. I'm just getting the document up in front of me. I suppose the context for this data and this part of the submission is really to try and pull together our own experience navigating industry co-regulation, which until this bill has appeared to be the preferred route for digital policy making in Australia. And so our headline is that we enthusiastically support the designated role of the Commissioner to draft the codes themselves at the outset. And so we provide in our submission some evidence with the shortcomings in industry drafted code making, which has been, as I said, until now, the status quo. So the sources of evidence we have on that is some polling. I think that's the first graph, which is indicating the significant public trust issues with industry code drafting. So we have here only 21% of adults in Australia, that's N equals over 1,000, only 21% of adults suggested that they trust the social media industry to write their own codes, and I think everyone here is unsurprised by that finding. So 76% prefer the Information Commissioner to draft any potential privacy codes for children. So we take that data point as strong public support for the model proposed. And I suppose the other evidence in our submission is with respect to a case study where industry attempted to set safety standards for young Australians, particularly privacy defaults, and we saw some unacceptably low standards of protection. So we point to that as evidence that we surely would not want to repeat the errors of the past and hand industry the drafting pen again. So to reiterate, excellent news that the Commissioner is being empowered to do this.
Well, thank you. Thanks very much. The other question I had for you in relation to that research was around small businesses, and I guess we'll come back to that to other questions, but particularly for your research that you do, how concerned are small businesses about data breaches where the personal information of their customers is compromised, and the extent that small businesses feel they're prepared to deal with that type of data breach?
Thank you, Chair. We don't have polling data with small businesses, so I don't want to misrepresent any of the data that we've got. I would like to reiterate Ms O'Shea's point, which I think is a really good one, which is that there's really good intentions in the small business industry, and working through this exemption in a considered way would have a positive outcome so that businesses can more appropriately protect themselves, if that answers your question, Chair.
Yeah, it does. Thank you. I've got some broader questions for the rest of the panel. And it goes back to your opening statement, Ms O'Shea, about the need for reform, and then also the importance of the tranche to reforms. I think most of you on this panel have acknowledged that this bill is a positive first step, and there's also support for a tranche 2. We've had some witnesses and some submitters suggest that we shouldn't progress through this bill because tranche 2 is essentially not complete, and that we should wait even longer to get that change happening. You sort of mentioned you've got almost a position for the committee to consider as a recommendation to government around tranche 2. But what is your position about this bill and progressing this bill? Because this committee will have to make a recommendation about passing this bill and whether the Senate should do that. Happy to take other views around that as well.
Chair, I'm not sure if that question was directed at me, but I might start. I speak for Digital Rights Watch, but I suspect I speak for other civil society organisations in that we would like to see this bill passed. We've obviously made various recommendations about how we think it can be improved, but we think there is a real urgency around privacy reform. In part, that's because the current Act is so significantly out of date. We are out of line with comparable jurisdictions from a basic privacy rights perspective. And then, of course, the public largely support these measures to the extent they've been asked, and they have been in polling and surveys. The Office of the Australian Information Commissioner conducts a survey with the Australian public which shows a mandate for this kind of reform. In general, many civil society organisations are calling for the implementation of the remainder of the recommendations that were accepted by this government, either in principle or with in some, that they be introduced within 6 months of the election or sooner if possible. But that's the frame that we have been working towards because we do think there is urgency. This has been going on a very long time and there's a real need for us to improve privacy protections in Australia.
Yeah, okay, thank you. If anyone else want to comment on that, because I think this will come up throughout the committee hearing today, but also in the debate in Parliament.
Just very briefly, we would endorse that view. In a perfect world, of course, all 100 plus recommendations that the federal government has committed to should be in a single bill, but we don't live in a perfect world, so we've got two choices: either to move forward with this bill with some sensible amendments, or to delay and defer. And clearly, it would be better to move forward with this bill with those reasonable and sensible amendments. The kind of sad history of privacy reform in Australia, particularly over the last 19 years, has been that government has found it very, very difficult to progress to a bill, let alone to actually enact the bill. And so I would treat with some real scepticism stakeholders who are saying, look, we haven't been properly consulted. This has all been kind of foisted upon us with, it's all new information to us.
Yeah, thank you.
If I could, Chair, sorry, I just wanted to add one further remark, which is from a digital rights watch perspective at least, but other organisations may also endorse this, I don't know. But there is a way in which privacy reform cuts across multiple fields of policy reform. So systems like digital ID gain greater trust from the public when there is strong privacy reform behind it. Problems like mis and disinformation, which is also an issue before this Parliament, they have a relationship with data extractive business models for which Digital Rights Watch has given evidence about that particular issue. The protection of children online, which is obviously a source of considerable concern for the public, for also policymakers and parliamentarians. A lot of these issues at their core have a privacy component, and there is an interest, I think, for policymakers who are concerned about all these topics to get behind and support privacy reform that will target data extractive business models that have problematic implications and effects for our democracy as well as for us as individuals. I wanted to add that to give some weight to the argument that there is some urgency behind this reform.
Thank you very much.
Chair?
Sorry.
Sorry, Chair, if I could add to that just briefly.
Yeah, of course.
EFA has the same concerns. The Act was passed in the previous millennia, to give it context. The basis of the principles on which privacy law was passed in Australia was on technological neutrality. That hasn't succeeded. No one expected the technological advances that we have today would arise. No one expected newspapers will be put out of business and are now principally data brokers, big media data brokers. So it's essential that this bill pass. Understandably, from a business perspective, it's been put into two tranches because the other approach would have been a big bang change, which is very expensive and very difficult for business to pass. So this is actually quite intelligent from a business perspective, even wearing my civil society hat. But it's critical that we get some promise from current government to enact a bill within 6 months of the election, or to get some sort of promise around tranche 2, not going off into 2027 or something like that.
Yeah. No, I take that on board. It's clear to me from your evidence that the Tranche 2 reforms are pretty important as well. The other question I had was around the importance of acting on implementing the fair and reasonable test and modernising the definition of personal information in the Privacy Act. I guess broadly, if anyone has a view on this, it would be helpful. Do you consider it important to act on these measures in particular, the definition of personal information and the fair and reasonable test?
Absolutely critical to the success of the legislation. Absolutely critical to making Australian privacy law equivalent to contemporaneous laws in other jurisdictions, and absolutely critical if Australia wants to achieve adequacy for the purposes of the GDPR, as New Zealand did in January of this year.
We would agree with EFA. I think that definition of personal information needs to keep pace with how technology has moved. And so our submission basically endorses what the government's committed position is in any event. But perhaps picking up on the point that Elizabeth O'Shea made on behalf of Digital Rights Watch, that there's recent legislation, including in respect of digital ID, two bills that were passed in this parliament that rely on some of the protections in the Privacy Act. Now, if those protections are sort of inadequate because they don't encompass the full range of what is personal information these days, then those bills can't really, or that law can't really provide its protective function. And there's a real risk that a major government initiative on digital ID that has, pretty solid-ish support in the public could be completely undermined because those protections haven't been put in place effectively enough. And, we only need to go back and look at the My Health record problem to see how that can cause really serious problems.
Yep. Okay. One other issue that's been raised, I think you were asked by Senator Shoebridge around views around small business. There's obviously a lot of issues and submissions that are trying to grapple with this idea. I think, my question is around the tort and the exemption. So it's been proposed by the Council of Small Business Organisations and the Australian Industry Group that small businesses should be exempt from the tort. I'm not sure whether there's comparable jurisdictions around the world that have an exemption for small businesses to privacy laws, but what are your views about whether small business should be exempt? That's to the panel, so anyone who has a view.
Well, maybe if I can start while I've got the conch. We're not aware of any jurisdiction that has a comparable exemption to the one that's being proposed by some of those stakeholders. We would say it's a very, very difficult position to maintain. The right to privacy is a human right. As just an ordinary member of the public, it is no less harmful to you if your right to privacy has been seriously invaded by a large company or a small company. It is just as harmful if it's a small company. So I don't think it's helpful to focus on this idea of offering certain companies some kind of blanket exemption, but rather I think it would be more helpful to focus on what the Small Business Ombudsman has been calling for, which is really clear, practical guidance for small and medium-sized enterprises so that they really understand how they can stay on the right side of the law and what are some of the easy things that they can do to make sure that they don't, inadvertently fall foul of this new law. But bearing in mind, it sets a high bar. The Australian Law Reform Commission was very clear about that, and the government has endorsed that position. But this is not just about trivial breaches of someone's privacy, it's about serious invasions of privacy.
Senator, I might jump in and endorse what Dr. Santo has just said, but also on the issue of exemptions generally. I think the approach that this bill has taken in using kind of broad exemptions and the suggestion of having further broad exemptions, like you've just suggested for small business, is kind of not the approach that the Law Reform Commission took in the proposed model, and that the issues that those exemptions are trying to address were better addressed through the concept of a public interest defence, or through defences that use that approach, where the appropriate kind of balancing of the rights of the person experiencing an invasion of privacy and the public interest in the other issues that are dealt with by the exemption, so freedom of expression, freedom of the press, and the ability of law enforcement to conduct their lawful activities, can be recognised in a more balanced way, rather than using the kind of blanket approach that just results, as Dr. Santo has pointed out, in people who have experienced the same kind of harm not having a remedy because an overly broad exemption has been used.
Yeah. On exemptions, I have one last sort of area to touch on. After we have a bit of a break, we're going to hear from some media organisations, and I know that your submissions, particularly Digital Rights Watch and the Human Technology Institute, have made some recommendations or suggestions around the journalism exemption for the tort, and that it's actually too broad. It should be confined more to journalism that isn't in the public interest. I guess, on the other hand, there are some organisations, some media organisations in particular, that would probably like a broader blanket exemption. So I'm interested in that balance that we're seeking to find through the bill. Obviously, we need to find the right balance between press freedom but ensuring journalists don't have to prove matters that are in the public interest when they're already sort of dealing with that in the courts. What is the concern, I guess, about the current exemption, and how can that be, when the committee is making recommendations about how to draft these types of exemptions, what are the things we should be taking into consideration, given we'll probably hear the other side of the story in a few moments?
Well, just very briefly, as currently drafted, we don't consider that the statutory tort would cover some pretty egregious conduct. Take for example, the illegal phone hacking conducted by the News of the World newspaper in the UK, which involved a whole range of prominent people in the UK. That would be exempt from the statutory tort. Or if a tabloid photographer was doing upskirting photos and publishing those, that would also be exempt. We just can't understand the public interest in allowing that egregious conduct to be exempt from the statutory tort, simply because the person or the organisation who's responsible for the conduct happens to be a media organisation or a journalist. That just doesn't make sense to us. So instead what we're saying is there should be a really strong focus on protecting public interest journalism, and that would be by having a broad, robust defence for anyone who is accused of this statutory tort, breaking the statutory tort, that they are engaging in public interest journalism, not simply that they have the status of a journalist, and so whatever they do cannot be impugned.
So Shay, did you have a view on that as well from Digital Rights Watch?
No, I would endorse those comments. I think as a matter of how a proceeding might be brought, I would struggle to see the objections from media organisations. I would struggle to see their merit in claiming that the protections are not significant enough in the bill as currently drafted, because they are very significantly broad. They're very broad. They're significantly broad. And I feel like the claim that they ought to be narrowed is legitimate, and I endorse the comments of my colleagues at the Human Technology Institute. I would say as well, the other kinds of cases that have come up in the UK are things like photographing children of public figures when they're in public. And I think that kind of coverage of people's lives, it does often occur by media organisations, but I query whether it's in the public interest, and I think, you know, there should be some consideration of whether it would fit within a defence rather than, say, just an immediate existence of an exemption. And as it's currently drafted, I'm curious to know how the process would work when, as far as I can tell, you would have to have a mechanism where a plaintiff would need to demonstrate that it doesn't fall within the exemption as a preliminary matter. But there are also other court processes that exist, including the use of things like summary dismissal and striking out and the like, that exist as part of normal court procedure that would assist media organisations where they've engaged in proper practices and engaged in public interest journalism. So I don't think it needs to be an exemption to still have the functionality of trying to deal with vexatious litigation. There are other processes that exist within court rules already that would provide for that. So I share HTR's concerns about the breadth of the exemption and its functionality. I think it would be better redrafted as a defence.
Okay.
Senator, I'd just add my endorsement to the comments from both the Human Technology Institute and Digital Rights Watch. And perhaps just refer to the submission that Senator Sky referred to earlier from Professors McDonald and Rolfe, where they discuss the exemption for journalists and the lack of limits on that exemption, and point out that even if a journalist were to commit a crime in the process of invading that privacy, the exemption would apply. And again, that type of exemption was not proposed by the Law Reform Commission and was not then subject to the extensive consultation that went along with the Law Reform Commission proposal.
Okay. I have a really quick one to finish off. Sorry, we've almost run out of time. Really quickly, the Business Council Australia has also recommended that there should be an exemption for the tort in relation to employee records. I'm not sure why, but I was wondering if you have a view on that sort of exemption, whether it's necessary or appropriate. Ms. O'Shea, you might have a view on that, I imagine.
I actually will need to take that on notice, I must confess. I haven't thought about it, but I'm not sure how I could see that it would be justified. The tort does have in place various ways in which there are protections against frivolous or vexatious claims, shall we say, including that it has to be intentional or reckless, and that it's serious. So I query the need for exemptions, and I query some of what other stakeholders have been saying about the grave difficulties or problems that might be imported with this proposal, which I'm not sure I agree with.
John, I think you had your hand up via video conference. Did you have a view on that?
Yes. Just by way of history, the employee records exemption existed at a time when it was meant to end up in workplace relations law. It did not, due to a political situation. The reality is that the information we collect about employees is no different than the information that organisations or government agencies collect about their customers or clients. There is no distinction to be made in how that technology is collected. There is no distinction to be made in how that information is managed, the IT infrastructure on which it sits. There's no reason why that the employee record exemption cannot be repealed and work equally as well amongst the new privacy principles by way of any necessary minor exceptions that might need to be made to protect employers' positions in relation to legal claims. In the same way that we have exemptions under Australian Privacy Principle 6 that allow organisations an exemption from the Privacy Act, minor exemptions could be made here, but there is particularly in an operational sense, no distinction at all between an employee record and a customer record. And the very fact that we have a situation where an individual who applies for a job with the government or a private sector business has their personal data protected by the Privacy Act prior to them joining that business, and essentially when they join that business, those privacy protections, those rights are essentially lost. It can't be sustained.
Thanks very much. And on that note, we've run out of time, and we want to thank you all for your submissions and also the evidence you've given today and taking the time to speak with the committee on this bill and, of course, on all the other types of legislation and inquiries that we conduct. Thank you very much for your time today. The committee will now suspend until 12 o'clock Canberra time, and we'll be back then with our next panel of witnesses. Thank you very much, everyone. hearing. And I now welcome representatives from the ABC, the Special Broadcasting Service, SBS, and the Australians' Right to Know. All of our witnesses are joining us via video conference today, so thank you very much for joining us. Information on parliamentary privilege and the protection of witness and evidence has been provided to you and is available from the Secretariat. For the Hansard record, can I ask you each to please state your full name and the capacity in which you appear today? We'll start with the team at the table that I can see. I'm sorry, I can't see the other group. You might still be on mute, unfortunately. Ms. Wilson, shall we start with you if your microphone is working? Do we have SBS with us, Sophie?
Yes, Chair.
Okay. All right, I think we've fixed it, so thank you very much. We'll start again. For the Hansard record, can I ask you to please state your full name, the capacity in which you appeared?
I'm Hamish Thompson from The Guardian Australia, here with Australia's Right to Know Coalition.
I'm Kaya Officer, Executive Council of Nine. I'm here in my capacity as a member of Australia's Right to Know.
Georgia Kate Schubert from News Corp Australia, in my capacity as Australia's Right to Know.
Claire O'Neill, Director of Corporate Affairs at SBS, and we are also a member of the Right to Know Coalition.
Lynn Chemist, Senior Legal Counsel, and also here from SBS, and also here for Right to Know.
Bridget Fair, I'm the CEO of Free TV Australia, also a member of Australia's Right to Know.
I'm Brett Farrell, the ABC Senior Privacy Officer, and also here as part of the Australia's Right to Know Coalition.
And Sarah Kruger, Chief Legal and Government Affairs Officer for Commercial Radio and Audio, here as a member of Australia's Right to Know.
Okay, wonderful, thank you. And Ms. Wilson, I don't know if we've fixed your technical issues, whether you're able to join us now. So we'll seek to fix that. But before we go to questions, is there a brief opening statement someone would like to make? I'm assuming you've got a collective one, hopefully.
Chair, we haven't prepared an opening statement. Our submission made to the committee stands, and we're willing to answer questions.
Perfect. SBS, do you have an opening statement?
No, Chair. We'll just take the Right to Know and our short supplementary submission as read. Thank you.
Okay, thank you. And just for as a courtesy from the ABC, do you have an opening statement?
No, Chair, we do not have an opening statement.
Okay, well, that's perfect because we don't have a huge amount of time, but I'm sure we have lots of questions. So I will start those questions off. Senator Scarr, you have the call to kick us off.
Okay, thank you, Chair. If I can first deal with perhaps the most simple area of concern that's been raised by the ABC and SBS, and that is namely that the exclusion of media organisations in the proposed new section 80KA2B, as it stands, only excludes commercial broadcasters as opposed to commercial broadcasters and national broadcasters. So if I can ask the ABC first and then SBS to speak to that, and also if you can comment as to, it seems to be an unintended error in terms of the drafting, but if you can provide any additional insight into that, if I could go to the ABC first.
Thank you, Senator. Yes, you're right. We did identify it as potentially an unintended drafting consequence, which we just put it in the submission, which was an ancillary point to the privacy tort exemption for national broadcasters or as government agencies. So it was just a drafting quirk. We thought it would be helpful to bring that to the committee's attention.
No, it is helpful. If I can ask our witness from SBS, our witnesses from SBS, they share the concern that there needs to be a tidy up in that regard?
Yes, Senator, thank you. And we do, I mean, it's not, in terms of it being a concern, it's really just flagging it. And it's partly, I think, stemming from the fact that it's not, I think, readily clear that a media organisation does not include ABC and SBS, and that we're in fact agencies under a different definition. So our feeling was that it was unintended and bringing it to the committee's attention.
Okay, thanks very much. If I can now go to the Australia Right to Know Coalition, and in the first instance, I'm interested to know if you've read or anyone's read the submission by Professor McDonald and Professor Rolfe in relation to the framing of the statutory tort?
Yes, we have read some of those submissions.
How do you respond, as I understand it, and I don't want to put words in their mouths, but as I understand their submission, they're basically saying that they've got a concern with respect to the exemptions and carve-outs as they're drafted, because those sort of matters should be dealt with in the body of the tort itself, and that it thereby constitutes a departure from the formulation of the tort put forward by the Australian Law Reform Commission. So I'm interested in, I want to make sure you've got an opportunity to respond to that, and also feel free to take on notice if you want to provide a more detailed response to their issue.
I think it's fair to suggest that the McDonald and Rolfe submission notes that the ALRC considered it essential to include in the legislation explicit recognition of and protection for the media's reporting functions, and that it's proposed to be achieved by building into the liability clause only. I think Right to Know and Professors McDonald and Rolfe had the same concerns with the liability clause at section 7.3 of the proposed tort. I think Right to Know's views were that building those considerations into the liability is not adequate, and hence we are asking for an exemption from the tort as it currently, and the proposed exemption as it currently stands. We don't believe it actually adequately delivers us an exemption to the causes of action that are able to be brought under the tort.
Okay. Did you have any other comments in relation to their submission?
I don't think there's anything.
I think
Can I just sorry to interrupt you. It might be easier. I'll just put a few quotes to you from their submission, because I'm currently getting my head around this. It does concern me that the Australian Right to Know Coalition has the concerns you've raised. That raises a substantial red flag in my mind, which I want to make sure I properly consider. This is what they say in relation to clause 15, the journalist exemption. The exemption for journalists in the bill is surprising in that we know of no similar exemption anywhere else in the common law world, and particularly in its broadness. Once engaged, there is no limit on the exemption. Even if a journalist were to commit a crime in the serious invasion of the plaintiff's privacy, the exemption would apply. We note that an exemption was neither proposed nor recommended by the Australian Law Reform Commission in its 2014 discussion paper or report, nor has it been the subject of widespread public consultation before this bill, end quote. So could I have your response to that characterisation? How would you respond to that?
It's Georgia Kate. I might just take a couple of those points first, and Hamish will probably follow on with some more substantive matters. It is in relation to that there are no other examples of an exemption. We put to the committee that there are a number of frameworks internationally that exist, which exist for the purpose of freedom of speech and, in fact, protection of the media, including Article 10 of the European Convention on Human Rights, obviously the First Amendment in the US, and, of course, Australia's own Privacy Act, as it currently exists, deals with and it provides an exemption for journalism as it currently stands. So we do believe that those things are already there. In relation to... sorry, I've just lost my train of thought in relation to the claims.
I could pick something up there. I think it's worth making the point in the context of this submission that we are all organisations that are bound by professional codes and have complaints processes in place, and none of us are aware of any ongoing sort of systemic problem with the way privacy is dealt with under those codes, under our complaints processes. And I think it's quite telling that there is absolutely nothing cited in that submission. There is no example cited in that submission to point to a problem. Now, there is a very healthy claimant lawyer industry, which I'm sure the senators will be aware of, and we are all organisations that are facing enormous financial pressures. And the point of an exemption here is to avoid us getting into those preliminary, very costly and really inappropriate ways to deal with what is already something we have systems in place for. And just to go to court, to have to prove a defence, to have to prove initial issues of serious harm, will have enough of a chilling effect on our journalists and on our editors to stop scrutinising the very people that are employing these claimant lawyers, the very wealthy, powerful people that are employing these claimant lawyers, and they will have achieved what they want to do. And I think it's telling that there is no evidence cited in these submissions of problems, of specific issues with any of our organisations currently.
Okay.
I think the last...
please. If you could, sorry to interrupt. If you could give your name just before just for the benefit of our good friends in Hansard, so they can follow it.
Sarah Kruger, Commercial Radio and Audio. I think the other point that the submissions don't necessarily recognise is the tough environment for media operators. So my industry, the commercial radio industry, has 260 stations across Australia in regional and remote areas that are no longer served by, in many cases, by any other local media outlet. 220 of our members are in regional remote Australia, and they are doing it tough at the moment. And any risk, whether that is in terms of additional administrative burden, financial burden, litigation, or the risk of some kind of adverse consequence, will have a chilling effect, because our stations simply cannot afford to go down a litigious route.
And Senator Claire O'Neill from SBS, if I can just add as well, I mean, the second element of that quote, I think, suggested that, you know, it would provide us with some sort of licence to engage in inappropriate activity. There's already a wide range of regulations and laws that, you know, that govern anything that might be considered malicious or nefarious activity, things like Surveillance Devices Act, defamation. We already have a lot of those things that, you know, control the way that we engage in journalism and do so responsibly.
Yep,
and just to add to that, if I could, Bridget Fair from Free TV, I mean, to the point around criminal law, We've got extensive criminal laws. No one's suggesting that we be granted an exemption from criminality. We're just saying that in relation to this tort, there should be an exemption for media activities. That, of course, would not preclude the law being properly enforced in relation to criminal offences.
Okay, thank you very much. That's very helpful. And if you would like to put anything else down in writing in response to that submission, I thought it was important to tease out your responses, which I think you've well made. But if you do want to add any further thoughts in that regard, I invite you to do that on notice. The next area I wanted to cover was the concern, and I think, again, your submission did a very good job in terms of bringing this out. You're concerned that, in effect, the tort of privacy in an international context, the international experience, that it is actually mobilised by high-profile individuals to seek to shut down legitimate discussion in relation to matters that might be of the public interest. So I'd like to give you the opportunity to develop your thoughts in relation to that further, and what we need to be aware of, and where we should draw the line in terms of legitimate public interest media, which you and your organisations engage in, the public interest journalism, as opposed to areas which maybe do cross the line into matters which are fall legitimately within the realm of individual privacy. How do we draw that line? And how does this bill get it right or wrong?
I think, Kaya Officer from Nine. I think our initial observation is it is correct that the international experience suggests that these are not laws utilised by everyday citizens to protect individual breaches of privacy. They very much become tools of celebrities, politicians and wealthy public figures to essentially stifle the publication of information that might be at odds with whatever public persona they seek to portray. And that seems to be the primary use of these laws through the courts, certainly in the UK. Particularly in Australia, the prohibitive cost of going to the federal court, for example, suggests that that would also be the case here. Our experience with defamation laws would also suggest that that is likely to be the case, and so that this tort is unlikely to provide a remedy for individual citizens seeking to protect their privacy. And I would go back to the point Hamish just made earlier, which is that, and there is also, we have yet to see any real evidence that there is in fact this danger or threat to the privacy of individuals that requires protection through the implementation of a tort that applied to media. Insofar as what should be protected and how do we strike that balance, I would refer to Right to Know's submissions on that point. Journalism and is a very wide range of services that professional media provide to the community. All of those services have importance, and there is a public interest in freedom of discourse, freedom of expression and transparency. And we would say that those rights should be, or those principles should certainly receive protection.
Okay, so one of the ways, having gone through the submission, one of the ways in which you're proposing that protection occur be through adding an additional limb to the cause of action, and that is that the invasion of privacy has caused or is likely to cause serious harm to the person. Harm to the reputation of a person is not serious harm. Presumably, though, harm to the reputation of a person could be serious harm, couldn't it? It might be justified, but it could be serious. Could you speak to that proposal? What's the? I understand what you're trying to achieve there, but again, it's a question of balance, isn't it?
Yes, Senator, in the UK, it's privacy is certainly used to manage reputation. I think the one of the things that it's given rise to a whole series that will certainly brought to the public attention the issue of strategic lawsuits against public participation, which is an issue that the US have dealt with for a long time, and there are now laws coming into place in the EU and in the UK. Situations where you see, shockingly, now sanctioned oligarchs like Roman Abramovich suing UK publishers and journalists. I think there was a case brought here as well in terms of defamation. He certainly would have used a tort like this to come in and use his bottomless pits of money to threaten and intimidate the media, who would have likely backed down.
Yep. Okay.
And to add to that, sorry, Kaya Officer from 9 again.
Thank you.
I think when looking at comparable jurisdictions, one thing to bear in mind is that Australia is widely referred to as the defamation capital of the world, and the defamation laws that we have here certainly operate in a way that imposes far greater restrictions on the media, both in practical and financial terms as well as in legal terms. So I think when you're looking at those comparable jurisdictions, that is something to bear in mind. Protection of reputation is very well catered for in current Australian law. And even so, the legislature sought it fit to introduce a serious harm test to defamation, to recognise that there is a threshold there that to try and minimise the number of claims before the courts and to limit those to only the most serious cases. And even so, we still have a very booming defamation industry. So we would say that that is a comparable test to apply.
So is Hamish Thompson, The Guardian again, I think.
Please go on.
Okay. So, sorry, Senator. One point I was going to make is that in comparable jurisdictions, you're looking at the US, the First Amendment, Canada, New Zealand and the UK have all implemented laws that enshrine the right to freedom of expression, which is not something that has happened in Australia and is regularly called out for not having that protection. So when you're looking at striking a balance between privacy and the impact of the enforcement of privacy law, when the courts are not bound by a similar provision that, say, the UK is, where they have an express provision under Section 12 of the Human Rights Act there to take account of freedom of expression when dealing with privacy threats, I think an exemption is imperative for the media here.
Okay, understood.
I'll have to share the call in 2 minutes just to give you a bit of warning.
Okay, sure. So the concept is, if it's a reputation issue, the appropriate route for redress is the defamation law. Is that the thinking? It shouldn't be an action under...
Yes, correct.
Yes. But that privacy laws will be used as de facto defamation laws if they are able to be.
Okay, understood. And then just some of the other points, and I must say your recommended amendments were very useful, so congratulations to whoever drafted that. There's
team effort.
Team effort, good, excellent. Well, there's a need for more parliamentary draftspeople in Parliament House, so you've got a job here. I thought obviously there's a concern with respect to the onus, who bears the onus in terms of demonstrating there's a public interest or not being a public interest, and that informed the amendments proposed to 7.2, and then also there's obviously a concern that unless you get the balance right in terms of interim injunctions, there's a risk that someone can simply initiate a process and thereby shut down a story or a discussion in the media through the use of an interim injunction. So I'll just, as my final question, I might just give you an opportunity to speak to those 2 points. So firstly, how we demonstrate public interest and who should bear the onus in terms of any procedure. And secondly, the importance in making sure that the interim injunction process doesn't act de facto as impeding legitimate public discussion of matters.
Bridget Fair from Free TV. Look, just to refer back to Hamish's points in relation to onus, it's very important to remember that in other jurisdictions, applicants coming to a court come to it with the court already being required to take into account that there is a requirement to consider that there is a right to free speech. So that onus is built into the underpinnings of the legislation before it even starts. Here in Australia, we don't have that, and that's why it's very important that the onus must fall on the plaintiff to show that there is a public interest in bringing their claim, not for media organisations to rebut that, because we don't have the underpinning of the right to free speech. So it's absolutely essential.
Okay, and then lastly, in relation to the interim injunction point?
On the injunction point, Kaya Officer from 9 again, the risk with the practical effect of injunction powers is that it enables people to temporarily seek to suppress the story, at which point costs are already being incurred. And the mere prospect of costs being incurred will itself, particularly for smaller media organisations, be a deterrent and a chilling factor in and of itself. The other types of applications that become weaponised in these sorts of scenarios are preliminary discovery, powers to try and identify confidential sources, and the use of the injunction power itself, which again we've seen in the UK. The granting of the injunctions and super injunctions have themselves become an industry which is enormously costly for media and utilised mainly by wealthy plaintiffs seeking to, stifle examination of their activities. So for all of those reasons, we say, as well as things like the burden on the court, the huge increased burden particularly on the federal courts for these types of issues, we say there is a real public interest in limiting the ability of people to stifle those reports and also to utilise the courts in order to suppress examination of their activities.
Okay, thank you very much.
Thank you. Senator Shoebridge, you have the call.
Oh, thanks, Chair, and thanks everyone for their submissions and engagement. In terms of interlocutory injunctions directed at journalists to try and get their confidential sources, how do the federal shield laws intersect with that?
I think it's a very good question. It's Georgia Kate Schubert, Senator. It's a very good question. It is unclear how those things intersect. And I guess it would have to be tried, but I think our view is that it raises the question of the evidence laws, which until a case came about, we don't know how it would fall. I think that's why we're building in some of these other amendments into our suggested changes to the law to ensure as much as possible that is actually not the uncertainty that arises is not something we need to be caught within in relation to sources.
Well, it's just, I don't see any reference to the shield laws, but there's an existing statutory protection to protect journalists' sources, which isn't mentioned in your submission, but it seems to me to be critical if we're to understand the risk to your confidential sources. And I want to be clear, I'm interested in ensuring confidential sources are protected, but it would have been useful to get your views on how the shield laws would work in this context.
Kaya Officer from 9. I think certainly the journalists' protections under 126K, they're certainly not guaranteed protections. That process is itself quite onerous and certainly not... there are many, many examples of journalists being denied the opportunity to claim privilege, and that obviously applies to journalists claiming privilege over sources. I think one of the concerns about this is that the exemption as currently drafted does not cover sources. So the sources themselves are potentially vulnerable to being sued under the tort, and the sources themselves don't necessarily have the benefit of those shield law protections. And the whistleblower protections that we currently have in various jurisdictions we would say are not necessarily adequate to provide the level of protection to those sources. And again, we have not examined, nor are we certain about the interplay between whatever current protections there may be. But we certainly do have concerns that the bill as currently drafted appears to create some exposure for confidential sources.
Can also come back to you on notice with some further detailed consideration of that.
I think that would be useful, and I'd invite any of you or collectively to come back on notice about how those interact. Your submission pushes against the ALRC recommendation that damage shouldn't have to be an element of the tort. That ALRC recommendation is now a decade old and seems to have been broadly accepted that for if we're going to put a tort in, that some kind of serious damage threshold should not be part of a tort. It does seem odd, 10 years after that recommendation was advanced by the ALRC, to see us go back to a debate that had largely been put to bed, I thought, by the ALRC a decade ago. And apart from media outlets, nobody else supports that inclusion in the tort. Does anyone want to reflect on why we're going back to a debate that was settled a decade ago?
Bridget Fair here from Free TV. I mean, Senator, in the past 10 years, I think we've seen a complete explosion in the use of defamation claims as a means of trying to shut stories down. And we've also seen an explosion of costs up to, companies spending $30 million plus defending defamation claims. And this in itself has an absolutely chilling effect on the ability of media organisations to report stories, both large and small. We have boardrooms around the country for small organisations up to listed companies who are actively debating the amount of money they can put aside to fund legal actions that are brought on a speculative basis, because we have a defamation claims industry in this country. We do not want to replicate that in the privacy arena. These were not matters that the ALRC turned its mind to. In fact, it's almost impossible now for many companies to afford directors and officers insurance because of the explosion in costs of this nature. Insurers are refusing to provide cover that people can actually afford, and many companies are having to take the risk to self-insure. So these are all matters that flow through to the media's ability to report on matters of public interest. And I don't think that that's something that the ALRC recommendation adequately considered, and it certainly wasn't necessarily a set of circumstances that existed in the lead up to that recommendation.
Well, a serious harm test would have not have been of assistance in that most notorious recent defamation case. One would have thought that, asserting that somebody had murdered people would have met the serious harm test to allow the action to proceed. But I come back to the point though. It's only media organisations that are putting forward this proposal to sort of unpick the ALRC recommendation. Have you thought about what an impact that would make more broadly to the viability of the tort? Because I want to be clear, absolutely there are compelling public interest reasons to give media protection, but there have been some appalling abuses of people's privacy without any valid public interest by the media in this country and in other countries, and people want to have some protection.
Senator, can you outline what appalling abuses you might be referring to there?
Intrusive photographs of people in private settings, notorious breaches of people's data, including, for example, with News Corp's related entities in the UK, actively stealing people's data, unlawfully stealing people's data,
Senator,
notorious instances.
Georgia Kate Schubert from News Corp, Senator. There has been no evidence of phone hacking in Australia, and in the UK that has happened a number of years ago, and the UK laws changed significantly since that time, to the detriment of reporting over. And I think my colleague from Guardian, Hamish McDonald, has talked about that previously in today's hearings. But there is no evidence of phone hacking in Australia. So the basis upon which that is being suggested by a number of submitters as a spectre of what needs to be dealt with, we do not agree with.
Well, I mean, most people see News Corp as a global entity, to be clear, and when they see a significant part of a global media player having shown such a lack of ethical standards, they not unreasonably want to have some protections for their privacy here.
And that has not been proved here, Senator.
Well, but I point out that News Corp acts as a global entity.
As I said, it's not been proved here. And in fact, there was an audit done at News Corp in Australia after phone hacking in the UK, and no evidence was...
we can have the argument back and forth about whether News Corp Australia or just News Corp UK engaged in the conduct. But you ask me why people want protections. It's because they've seen that kind of vile conduct.
Senator, with respect,
so it's a question about getting the balance right. And
Senator, with respect, Hamish Thompson from Guardian Australia, there are a number of other organisations in this room, ABC, SBS, The Guardian, who I think it's very important when we're looking at a piece of legislation that could have such a serious impact on a serious, very real impact on our editors' decisions about what they investigate and what they go through with because of the cost implications. That there needs to be specific examples of Australian egregious breaches by the media to be put in place, and none of these submissions that have listed these things. There are no specific examples. There's generalised talk that generally refers back to the UK, back to Leveson, and that is not a problem that is extant here.
And Senator Kyra, officer from Nine.
Sorry, the chair here. If I can just call order for a moment, Senator Shoebridge, if you have a question, I have to share the call with myself because we have a few more questions before we leave this panel. If you have a final question you want to put, and then I'll share the call.
Well, perhaps I could go. Your point about the narrow application of the exemptions seems to have genuine foundation in it. An example would be if a wire service like AAP produced a news report which was then syndicated and sold on licence, arguably the exemptions wouldn't protect other entities who are publishing it under licence. That's one of the concerns you have about the narrow exemption?
We would want to remove that ambiguity.
And you have two different options for removing the ambiguity.
Yes.
Do you have you considered another option, which would be extending the definition or putting some additional subclasses in 15.1?
Senator, it's Georgia Kate again. The two options that we've presented to the committee are the two options that we think best deal with our concerns in the scope of our concerns. We do not think that the proposed drafting is at all redeemable to actually address our concerns, other than what we've proposed in options 1 or 2 in our paper.
I suppose the concern I have about...
Thank you, Senator Shoebridge. Thank you. I have some questions I need to put to these witnesses. Thank you very much. I have a different issue that I wanted to raise, specifically with ABC and SBS. There's part of the proposed bill Part 3 deals with emergency declarations, and as a senator from a pretty disaster-prone part of the world, I'm very alive and conscious to the fact of the role that particularly public broadcasters play, but all media organisations play when we have an emergency and a disaster in our communities. You recommend, the ABC particularly recommends that the exclusion of media organisations in the proposed new 80KA, I think it might be, which only it stands only to exclude commercial broadcasters, but it should also exclude national broadcasters. I just wanted to get your views on that drafting. That might be something that we can recommend is remedied.
Thanks. It's Lynn Chemist from SBS. It's a great question. And I think that, in short, if the concern is about national declarations or emergency information, then the counter question to that would be, why exclude any media organisation? I think, and it's a question for the drafters. I don't think SBS, I won't speak for the ABC, I don't think we have a significant stake in it being one way or the other. But I guess if there is an interest in us being included there and not the other media organisations, maybe query why, I think the public policy question could go the other way, and perhaps maybe looking at how other media organisations could be included as well. Because I think the purpose here is about the provision of people's personal information for in the case of an emergency like a COVID outbreak or similar, and it's permitting government entities to quickly, distribute information about individuals that might urgently need to know their exposure. And it's suggesting that the media is not the way to do that, was my reading of the legislation. So if you do want to loop the national broadcasters in there, some question about what that could look like.
Yeah, Senator, it's Brett Farrell from the ABC. We understood this particular use case was out of recent data breaches, whereby to protect consumers from subsequent fraudulent activities from data breaches, there was a question whether or not organisations who had suffered data breaches could validly share personal information, say with banks, to ensure fraudulent protections were put in place for those customers. So we understood that's what this provision was attempting to do. And then there was one lens that would make sense in that use case to exclude media organisations from having that data in those circumstances. So it made sense that perhaps if that was the intention of the Parliament, that the national broadcasters were looped into that as well.
Okay, thank you for clarifying that for me. That's helpful. If I can just go to the point which has been discussed with other senators, obviously it's around the way that the statutory tort would apply to journalism. Something that we haven't necessarily talked about, and I'm just sorry, I'm getting the legislation up in front of me so I can have a look. The tort does provide an exemption, a couple of exemptions, and obviously the first one in Part 3 of the proposed legislation has Section 15, which is journalists, and steps through what that who would be covered: a journalist, an employer of a journalist, a person assisting a journalist, a person assisting a journalist in the person's professional capacity. And it says that the schedule, so the tort, doesn't apply to an invasion of privacy by any of the following to the extent that the invasion of privacy involves the collection, preparation for publication, or publication of journalistic material. So there is a exemption there. You haven't provided, as far as I can see, amendments or recommended amendments to that exemption. Why does that exemption not go far enough, in your view, to protect media organisations or public interest journalism from these types of frivolous claims I guess you're suggesting people might make?
Senator, it's Georgia Kate. I'll have a first go stab at it without wanting to use a violent word, but our submission and my page numbers are blocked out on my printed version. Our submission, we don't actually provide a markup to the proposed exemption. Instead, we've provided two other options because, as we said to Senator Shoebridge, we don't believe that the current exemption can be operated upon without leaving it with any life. And so we have proposed two new options for the exemption. The issues that we have with the current exemption are outlined in our submission, but we've got concerns about the limitation of the term journalistic material and also the limitations on the limited availability. So including the way in which, in relation to limited availability, includes the way in which freelancers would work for an organisation, for example, because I'm a direct employee and those sorts of things. So it is quite specific and technical, but those issues are fully explored in our submission about what actually are the limitations of that. I mean, I could read from the submission if you'd like, or unless someone would like to summarise.
No, I have it in front of me. That's not necessary.
Sorry, that was probably for the I'm sorry, Senator, that was for the benefit of people in the room in case someone wanted to come in behind me, not for you. I'm so sorry about that, how that sounded.
I think the main thing I'm trying to understand is I can see your redrafting of that provision, but there has to be a balance, right, about the protection of public interest journalism, the promotion of that public interest journalism, and the protection of people's privacy. In terms of what this committee considers and what recommendations we make, we've had submissions that the exemption is actually too broad and should be narrowed, and I guess what we're trying to do is get the balance right. Is there a different definition that you'd like to see around what journalistic material is, if that's the term that you have an issue with?
Senator, I think it's fair to say that we've looked at how the drafting could be reworked, and options 1 and 2 cover that. I'd say option 2 is quite loosely based on some existing provisions in other laws that already exist in Commonwealth statutes that might be useful information. I think on the point around balance, and I don't want to labour this, and a number of my colleagues today have articulated much more clearly than I could ever do, but the balancing exercise in other legislation around in other jurisdictions exists because of those other frameworks that we've talked about already today, like in the European Union or in the United States of America. The importance of having an exemption in the statute in Australia is really important when we do not have those other frameworks that actually provide very clear indicators to the judiciary or anyone else about the importance of free speech in Australia's democracy. We know that it's a really important part of the conversation in Australia at the moment in relation to mis and disinformation and other terms, and the importance of the role the media plays in Australia and in our democracy. And so that's why we believe that the balancing exercise is important for the exemption to actually exist within the statute here. I'd also note that in a number of the submissions, they seem to talk about this balancing exercise and suggest that anything that the current proposed exemption is unprincipled. I may be reading too much into this, but it does seem that the unprincipled nature is that those parties do not believe that the balancing exercise should actually occur, that they would like primacy of Article 17 of the ICCPR being the right of privacy over that, which is Article 19, which is actually the provision of the right of free speech. Both of those rights actually have equivalence, and we think that the adoption of an exemption and a truly workable exemption, an exemption that's fit for purpose for the cause of action as it's currently drafted, is the most important element of the balancing exercise that can occur in this piece of legislation and in the Australian statutes.
Chair, it's Claire O'Neill from SBS. The other thing I'd say is this is not about a lack of accountability for the media. What it reflects is the fact that we have accountability already across a whole range of mechanisms, as my colleagues have talked about today, and it's just ensuring that that's reflected in this legislation.
Just one other issue that I wanted to discuss was the doxing offences. I think your submission, I'm just looking through it now, deals with the relationship between doxing offences and journalists. The explanatory memorandum for the bill on page 5 suggests that proposed doxing offences actually build on current offences in the criminal code which relate to using a carriage service, and there's no specific defences for journalism under the criminal code. For these, so I mean, I guess there hasn't really, I don't think there's been any journalists prosecuted under the existing offences, and I'm just trying to understand why journalists might be captured under the new doxing offences when they haven't previously been prosecuted under the existing offence.
I'll have another go, Chair. It's Georgia Kate again, and someone will jump in and set it straight. The doxing, our comments on the doxing offences are important. We've made representations as Right to Know over, and as individual organisations, I'm sure as well, over many years in relation to developments in not just the criminal code, but particularly the criminal code, that would see journalists jailed if they fell foul of these provisions. And this is, in a way, no different to any of those. These are serious consequences. We do believe that there is a risk inherent in doing what we do every day of the week, which is reporting, and potentially falling foul of these, and we do not think those are a good place to be. And it is an unnecessary risk that the media would face. And so for the purposes of clarity, we seek an exemption of a similar kind that exists in other places in the criminal code for that purpose.
All right, I might put some questions on notice. I think we've run out of time, unfortunately, so thank you for your time and for your submissions. And thank you for all attending around the big table.
Senator, Chair, could I just ask one question for clarification? And no, Senator Scarr has asked as well. You're going to put questions on notice, and Senator Scarr's asked us for some written feedback in relation to some elements he put on a table previously in relation to the McDonald and Rolfe submission. Could you give us an indication of when those materials would be due?
So the committee is yet to agree to a date, but we will be proposing the 4th of November.
Thank you very much. I appreciate it.
If that changes, we'll let you know.
Thank you.
Thank you very much.
Thank you.
Thank you.
Thank you.
Thank you very much.
Thank you.
Okay. Now, moving on to our next witnesses. And apologies, I've just lost my paper. There we go. Who I think are joining us in person today, if I'm correct. I might get a nod from the table while we have a changeover. Thank you. And online. Fantastic. Well, I now welcome representatives from the Australian Industry Group and the Council of Small Business Organisations Australia joining us via video conference. Thank you for taking the time to speak with the committee today. Information on parliamentary privilege and the protection of witness and evidence has been provided to you and is available from the Secretariat. For the Hansard record, can you each please state your full name, the capacity in which you appear, and we'll start in the room.
My name is Louise McGrath. I'm Head of Industry Development and Policy at the Australian Industry Group.
My name is Yoness Blackmore. I'm a Principal Advisor in the Workplace Relations Policy Team at AI Group. Thanks.
Thank you.
And my name's Adele Sutton. I'm from the Head of Policy and Advocacy at COSBO at the Council of Small Business. Thank you.
Fantastic. Thank you very much for joining us. Do either of you have a brief opening statement you'd like to make before we go to questions?
Yes, we do, Chair.
Okay, over to you.
Thank you. We thank the committee for the opportunity to provide further assistance to the inquiry following our submission we made on the 11th of October 2024. We note the committee is is to broadly inquire and report on the provisions of the Privacy and Other Legislation Amendment Bill 2024. As you may be aware, AR Group is a peak national employer organisation that represents employers of all sizes and which conduct business in traditional, innovative and emerging industry sectors. AR Group supports the need to provide the public with confidence that their privacy and their data is being handled safely and responsibly. We have focused our submission on this bill to the areas of relevance to our members in connection with the workplace. However, we refer the committee to our past submissions which set out our members' positions more generally in relation to the government's review of the Privacy Act. As you will be aware, we have consistently pressed for the employee records and small business exemptions to be retained and for the government to instead pursue best practice outcomes for members' dealings with personal information. We maintain this position. We'd like to briefly highlight several key points. Our members, as employers, deal with personal information for legitimate reasons and in the public interest. We ask the committee consider that. This includes where employers manage their workers' conduct and performance to ensure compliance with their obligations under workplace laws and to keep people and property safe and free from injury or damage. While a worker may believe that employers dealing with their personal information breaches their right to privacy, this should not always be considered when it occurs in connection with a workplace. The introduction of the statutory tort for a serious invasion of privacy is significant change that is not justified by any apparent existing shortcomings, especially in the context of the workplace. If the statutory tort is retained, despite our opposition, it is essential the employee records and small business exemptions and definition of personal information are applied to the cause of action. There must also be specific defences acknowledging the legitimate dealings with personal information in connection with the workplace and the public interest in maintaining that. Due to the generally commercial or proprietary nature of automated decision-making or other artificial intelligence tools, it will also be extremely difficult for most employers to be open and transparent in an APP privacy policy. A better approach would be to support our members in their adoption of these tools, including with reference to the 10 voluntary guardrails recently introduced by the government to support safe and responsible AI use. Finally, it is our position that the proposed expansion of regulatory enforcement powers and penalties is unwarranted and preemptive. OAIC's focus should instead provide business uplift through education and industry engagement, and the proposed amendments do not do that. We'll be pleased to take any questions.
Okay, thank you. And Ms Sutton, do you have an opening statement?
I do, yes. Thank you very much for the opportunity to appear before the committee today. Last week, COSBOA released our Small Business Perspectives report in partnership with CommBank, which revealed the ongoing difficulties small business owners continue to face, with more than half expecting operating conditions to only get worse over the course of the next 12 months. Already reeling from complex industrial relation laws to changing skilled migration requirements, COSBOA is relieved that the small businesses with turnovers under $3 million, including 1.1 million sole traders, appear to have been spared further complexity through the government's decision not to proceed with the removal of the small business exemption from the Privacy Act. The exemption was introduced as recognition of the significant additional compliance burden facing small businesses without the extensive resources available to large companies. We note the government's cost-benefit impact statement has still not been publicly released, which we believe would shed proper light on the compliance costs actually involved. However, it is also important to note that currently small businesses with turnovers of between $3 and $10 million are required to comply with the Privacy Act. The additional proposed requirements incorporated in the bill will impact those non-exempted small businesses if passed in their current form. So whilst noting our relief about what is not in the bill, i.e. that the threshold has remained, more worrying to us now is the proposal to introduce the statutory tort of privacy into the Act. The current drafting does not include a small business exemption and has very broad application across the community. The introduction of the statutory tort will create a new risk of vicarious liability, potentially exposing small businesses of all sizes to legal responsibility for the actions of their employees or agents, where the invasion of privacy occurred within the course of employment. We must ensure we do not bury small business in a multitude of legal requirements they are ill-equipped to comply with. It is vital that government is clear about the most significant privacy harms the community seeks protection from and then takes a risk-based approach to set out simply the actions small business can take to minimise these harms. A 2023 report from the Information Commissioner's Office found that 74% of the Australian public considers data breaches to be one of their biggest concerns. From a reputational perspective, categorically no business, large or small, wants to lose customer data. It's a PR disaster, and more so in the social media age, regardless of size or turnover. Based on the reality of their data flows, we need to arm all small businesses with the right tools, including scaled and proportionate guidance, particularly in relation to data breaches, so that they can play an appropriate role in the broader privacy compliance landscape. In conclusion, we are concerned that the proposed bill, particularly the proposed statutory tort, will merely introduce a significant new burdensome requirement for small businesses through the back door. The stark reality is that small businesses do not have HR or legal teams that can wade through pages of complex legislation. A one-size-fits-all approach to the Privacy Act is simply not feasible or appropriate. A pragmatic and considered approach to work with industry to produce appropriate and tailored guidance would be a welcome first step. Thank you very much.
Thanks very much. We'll go to questions, and I can start with Senator Scarr, who's in the room today.
Thank you, Chair. If I can go first to Cosboa. The question has been raised by previous witnesses we've heard from today with respect to the application of these provisions to small business, and that Australia is one of the, perhaps we've been told, one of the only jurisdictions which has this exemption for small business. How do you respond to that claim that, well, consumers have a reasonable expectation, Australians have a reasonable expectation of privacy, why shouldn't small businesses comply with the same principles that apply to everyone else in this regard? I just want to give you an opportunity to explain in the most forceful way possible the concerns you have in relation to rolling this out onto small businesses at this particular time.
Yes, and I think small business, I don't think the small business lobby at all wants to be perceived as a barrier to international trade. I think what we're saying is just the sheer breadth of complying with all 13 APP principles is a big compliance burden on small businesses. As I said, we haven't seen the cost benefit impact analysis which would outline those costs. That hasn't been made publicly available, so therefore it's hard to actually quantify without that data the situation we would be looking at. But I would note that even in other jurisdictions like with GDPR, there are specific, although it applies to small business, there are specific exemptions within that European legislation from certain types of principles. So, for example, I don't believe that, businesses with less than 250 employees, for example, necessarily need a data protection officer, and so there are exemptions within that legislation. And I think what we're saying here is let's look, as I just said, 74% of the Australian public are concerned, including small businesses, are concerned about businesses losing data. How do we allay those concerns in a pragmatic way by focusing on the APPs like APP 11, APP 8, encouraging small businesses to educating them to remove data that they're no longer using, and focus on the areas where we can really hone the compliance resources that are available to have the biggest impact in meeting community expectations of privacy.
Okay, the cost-benefit analysis that you're referring to, can you provide some more particularity with respect to that cost-benefit analysis and why it hasn't been, your knowledge as to why it hasn't been released?
I'm not sure. I understand it was undertaken by a third-party provider earlier in the year. We have requested it be made public, but at this stage I couldn't tell you why it hasn't, but yeah, it just hasn't been made public.
I might just ask the witnesses from the Australian Industry Group, are you aware of that issue?
We're not aware of the cost-benefit analysis being released either.
But are you?
So
let me go back. Let me go back a step. You're aware a cost-benefit analysis was done.
I do understand that there was certainly analysis done on the regulatory burden for SMEs in individual sectors, as I understand, but I don't know what the result of that was.
Okay. So can I just ask you, Mrs Sutton, how are you aware that a cost-benefit analysis was undertaken?
My understanding is that some of my colleagues prior to me taking this role were involved in that process of providing input towards the analysis.
Right. Could you provide some more detail just on notice in relation to that? I'd just like to try and flush that out if I can.
Yes, certainly.
Because if there is a body of work that's been done that has undertaken a cost-benefit review, that would be useful, certainly to inform my deliberations. If I can turn to the Australian Industry Group, the question was raised earlier today as to why employee records should be treated any differently from any other records. How would you respond to that?
Well, I might pass to my workplace relations expert.
Well, thank you, Senator Scott. I think that to take a step back, firstly, is that we need to understand that privacy can't be viewed in isolation, and there is a complex web of workplace relations laws. Now, employers must and are entitled to manage their workplace and run an efficient business. Part of doing so requires that they deal with data of their workers to, for example, ensure that those workers work in a safe way, to ensure that sexual harassment isn't happening in the workplace, and so forth. Does that answer your question, Senator Scott?
To some extent, but it has... let me go the next step. What's your concern specifically around the implementation of a statutory tort with respect to employee records in particular, and how that might obstruct the legitimate keeping of information in relation to employees on the basis of the matters you just outlined?
So our concern with it in relation to the statutory tort is that there is no... So if we think about a defence under the statutory tort, employee records is not specifically detailed under one of the defence items, and we think that that then has unintended consequences and certainly increasing the risk for employers and not giving them confidence and certainty in how they manage that data.
Okay, so do you want to walk us through, you said if the tort is to be imposed, the AI is proposing that certain amendments be made. Can you walk us through those amendments and why you consider those necessary?
Well,
Senator Scarr, so firstly, for consistency and clarity, we would propose that both the small business exemption and the employee records exemption be applied to the statutory tort, because otherwise you have the Privacy Act going along and then you have the case law happening on the side. We also would propose that information in terms of the statutory tort has the same definition as that applied under the Privacy Act, because at the moment the Privacy Act has a definition of personal information and health and sensitive information, but that is not the same as information under the statutory tort. So even just on the grounds of consistency, we think that there needs to be alignment in those things.
Okay, so just that first point then, just betting that to ground, if a statutory tort is to be introduced, your argument is that the exemptions which apply with respect to the privacy law more generally should also apply to the operation of that statutory tort, so there's consistency across the two applications, one a current application of privacy principles, the other a potential application of privacy principles. Is that correct?
Yes, Senator Scarr, but I would add to that, if I may.
Yes, please.
So in terms of the statutory tort itself, it obviously has a lot of different elements in it that are different to the Privacy Act. So, for example, it has a consideration of a reasonable expectation of privacy in all the circumstances. So whatever exemption, for example, that it is put together in terms of employee records, it needs to be adjusted to how this statutory tort is set up at the moment.
Have you had any engagement with the government on this issue? I mean, I used to be a general counsel, right? So dealing with sensitive employee matters, I can see the real everyday application of the concern that you've had. What sort of engagement has there been with the government, and what sort of response have you received from the government with respect to your concerns around employee records?
So we've had a great deal of engagement, as my colleague from COSBO has mentioned, in preparation for this legislation. However, it was primarily on the SME exemption and employee records exemption. We were very surprised to learn about the statutory tort, and we do not remember it. I mean, there's a lot of things going on, but we could not recall any conversation around statutory tort in the consultation process.
Okay, well, I'd like to run that to ground. So you're saying in relation to the consultation process in relation to this bill, that you're not aware of any engagement with respect to the statutory tort?
That's correct.
Okay. What about before this bill? Had there been any engagement since over the last few years in relation to this issue of the statutory tort? Obviously, we're going back 10 years or whatever it is to the Australian Law Reform Commission, which spent a year looking at the issue. Presumably, AI engaged with the Australian Law Reform Commission?
Presumably we did. Perhaps we were not aware of all engagement. It's certainly not within our internal discussion.
Okay, can I ask you to take on notice, and it is an important question for all stakeholders, the extent to which there was engagement with the Australian Law Reform Commission in relation to this specific concern about employee records. Obviously, organisations have got workplace health and safety obligations. There are issues around alleged sexual harassment, investigations, all sorts of issues in the context of employee records. So I'd be very interested to know if the AI group made submissions to the Australian Law Reform Commission in relation to the application of a statutory tort specifically to employee records.
Certainly, Senator. We'll investigate.
Okay. So the first you knew about the statutory tort being in this bill was when it appeared in the bill. Is that correct?
Correct.
Have you had any engagement with the government since then, apart from through this submission?
No.
Okay.
Senator Starr, I have to share the court shortly.
Okay. So what are the particular concerns you have then, if we can try and get to the nuts and bolts of what could well be unintended consequences that could flow from the application of the statutory tort to employee records? What are the particular concerns? One of them I note was in relation to employers becoming more guarded with respect to the information that they keep, which, I mean, there are competing interests in that regard. But what are the particular practical concerns you have?
Well, fundamentally, regulatory coherence, because if there is an exemption under the Privacy Act, then the exemption should continue within the statutory tort.
Okay, I understand that. That's neat, but we're not there yet. So, how do you convince? What are the specific arguments that apply? The specific concerns that apply if we went down this track and didn't have an appropriate exemption for employee records? I understand the coherence point, but I'm trying to get to the nuts and bolts of the practical implications that will arise if we don't have a carve-out for employee records. And feel free to take it on notice, but other stakeholders who have made submissions to this inquiry, I understand it's an abbreviated amount of time, but they've given specific case studies, for example, media organisations with respect to their specific concerns about how this could impact upon the members they represent.
I think we'll take that invitation, Senator, and provide specific case studies.
If you could, it is important, I think. Thank you, Chair.
Thanks very much. Senator Shoebridge.
Thanks, Chair, and thanks to each of the organisations for your submissions. To be clear, this bill doesn't remove the small business exemption. It just retains the small business exemption. And you've probably seen there's a series of submissions that have said that the exemption should be removed and small business should be covered by the Act. So your submission, if I understand it, is it should not only be retained but extended from a threshold of $3 million to $10 million in turnover.
I don't think we made that.
That's Ms. Sutton. Yep.
Yeah, I think we just made the point the point we're trying to make is that I suppose it's called the small business exemption, but in fact, with the $3 million threshold, it's actually sort of split. So really, it's probably more akin to what the ATO would define as micro businesses. I think they define them by $2 million. So really just noting that although we've retained the small business exemption, there are currently many small businesses between $3 and $10 million who are required to comply with the Act already, because the $3 million has never been indexed over time. That number of small businesses has increased. So, not necessarily saying it should be, in an ideal world, yes, it would equate to all small businesses, but just making the point that the changes that are coming in will apply to a raft of small businesses that are already required to comply between that $3 and $10 million mark.
Well, I think the ALRC first recommended removing the small business exemption in 2008, saying that there was no principal basis to have a small business exemption, and referred to the fact that no comparable country had a small business exemption. I think you've been asked by Senator Scarr if you're aware of any other jurisdiction that has a small business exemption. But I'll just ask again, are either of your organisations aware of another country which has a small business exemption for privacy protections?
Yeah, my understanding is not necessarily an entire exemption, but certainly exemptions exist, I think, within GDPR for businesses with less than 250 employees, for example, from documenting data processing efforts, unless other certain specific criteria apply. So I think what we are saying is, the current 13 principles are very broadly drafted. And I think for a small business, particularly a sole trader, without guidance as to what they mean and what they can practically do to comply, and we haven't got the figures as to how much compliance with all 13 would cost. What does this look like for small businesses? And our understanding is it's cost prohibitive to comply with such a broad brush of Australian privacy principles without assistance and guidance. Our recommendation would be to focus on the APPs where everybody really is in agreement about data breaches and nobody wanting to lose data. How can we, as a first step, really focus on the principles which are going to have the most impact on those community expectations to avoid data breaches?
Well, I think to put it in context, the exclusions from protections under the GDPR in Europe are exclusions for rights and obligations that don't exist under Australian law and aren't actually being implemented under this law. Those exclusions for entities that have less than 250 employees only relate to rights and obligations that aren't found in this bill, aren't found in the Privacy Act. That's the case, isn't it?
So I would just say that a lot of the privacy, this may add more complexity to the situation in the terms of that a lot of the privacy principles are really based on principles that were originally under the Data Protection Directive 1998. So to that extent, are we comparing apples with apples? It's an interesting question.
Small business is such an important part of our economy. I think you probably have the figures to hand. What proportion of businesses are actually small business in Australia?
Well, I know, for example, we've got 1.1 million sole traders. I probably have to go and get some more nuanced data for you, because we've got sole traders, we've got micro businesses which are under the $2 million. That's the ATO definition. Obviously, there's many definitions of small business, which is probably part of the problem with the complexity. And then the ATO, would define small businesses as under $10 million. So. Again, it's a very broad church, and that probably is part of the complexity, then really trying to understand industry by industry and the small business sector, what compliance looks like for each of those cohorts.
Well, I mean, even if you took the $3 million turnover test, it's probably still, in terms of sheer numbers, the majority of businesses in the country, isn't it, Ms. Sutton?
Yes, it probably, absolutely. I think small business, we would say generally under 10 million is like 97% of Australian businesses, yes.
So for many Australians, having such a large part of our economy excluded from the privacy protections entirely is really problematic. And I'll give you an example. Renters who are increasingly required to provide very large amounts of personal information simply to get somewhere to live are deeply troubled that many real estate agents are not required to protect their privacy. You can understand that anxiety, can't you, for people when they hand over such a large amount of personal information?
Completely, and I think as well we appreciate that small businesses many of them are individuals themselves, and I think some of the data would, many small businesses themselves are obviously as individuals worried about their data. I mean, I think it's very much in the discourse across the Australian public generally, and that's the statistic is that 74% of the Australian public have cited data breaches as their main concern. That's why we at COSBOA are working and rolling out a cyber wardens program, which there's been very significant uptake for small business, and hopefully with a new digital ID legislation that's coming out, a lot of that data now with real estate agents will be alternatives so that small businesses don't have to hold as much data. I think that's one of the key.
Well, I think I join with you in the hope that the digital ID reforms mean that small business will have to hold a lot less data, and people's online data will be better protected. But then, of course, and I'll come back to the real estate example. Real estate agents seek detailed financial records, character references, past rental records, like incredibly detailed personal information. Shouldn't that be protected by legal privacy obligations?
And what I think is interesting is that, and I think what I've been saying in my opening speech as well in our submission is we're looking for pragmatic ways of how we can scale out privacy protections across small businesses. As I said, the $3 million and above are already required to comply. And I was talking to an industry association yesterday whose members are all small businesses who handle a lot of financial information. It's in their code that they have to comply. And that industry association, in acknowledging the complexity its code of conduct is imposing on its small business members, offers a lot of support and guidance and training as an industry, regardless of members not being required by law. And that kind of model is how industry can partner to be able to, allay the concerns of the Australian public.
One other way of looking at small business being covered by the tort is that actually should be an impetus to actually lift the privacy protections that small business implements in their day-to-day business operations. So it actually is an argument in favour of roping small business in to privacy protections, because that's actually one good way that small business can put in place the measures needed to protect themselves from a potential tortious action. Do you see the logic in that, Ms. Sutton?
Well, I think we would agree with the AI group, and I think it just adds further complexity when we have, like, you know, definitions around organisations and APP entities, like sort of flowing into Schedule 1, but then Schedule 2's got completely different definitions of individuals and persons. I think it just adds to the confusion and complexity of if they're going to be housed within the same Act.
Well, if we want small business to have continued social licence, and given we operate in a highly, data-driven economy, there are some pretty good arguments, aren't there, for requiring small business to meet minimum statutory privacy obligations.
I think one thing that's very interesting as well is APP 8 in terms of, I think there's, if you pragmatically look now at how a lot of small businesses are holding data, it's probably through third-party overseas companies who facilitate, booking engines, payment services. And at the moment, I was talking to one small business this morning that says, when I use these, I'm not sure if they're certified for the purposes of Australian privacy law. So to the extent, how much are we laying on small business who, when the practical reality is a lot of them are probably using larger platforms. So are there ways there in which we can ensure that small businesses are compliant through their relationships with much larger tech businesses based overseas?
Well, one element in this bill should give you some comfort, because it would actually provide for a list of comparable jurisdictions that have similar privacy protections that small business could rely upon. So it's actually a positive.
That would be a positive, yes.
Thanks, Senator Shoebridge. We have a very short amount of time left, and I just have one quick question for Ms McGrath. It's just on this issue of employee records again, if I may. As I understand it, can I just check? So you're seeking exemption from the tort for employee records?
Yes, that's correct.
And is that for all businesses or just small businesses?
All businesses.
Right. So the tort is a tort of serious invasion of privacy, and it only applies where the defendant has invaded the plaintiff's privacy by either intruding on the plaintiff's seclusion or misusing that information. Wait 1 second, sorry. It also has to be, another element of the tort is that the invasion of privacy has to be intentional or reckless, and that the invasion was serious. So what circumstance do you think that bar is too high for employee records?
So perhaps it's a clarification of definitions, but in terms of seclusion, if we look at work from home practices, perhaps an employee's family member could expect that they are in their family home in seclusion, but the work is inserting itself into the home environment.
But you want an exemption from all employee records. So every piece of information about employee, you want an exemption from the serious misuse, intentional and reckless breach of privacy. Do you see how I guess we're struggling to understand the circumstances in which that bar would be, when it would even apply to an employee record.
Senator Green, may I add to that, if I may?
Yeah, sure.
So I don't think we're prescribing exactly what the exemption would be, and it may very well be, we would say, as broad as that, but adaptable depending, with due regard to the elements of this action. Senator Scarr has already asked us to provide some case studies, so perhaps that might provide some more information in this respect?
Yeah. Look, I think that's fine. I think it's really important in that information that you provide to indicate to the committee where it relates to the intentional, reckless or serious invasion of privacy, because those are elements of the tort. They have to be made out for it to apply. And I struggle to see where that would be, where an exemption would be necessary for employee information, whether it's someone who works for the company or someone, in the case that you've just given, someone who doesn't work for the company, why those two situations would be different.
Senator Green, just probably a little bit aside from that, but I think it's important to remember that the statutory tort is going to be developed through case law. So it's not the case that employers will actually know the boundaries of this. This will be developed through case law and through having to go to court and significant legal costs, time and resources. So just, of course, I'm not disagreeing in any way, but I think that needs to be considered in the context of this. And as Louise said, we'll be providing some more information.
Okay, that would be good. It seems to me it would be very hard to accidentally invade on someone's privacy, intentionally or recklessly or in a serious way, that would require an exemption. The exemptions that are in there at the moment relate to information that would be required. So I guess maybe one thing you could take on notice is drawing us to the relationship between the exemptions that are already in there in the legislation and the one that you're seeking.
Senator Green, I think
we're talking about intelligence agencies and enforcement bodies and the police who have a very serious job.
Okay. I presume, Senator Green, you weren't talking about the defences then?
No, the defences and the exemptions.
Yeah.
That's what you're seeking, isn't it? An exemption.
Yeah, that's correct.
Okay. All right. Thank you. We're just ticking over time, so I might have put some questions on notice to the other witness, and then we can get you to come back to us on a couple of those things. Maybe if you could just take this on notice, the Australian Industry Group, sorry to put you on the spot, but not let you answer. We did get some COSBO. We did get some research earlier in the hearing from AED that 79% of small businesses believe that companies should be doing more to protect personal information, and that 67% of small businesses would feel more comfortable about AI if there were stronger regulatory safeguards around it. I'm keen to know what your members think about those developments in technology and the need to protect not just their customers and clients, but also those businesses themselves, because they would in turn be clients and customers of bigger companies. So that would be helpful to understand. But I'll let you take that on notice given the time.
No, fantastic. I've read the report and there's some really, really helpful data in there generally, which we'll be taking a look at. But I'll take that on notice and we'll come back to you. Thank you so much.
Thank you, and thank you for both of your organisations for your time and for your submissions. The committee is going to break now for lunch and come back at 2:30 Canberra time. We'll resume the hearing there. I think all of our witnesses are online now. Thank you very much for being with us today. I now welcome via video conference representatives from the Consumer Policy Research Centre and Choice. Thanks for taking the time to speak with the committee. Information on parliamentary privilege and the protection of witnesses and evidence has been provided to you and is available from the Secretariat. For the Hansard record, can you each please state your full name, the capacity in which you appear today?
Hello, I am Chandani Gupta. I am Chandani Gupta, representing Consumer Policy Research Centre. I'm the Deputy CEO and Digital Policy Director.
Good afternoon, Senators. Rosie Thomas, Director of Campaigns at Choice.
Hi, Rafi Alam, Senior Campaigns and Policy Advisor at Choice.
Fantastic. Now, before we go to questions, would either of you like to make a brief opening statement before we go to questions? Great.
Thank you, Chair. I'm representing Consumer Policy Research Centre. We are an independent think tank dedicated to exploring consumer issues to achieve fairer markets for all Australians. While we welcome the movement on Australia's privacy reforms via this first initial tranche, crucial gaps remain in adequately protecting Australians for today's digital economy. The balance of power and the balance of accountability both need a recalibration, and it starts by ensuring that we no longer disproportionately place on individuals the burden of their own safety online. Today, I'm here on behalf of CPRC with a focus on two issues. The major mismatch between the Australian experience versus people overseas, and the privacy protections that must be urgently prioritised. On the first issue, our privacy protections are currently built on a model of notification and consent, and very much on a take-it-or-leave-it approach from businesses. This means we are often sharing more of our data with businesses than ever before. Our consumer research has found that only 7% of Australians feel companies give them real choices to protect their privacy online. While businesses may course correct their actions overseas due to stronger privacy obligations, unless they are obligated in Australia, they will not change their business practices out of sheer goodwill. Basically, we have a situation where Australians are using the same service provided by the same platform, but someone in Copenhagen has more protections than someone sitting in Canberra. I'm currently overseas, and I'm seeing websites and apps I use every single day in Australia that have never asked me of my choice, so diligently asking me whether I would like the information to be collected and shared about me for marketing or for third-party purposes, with many offering a clear option to reject all. This confirms our research from July 2024, where we found that Australians would need to spend an average of 30 minutes daily to fully adjust privacy settings on websites and apps rather than accept the company default. We also found that Australians need to spend an average of 2 minutes per website or app managing their privacy versus our participant in Europe who just spent an average of 3.1 seconds. I'm the same person, but suddenly as an Australian in Europe, my data is treated with more care and respect. Australians deserve far better, and this will only happen if the law reform puts Australians first. We urge the federal government and we urge the Senate, this committee, to recommend that the federal government commit to a clear timeline to close crucial gaps in Australia's privacy protections, and recommend that the committee in particular calls for modernising the definition of personal information so it covers information obtained from any source and by any means, introducing a fair and reasonable obligation on collecting, sharing and using consumer data, removing the small business exemption, empowering the regulator to swiftly ban or restrict harmful practices that cause direct and clear consumer harms. Australians deserve to experience the benefits of the digital economy and all the amazing aspects it offers in an ecosystem that is fair, safe and meaningful today and in the future. Thank you so much for the opportunity to attend this hearing today.
Thanks very much. And from Choice, do you have an opening statement, Ms. Thomas?
Yeah, thank you for inviting Choice to address the committee. Australian consumers are deeply concerned about their privacy. In December last year in our polling, we found that 65% of consumers did not trust businesses to use their data responsibly and in their best interest. 78% were concerned about businesses selling their personal information to data brokers, and 70% were concerned about their data being used in automated decision-making. Sadly, this widespread lack of trust in businesses is warranted. Across many sectors, businesses have failed to demonstrate their ability to self-regulate and protect personal information, and consumers have paid the price. Consumers know all too well of data breaches that expose the lives of millions of Australians, of mass data scraping to train AI systems, and how our online behaviour is tracked by advertisers. Members of this committee may have seen our investigations exposing the use of facial recognition technology in retail and stadiums, and more recently into smart cars collecting data on driving behaviour, location, and even voice and visual data. Choice has welcomed the government's bill as a first step in reforming the Privacy Act. In particular, we support increasing the powers of the OAIC with greater enforcement and penalty mechanisms. Our polling found that 88% of consumers support the regulator being able to fine businesses. We also support greater transparency on the use of automated decision-making and a statutory tort for serious invasions of privacy. Therefore, we believe the committee should recommend the passage of the bill and suggest amendments to the bill that will strengthen the reforms, namely, 1, expanding the penalty regime to consider the value of the benefit or business turnover when interference is not considered serious, to provide sufficient deterrence to large entities. Number 2, higher infringement notice penalties for listed corporations in line with the infringement notice powers of the ACCC. And 3, requiring businesses to explain how they use personal information in substantially automated decisions. However, despite our support for passage of the bill, we are disappointed these amendments do not live up to the expectations set by the Privacy Act review. After years of consultation, we believe this was a missed opportunity to comprehensively overhaul our privacy laws to protect consumers. Specifically, we believe that government must prioritise the following reforms that were endorsed in the government response to the Privacy Act review last year, including a fair and reasonable use test. 77% of people agreed in our polling that businesses should only be allowed to use their personal information in ways that are fair to them. Number 2, removal of the small business exemption. 83% of people agreed that small businesses should be required to follow privacy laws. And number 3, which is expanding the definition of personal information to capture all modern types of information that can identify someone. We understand that the government wishes to pursue further targeted consultation on a second tranche of reforms. However, we ask the committee to recommend the government set a clear timeline for consultation and introduction of legislation, and to provide consumers certainty that privacy needs will be addressed after many years of waiting. Thank you for allowing us the opportunity to speak to our submission.
Thank you very much for those opening statements. We'll go to questions. Senator Scarr, you have the call.
Thank you, Chair. If I can ask questions first of the CPRC, and you helpfully provide some interesting statistics there regarding the difference between Australia and Europe in terms of how much time is required to adjust privacy settings, etc. How do these reforms respond to or address those issues in any way?
Unfortunately, I'd have to say they don't. So what you have is, yes, you've got the penalties, yes, there's a statutory tort, but in the end, there is no requirement for how data is being used by businesses. And so the current proposals that are in here in the first tranche only move us slightly towards the EU EU aspect of the protections, but otherwise there are no obligations in there at the moment that say, well, this is what is expected of businesses, and this is why we are proposing that the committee recommend that especially the fair and reasonable obligation is put in. We need to be able to have very clear obligations on businesses on what they can and can't do with our data, and at the moment that's just not there.
So is that the main reason for that discrepancy? And just for the Hansard record, what I'm referring to is you're saying the submission, Australians would need to spend an average of 13 minutes daily to fully adjust privacy settings on websites and apps rather than accept the company default. Australians need to spend an average of 2 minutes per website app managing their privacy versus a participant in Europe who just spent an average of 3.1 seconds per website app.
Yes, that's correct.
So it's the
fair... That is correct.
Okay. All right.
The fair and reasonable will definitely move us much closer to that, much closer to the 3.1 second, that is for sure. But it is only part of the ecosystem. When you see the way in the EU how clear the guidelines are in terms of when choice is asked, it's asked with a real clear manner whether you accept or reject. It's not perfect because there's obviously no law is perfect, but it certainly it puts a choice there. So it's the same websites. It's quite shocking when I've seen websites who have never asked me before are asking me now. And it's a clear, do I accept or do I reject? It's a clear choice. And I think at the moment we just don't have that.
Okay. Did Choice have anything to add in that regard?
Yeah. Sorry. Do you want to go ahead, Rosie?
No, you go ahead.
Only that, we agree with Channy. And just even recently, when we did our investigations into smart cars, for example, the number of consumers who just were completely unaware of what was happening in those privacy policies was concerning, and that car companies were withholding some of this information when they advertise their products. But also on the flip side, as someone who went through the privacy policies, there was still a very big lack of clarity. And we think that a fair and reasonable use test will set a really strong baseline for the kind of behaviour that companies in general can do with personal information, and we think that will help Australians in the long run when it comes to consenting.
Okay. If I can ask Choice, you raise the removal of the small business exemption, and CPRC also touches on that. You specifically refer to real estate firms. Has there been any research done on what the issues are specifically in relation to real estate firms? Why do you raise real estate firms? Why are real estate firms being mentioned?
So we've done some specific research looking at what we call the rent tech sector. So that's third-party rental applications. I might hand to Rafi to speak to that because he was the author of that report. So, but that's the research that Choice has done in this space. But broadly, there's a large number of businesses there collecting large amounts of data. We can't definitively say whether or not they're small businesses, but that is part of the challenge from a consumer's perspective. They have no way to know whether the business that is collecting large amounts of their personal data for rental applications or other reasons is subject to the Privacy Act or not. And so, it is an example of a sector where it's likely that the Privacy Act is not always applying, yet they are dealing in large amounts of personal information. Rafi, is there anything further you'd like to add there?
Yeah, just that the motivation for looking at RentTech was because of the number of issues that consumers and renters face when they're applying for a rental property. Often very, very sensitive information that they are concerned about potentially going into a leak or being used against them. So we also looked at, for instance, the use of automated decision-making on certain RentTech platforms to deliver what's often called like a renter score that can be determined for your eligibility or appropriateness for a rental property. So that's one reason. And yeah, then an amount of financial information that you often have to give over as well is deeply concerning. So we looked at that for that reason. When it comes to real estate firms themselves, there is a bit of a lack of clarity about whether or not individual franchises of real estate businesses have the same obligations to the Privacy Act as their parent company. But of course, there are also smaller real estate firms that might not reach that $3 million threshold to be covered by the Privacy Act. And like Rosie said, renters may be none the wiser about whether or not that firm has to follow privacy obligations and another one doesn't.
So is the issue one in relation to inappropriate use of personal information, or I'm trying to understand practically what is happening at the moment, what's the mischief, if you like, that's happening at the moment that you need to see addressed. Obviously, if someone's applying to be a tenant in relation to a property, there are going to be requests for references. The agent might be concerned to know what their income is, to see if they've got capacity to meet the rent. Where's the line being crossed that concerns choice in this regard?
I will say that one reason of concern is that, particularly using RentTech platforms, the amount of data that can be collected and stored for a lengthy amount of time does put people more at risk of data breaches. And our research also found that many renters across the country were being pressured to use these platforms. So that's one reason. Also, the development and constant advancement of automated decision-making puts people at potential risk of that data being used for discriminatory purposes, or maybe not for discriminatory purposes, but maybe incidentally discriminatory outcomes. Based on certain characteristics that could be maybe used for, that could maybe end up in an equation that discriminates against people from a socioeconomic background or from different racial groups, things like that. So that's another concern. Also, like our report did look into the concerns around how this data can be monetized in the long run for targeted advertising, for instance, because some of these rental platforms may have connections with advertising platforms.
And just my last question, has the Privacy Commissioner done any work in this regard in terms of the context that you're talking about, and including RentTech?
We believe they might be looking at the sector, but beyond that, that might be a good question to ask them, I think. If I can just add one further point, in terms of the mischief here, some of it is about the volume of data being collected. We've heard examples of consumers having to upload pictures of their children and pets into these platforms, and you can't help but wonder why that's relevant to the decision about whether or not to approve someone's rental application, and then having to hand very sensitive data like that to a third-party rental platform without knowing where it might end up and what it might be used for is naturally very concerning to consumers.
Okay, thank you. Thank you, Chair.
Thanks, Senator Shoebridge. You have the call.
Thanks, Chair, and thanks to both of your organisations for the work you've been doing. You've both been producing some really important research. To go to CPRC first, your analysis of how long it would take Australians on average to actually adjust and protect their privacy settings was pretty extraordinary. can you just shed some light on the difference in life if you're Australian to if you're, say, French, protecting your online privacy?
Definitely. Basically, the key difference is how choice is presented to us in Australia versus how choice is presented, say, to someone who is residing in France. So usually in Europe, now that they have the GDPR, whenever you visit a website, a cookie banner comes up and it says, would you like to accept or reject for the company to collect and share information about you for marketing purposes, for third-party purposes, or for others, and you can accept or reject. In some cases, it's a clear to, or it's a reject all, or manage your preferences, and you can manage very quickly. You can go into a second screen and you can quickly turn off anything that is non-essential. So non-essential for the website to be running and for the information to be presented to you. But here in Australia, often that banner barely comes up. Some do it, but it's very few. In fact, in our sweep, I don't think we saw many who had. You either had the no choice, so a banner would just come up saying, by using our website, you are accepting our terms and conditions. And then if you were to go in the terms and conditions, it can have where information is being shared with third parties, where there's cookies being added to track your purchases or your behavior online. So that's all. You have no choice. But because our model is built on notification, well, they've notified. They have obligated to what's expected of them. There are some websites and apps that will offer you to manage your privacy settings, but you have to go in and you almost have to become a privacy expert to go through multiple sections of the website in the settings, often deeply buried in the website or the app, to then turn off, because everything has been turned on by default in most cases. So you have to go in one by one, turning everything off, such as online tracking, such as marketing information being collected about for marketing purposes, targeted advertising, all of that you have to do yourself. So instead of you being able to go, no, reject all, let me get on with my life and my day and using the website, you've got this, you have to go through that. And I would say the time that we found, which was just under 2 minutes per website and app, I'd probably say that's an underestimation, because the sweep where we participated in, many of us were consumer advocates. We are very much in this particular space. We often know where to go looking for this, but that is not the case for Australians. And I think that's a really important aspect, that they should not have to be technical experts or have a PhD in privacy to be able to enjoy the benefits of the digital economy. Yeah, and the distinction between privacy protections for Australians and Europeans was made very real to me in another committee inquiry we had into artificial intelligence, where we had Meta explain that they had scraped Australians' Facebook and Instagram posts going back over a decade to feed into their large language model, but they hadn't done that in Europe. And when they were asked, well, why did you target Australia and not Europe? And they said, well, it's unlawful in Europe, but they have privacy laws. And those distinctions are very real, aren't they? They are extremely real. It really shows that it is not a matter of businesses course correcting just because they've done something in one jurisdiction, that they will apply that same business model across all jurisdictions. And I think that's really key why Australia needs protections for Australians, and it cannot rely on protections that are in Europe or the US or other parts of the world to protect Australians, because that's just not going to happen. Yeah. Could I just quickly
go to choice, obviously consent is one thing, and we've seen from the CPRC research just how problematic consent is as a protection for our privacy. Choice, I think, along with a number of other organisations, says we can't just rely upon consent. There need to be ongoing protections that you can't give away by a click of the button. Do you want to speak to those?
Yeah, I can speak to that. Thank you for the question. Choice strongly supports, for example, the fair and reasonable use test, what we often affectionately call the privacy pub test, because I think most consumers in the market expect some baseline protections around privacy from their products and services, because that's also what they expect from, say, goods and services generally under consumer law. And so we don't know why privacy should be exempt from this. Like Channy was saying, you shouldn't have to become a privacy expert in order to negotiate your privacy with a business, especially when they hold so much market power. Rose, do you want to add anything to that?
I think when we're talking about consent here, in theory, what we mean is choice, but the truth is we don't have choice in Australia. For so many of the websites and businesses we might want to use, everything is presented in a take it or leave it way. And so any concept of consent here is really you either use the product or the service or you don't. And so I think that really does highlight why this concept of consent, which is really we're talking about ticking the box, isn't really providing any meaningful protection, and we do need to introduce a baseline for businesses to meet.
And the sort of off-the-shelf safeguard is saying to businesses, well, even if you have the data and even if you have consent, you can only use it for purposes that are fair and reasonable.
That's absolutely right. And so that would then, even if you do tick the box, you have the comfort to know that it doesn't matter what that privacy policy might say, there is this baseline protection that they can't be collecting or using or sharing your data for reasons that are not fair or reasonable.
And that is particularly important where you have such a sort of dynamic online environment where people are coming up with novel ways of using data and using information that you might give a broad consent now, but perhaps in 5 years' time, that entity that sucked up your data may use it in a way you'd never conceived of. And so that ongoing constraint seems to me more important than ever.
Absolutely. I think another example that highlights this is around data breaches, where that is the holding onto of data after time, which then exposes you to that risk. So if you have that kind of ongoing fair and reasonable requirement, there will be more, businesses will be under more of an obligation to delete or not collect the data to begin with, which would then also reduce that risk as well.
Yeah. Given we're in 2024, not in sometime in the latter stages of the 20th century when the Privacy Act was first written, it is fairly remarkable that we have these reforms coming through after a decade or so of consideration, and they don't treat location data as personal information. I can't think of anything that, obviously anything that so obviously ticks the box of personal information as knowing exactly where you are in real time at any point. That have you had it explained to you at any point why the government hasn't included location data as personal information?
You raise an excellent point, Senator. We haven't specifically had anything from government of why or why not that is included or not included. However, we do believe it is those points of data, such as location data, that are very much personal to you. If you think about the fact that you are tracked across the day and your journey across a day and the different locations that you visit are very much specific to you. There is no other person probably that follows your pathway in the same way.
Yeah.
And so therefore it is very, yes,
No.
do.
And this is partly why I think it was the Human Technology Institute that said personal information should be not just information that can identify you as Ms. Gupta or, Senator Shoebridge, but also if an entity has enough information, even if they can't identify you as Ms. Gupta or Senator Shoebridge, but as a unique individual with unique traits and circumstances so as they can target you for commercial or other purposes, that should also be considered personal information, shouldn't it?
We completely agree. In fact, research we did earlier this year in partnership with UNSW, we found that companies use terms like pseudonymized information, anonymized information, de-identified information, but it is so easy to re-identify because of how unique our map is. You do not need to know who the person is. Businesses can very easily single you out. And in terms of what you said before, yes, it was important in 1988 that people didn't know that it was Miss Gupta, and that would have been enough to protect us. But it's not 1988. At that time, there had only been one data breach, which was the Morris worm. And we know now that there are multiple data breaches every year. So we are living in a very different time.
Yeah. And in actual...
Senator Shoebridge, I'll just draw your attention to the time.
Okay. But in fact, if you're a large online data broker, you could avoid any of these protections by saying, well, I'm not attaching a name to this data package. You could just not have a name attached to it, but it's, one of 7 million unique Australians that you can track and follow, and you know what their consumption patterns are, you know what their travel patterns are, and provided you don't attach a name to it, on one view, you could avoid any of the privacy protections because it doesn't meet the definition of personal information. That seems...
That's exactly right.
That seems perverse.
Which is why that is exactly right, which is why we need fair and reasonable to use tests, but we also need to modernise the definition of personal information.
Yeah. The chair is not unreasonably winding me up, so I'm going back to her.
Thanks, Senator Shoebridge. We're a little over time, but I'll just ask 2 questions. I really want to get on the record and thank you for all of your work. We'll probably go down a bit of a rabbit hole if I start asking you about how corporations are using our faces, and it might get a bit scary from there. So I'll just ask for choice to begin with. Your submission notes that support for the statutory tort for serious invasions of privacy in the bill, and that research by Choice has actually found that 85% of people believe that they should have the right to take action against a business if it breaches their privacy. I just thought I'd give you the chance to talk us through some of the context of that research and that findings.
Yeah, thanks for the question. We did national research in the middle of the year on a number of some of the key reforms that we supported in the Privacy Act review, and to try to find out what consumers felt about them. We weren't surprised that many consumers supported a statutory tort and to support the ability to sue businesses, particularly after years of data breaches and misuse and news around these issues. But I will add that one of our kind of key planks, particularly in the Privacy Act review report submission, was that we also believe that it's not enough to rely on consumers to sue businesses in order to keep businesses accountable. It might not come as a surprise that we support a lot of regulatory action, like empowered resource regulators taking that kind of action as a baseline, which is why we also supported a really strong penalty regime for the OAIC to take against misbehaving businesses.
Yeah, okay, thank you. I'm also interested in your submission. You have support for the automated decision-making proposals in the bill. Again, that could the potential of that to be problematic for consumers, but also for businesses that might not have the right policies in place or be informing their clients or their consumers about the use of automatic decision-making. Throws open a big potential for data breaches. Why do you think it's important that the Privacy Act includes specific provisions about automated decision-making, and how are we seeing this sort of play out more broadly in the community?
Yeah, once again, our polling found that most consumers supported transparency over when their information was being used in automated decision-making. One of the reasons for this is because it can have significant impacts on people's access to goods and services. For example, like in a financial service, is automated decision-making being used to set costs and premiums? And we think that consumers have a right to know when that is happening. We did research investigations into Airbnb's use of automated decision-making, Tinder's. But I think also we added that we think there should be a right to request how the information was being used, because we think that it's no good if consumers know it's being used, not how. But I mean, further to the point though, this is a baseline expectation that businesses should just say how they're using your data across the board, but that's really the bare minimum. We think that businesses should be obliged to use it in a fair and safe way, not just let consumers know how they're using it. And also additionally, we support a number of mandatory guardrails in the other consultation around AI. But yeah.
Okay, thank you. I am conscious of time, and I just did want to get your view on one of the things that's been raised throughout the hearing this morning, and that is the exemption of small businesses. Obviously, your organisations cover the range of businesses, small and big. People have heard a lot about the big data breaches from companies like Optus and those sorts of things, or those types of breaches of privacy, or the way that big companies are using our location or face recognition, things like that. But there seems to be this push to exempt small businesses. I just thought I'd get your views on that before we wrap up.
I'm happy to go first. I mean, I think it's worth noting at the outset that, Choice has always supported a sort of proportionate approach to regulation here, and that, we would be open to calibrating the obligations in a way that is proportionate to the risk, and that recognising that business might need time to transition, and so with an appropriate transition period as well, and appropriate resourcing for the OAIC to be able to help and educate business on this journey. But fundamentally, it isn't acceptable that well over 90% of the businesses in the country are not captured by the Privacy Act at the moment. I think most consumers wouldn't appreciate that, and when handing over information, they don't realise that they don't have any of the protections that the Privacy Act might provide. I think it is highlighted most pertinently in that rent tech real estate adjacent sector that we mentioned before, because not only do consumers not know whether or not a particular business they're dealing with may be a small business or not, but I think it's safe to say that all of these businesses will have at some point been a small business, because that's typically how a tech business starts, is as a small business. And so even when your business is almost entirely dealing in people's personal information, the Privacy Act doesn't apply because of your size. And so that, we think, is not aligned with what consumers would expect, and we think it's only a matter of time before we have a data breach or something affecting a large number of small businesses, which will then expose consumers to the same risks.
Okay. Well, thank you very much. I'm sorry, and thanks for the indulgence of other committee members for us to go a little bit over time, but I did want to get those answers on the record. So thank you very much for your time. Our next witnesses are in the room, I think, and ready to go. So we'll swap over quite quickly. Thank you very much for your time.
Thank you so much.
Thank you, Senators.
I now welcome Professor Barbara McDonald. Thank you for taking the time to speak with the committee today. Information on parliamentary privilege and the protection of witness and evidence has been provided to you and is available from the Secretariat. For the Hansard record, can you please state your full name and the capacity in which you appear today?
Emeritus Professor Barbara McDonald.
Thank you very much. Would you like to make a brief opening statement before we go to questions?
Yes. So first of all, I'd like to thank you very much for the invitation and opportunity to speak to the committee. It's really encouraging to the process of law reform to see this sort of detailed consideration. You know, I led the Australian Law Reform Commission inquiry, so I won't go into that, but I suppose I would just point out what a lengthy process it was over 11 months with hundreds of submissions and consultations at various stages, and also point out that the Law Reform Commission is not an advocate or an activist for one view. Where views conflict, as they do here, our job was to try and find a compromise or a solution which respects the position of all legitimate interests. So our task was to design a statutory cause of action, and our report does that in chapters 4 to 12. The other chapters actually discuss other avenues for prevention or for remedies for invasions of privacy, such as modernising our surveillance device legislation, which varies enormously around the country, considering an action for harassment. And we also extending the equitable action for breach of confidence, and we also made some recommendations about some regulatory mechanisms. We weren't given the time or the opportunity to include an exposure draft at the end of our report. So this bill is it. And of course, I don't need to tell you that wording is very important. In our view, when enacting the cause of action, apart from the fact that we were asked a lot of detail in the terms of reference, our view was it's helpful for the legislation to give as much guidance as possible as to what Parliament intends, to lessen the chance of years of costly litigation to work out what the statute means. Of course, it's not possible to itemise every circumstance where the statute may or may not apply, so it has to be drafted in somewhat general terms, but it does need to be technology and future-proof to a certain extent. I know you'll have a number of specific questions for me, and I won't repeat our submission. But again, just to point out that the level of detail in the design was in response to the terms of reference. We could have just done what British Columbia have done in Canada, which is simply to have 3 lines. It is a tort actionable without proof of damage for a person wilfully and without a claim of right to violate the privacy of another. A very simple few lines, but we felt we needed to provide more detail than that. I could go through what I consider the most contentious parts of the bill, if you'd like me to, now at this stage. Or I can go to questions if I've said enough. We could go to questions.
We are going to go to questions, if that's okay
sure.
with you. And I'm sure that those issues will be raised in the questions that senators put to you. And of course, at the end, if there's anything you wanted to add, we can do that as well. Just conscious of time today, we've got a lot to get through. Senator Scarr, do you have questions?
Always.
Wonderful. You have the call.
Thank you. And thank you, Professor, for your submission. I found it extraordinarily helpful, especially given your background in terms of the Australian Law Reform Commission inquiry. And I did admire the level of detail you went to. I found that of great assistance. Just at the outset, I just want to give you an opportunity to put on the record, especially because Senator Shoebridge called me out earlier, and I'm always sensitive to what Senator Shoebridge says. I just want to properly characterise your view with respect to the statement of the statutory tort in this bill. I went back and had a look at your first page. Effectively, is it fair to say that the bill reflects the design of a cause of action by the Australian Law Reform Commission, except in relation to the provisions made for exemptions for journalists and enforcement bodies. Is that the major departure between what the Australian Law Reform Commission proposed and the structure of the cause of action in the bill?
Yes, that's the major departure, that the exemption for journalists was added, and then a further exemption for law enforcement bodies and intelligence bodies. I should add, though, however, that I think Clause 7.3 and Clause 7.4 differ from our design. So Clause 7.3 is about the balancing exercise, and then Clause 4, well, actually, Clause 4 not particularly. There are a couple of details there, but really it's Clause 7.3, I think, which differs from our design.
And I know you deal with this in the submission. And before I go to the exemption for journalists and enforcement bodies, the public interest, the examination of public interest. In the bill, it provides an onus, if you like, and I'm not sure that's the right word in this context, to adduce evidence that there was a public interest in, and you make a comment about the use of this phrase, in the invasion of privacy, as opposed to justifying the invasion of privacy, and I think that's a point well made. But how material is the difference between what's in the bill and what the Australian Law Reform Commission was proposing? Is it of great moment, or is it a preference in drafting? How would it potentially impact on how these matters played out if there is a contested view with respect to public interest in particular? What would be the practical significance of the bill having this language as opposed to what was proposed by the Australian Law Reform Commission?
The bill's language puts an onus on defendants to adduce evidence that there's public interest, and only then must the plaintiff satisfy the court that his or her privacy interest outweighs any countervailing public interest. Yeah. In our view, privacy is such a relative matter. There are so many other interests that interact with personal privacy that we felt it should be considered in every case. And usually it may well be absolutely obvious on the facts of the case. If the plaintiff is a politician, or the plaintiff is some other director of a public company or something like that, it might be obvious on the facts that there's a public interest which arises, which needs to be counterweighed with any privacy interest. So we feel that's a really important aspect. It's not if the defendant adduces evidence, it's in any event.
And that's something presumably the jurisprudence is to the effect that the court can take judicial notice of that,
absolutely,
from the circumstances of the case. Is that correct?
Yes, absolutely. And it reflects the fact, again, in the objects of the Act, which are in Clause 1 at the moment. The objects of this schedule to establish the cause of action is to recognise that public interest in protecting privacy is balanced with other public interests, and to implement Australia's international obligations in relation to privacy. Now, international obligations, referring to the International Covenant on Civil and Political Rights, as the Australian Right to Know representatives point out, Article 17 is about privacy, but Article 19 is about freedom of speech. And we certainly had no interest in preferring one over the other. If anything, I think you can say that the way we've done the hurdle means that...
Sorry, in the
design.
Commission or in the bill?
Well...
sorry, you said the way we've done the hurdle.
Yes, in our view, the hurdle should be there all the time. If, of course, the defendant just points out, well, the claimant actually happens to be a politician or a director of a public company, it would be obvious. But if they point out, then again, this needs to be considered. To a certain extent, I think we're saying that the privacy interest must outweigh any public interest. So I think privacy advocates might say that's too heavy an onus, or not a legal onus in the sense of proof, because I think public interest essentially is a matter of judgment rather than proof, as it is in many other contexts. That it's quite difficult because we appreciate that we don't want the courts gummed up with too many actions based on taking a very personal view of things without recognising the public interest in so many different instances. The media obviously are one where they are engaged in public interest journalism as opposed to tittle-tattle. But there are many others, for example, as well. Proper administration of government, the taxation department, the banking sector, detection of fraud, and so on.
Okay. In terms of the concern that was raised by the Australians' Right to Know organisation, one of the particular concerns they had was the experience in the UK and some overseas jurisdictions was that public figures potentially will use this tort to prevent public discussion, media stories, seek interim injunctions, etc., and therefore stifle freedom of speech. How do you, and freedom of the press, how do you respond to that?
Look, I think, as has already been discussed today, a line needs to be drawn, and it is a difficult line sometimes to draw, and the courts in the United Kingdom have had to draw it. Many of the early privacy cases were cases that are now being just, routinely accepted as being invasive of privacy. Taking photographs of the children of celebrities when they're when they're going to a local cafe or something like that, revealing the case that started it all, Naomi Campbell coming out of a Narcotics Anonymous meeting. Even Naomi Campbell was entitled to have some privacy as regards, seeking help for her addiction. That was what started it all. But since then, there are a lot of cases involving, footballers' affairs and things like that, people's sexuality issues. I think these have now been accepted as being intrusive. The difficult ones, I think, which have been pointed out by the Right to Know, the difficult ones are the ones like the Cliff Richard case, the Bloomberg case, where the media were revealing the identity of someone who was subject to law enforcement inquiries. Now, this is quite difficult. Obviously, we have sub judice contempt, which takes effect to protect the proper administration of justice from trial by media or trial outside, to infect the jury. So it is a difficult issue. But it wasn't just the people themselves who were interested in having their identity kept secret. Law enforcement bodies don't necessarily want all their inquiries revealed to the world. It can compromise the inquiry or the investigation, and it can certainly lead to trial by media. And I think we've had a few examples of that in Australia. So I think that's a difficult one. Okay. As to whether or not the media rightly feel aggrieved in the United Kingdom, I've asked that question over there, and the answer is yes and no. Obviously for some it goes too far, but I think quite rightly we haven't had phone hacking here. But, we have had some situations here where I think the media have gone too far and strayed from their proper role of public interest journalism. For example, showing that photographs of a young radio personality checking herself into a mental health facility, or outing the sexuality of somebody, well-known person, before she was ready, and so on. There have been situations. I'm not saying they're common, but I'm not saying they're unknown.
And how do you address the situation that could arise where there is something that objectively you'd say, if you'd gone through the whole process provided in the bill, you'd get to an ultimate outcome that the information was in the public interest and should be disclosed, but someone who's the subject of that reporting uses the tort to try and frustrate, to delay, impose costs, such that actually going through that process and imposing those costs on a media outlet ultimately means that a media outlet will be gun-shy about publishing something or proceeding with the story, which is the theoretical rights and the law is one thing. The practical decisions people make, given they may be the subject of legal proceedings and I think a lengthy court process is another.
Yes. Obviously it's a very serious issue and a risk for our society to have a workable media. I don't really buy the argument that we should allow the media to continue to seriously invade people's privacy where they have a reasonable expectation of privacy in certain ways so that they can stay in business. I mean, the Clause 9 is about injunctions, and we have picked up there from Section 12 of the English Human Rights Act that the court may grant an injunction if the invasion of privacy involves publishing information that relates to the plaintiff. The court must have particular regard to the public interest in the publication of that information when considering whether to grant the injunction. So this is picked up from Section 12, subsection 4, I think, of the English Human Rights Act, which is intended to give effect to the human rights obligations under the European Convention, and there's no reason why we shouldn't have similar protections for freedom of speech under Article 19. I mean, in defamation cases, it's very difficult to get an injunction under the old rules. Bonnard and Perryman and ABC and O'Neill, it's very difficult to get an injunction, and the courts tend to say, no, publish and then pay the damages. We don't want people being able to use a side way to protect reputations and ignore those protections of freedom of speech that have been developed in defamation cases to protect reputations by using privacy. But the two issues are different. Can
I ask you, I'm sorry, I'm just going to backtrack a little bit, but do you know why there's the departure in Clause 7.3 from what the Australian Law Reform Commission put forward?
No.
Are you aware of any reasoning that underlaid the change in approach in terms of wording?
No,
Okay.
I'm not aware of it.
Okay.
I mean, I think, as we've said in our submission, we feel the wording is quite confusing and rather misconceived, I must say, because I don't think there really is a public interest in invading privacy. I think
you made that point very well.
Yeah.
Okay. And then in relation to if we can move to the journalist exemption, I can't remember if you were here when I put the first paragraph of your submission to Australians' Right to Know. What's the alternative to this exemption? Is it going back and boosting the wording around freedom of the media under 7.4 and dealing with it under that guise, as opposed to having an exemption?
Look, it is difficult. It's very much a policy issue, I think, for the Parliament. But it seems to me that it's that it, at the very least, the exemption should have some limitations on it. At the moment, it's absolute. The exemption applies even where the relevant parties committed a crime in invading someone's privacy. Now, they will answer, but we're liable for the crime.
Correct.
But
that's what they said.
Yes, that's what they said. But that's no help for the victim. The victim isn't able to take action. The victim relies on the law enforcement authorities being interested in pursuing that. There's no recompense for the victim. We could, for example, after every crime, every criminal provision, put in a provision that the court may, on application, provide compensation. For example, for breach of the Surveillance Devices Act or the Telecommunications Act and so on. We could give courts the power to grant compensation for that, and that would fill some of the gaps that we have, rather than this wholesale new tort.
And you've got a similar, you raised, as I understand, a similar concern with respect to the exemption for enforcement bodies, that there's no limit on it.
Yeah, that also is we didn't feel that was needed. I think in our report we do discuss this in exemptions, in the chapter on exemptions. We didn't feel that was needed because we've got the lawful authority defence, and also there can be no reasonable expectation of privacy for someone where the law enforcement bodies are lawfully pursuing their investigations. I mean, obviously we want our law enforcement bodies to investigate the commission of crimes and so on. That's what they're there for. So it may be that there's firstly no reasonable expectation of privacy, and secondly that the lawful authority of defence would apply. So I'm not really sure what the point of it is, other than perhaps they feel there's some ancillary conduct. But if you take a case like Smethurst and Australian Federal Police, which went to the High Court a couple of years ago, there a journalist's home was raided under an invalid warrant by the Australian Federal Police, who then seized data from her phone and put it onto their own USB stick, and then refused to give it back. And in the end, she couldn't get it back. She couldn't get a mandatory injunction for it to come back. And the High Court stated many times in their judgments, majority and minority, that she had not pleaded an invasion of privacy, and that was stressed many times. It would seem to us that, either the police have lawful authority to do what they did or not, and if they don't, then it seems to me that they should be subject to an invasion of privacy. On the other hand, of course, we don't want the police being constantly sued for any sort of trivial, perhaps trivial breach. So perhaps, it's to... It's to remedy that.
Just my last question, and before I ask that, could I ask you to take on notice, if you're able to, I don't want to impose, because we do have a short period of time, but it'd be very helpful from my perspective to get your response to the Australians' Right to Know submission, and also the Law Council of Australia submission, which just came in today.
Oh, okay.
To the extent that you've got any comment, I'm not looking for war and peace, but it would just be very helpful from my perspective to get the benefit of your expertise in terms of their submissions. And I did ask Australians' Right to Know to give their comments on your submission, so I believe in the principle of reciprocity. But my last question then is in relation to this issue of the tort, as it's proposed in the bill, deals with intentional or reckless behaviour, not negligence and not strict liability. So what do we need to be aware of, and this is touched upon in your submission, in terms of moving the definition from intentional or reckless to, say, expanding it to negligence? It's not just as simple as looking at that clause, is it? You need to consider the ramifications running through the whole framework of the
the design needs to be taken as a whole, and particularly the point that it's actual without proof of actual damage, as that is known in the law. As you know, actual damage means personal injury, psychiatric illness, property damage or economic loss. The law traditionally does not treat emotional distress as damage for the purposes of any negligence action. This was a contentious issue as to whether we should extend it to negligence. In our view, looking at what has happened in other jurisdictions, the most egregious forms of invasions of privacy have been deliberate. So, in fact, in England, a judge from there last night was just saying, well, he feels it's really rather strict liability in England, but I don't think it's been tested in England as to whether it would apply to a negligent breach. And to a certain extent, I'm sorry, it's getting a bit legally technical, but the tort in England derives from the equitable action for breach of confidence, which is strict liability because it was subject to an obligation of confidence. You needed to have knowledge of the confidentiality, but that was it. And if it's breached, it's breached. So certainly if we extended it to strict liability, it would be extremely onerous, I think, on a lot of people. It would lead people into liability when, clearly they hadn't intended to do what was done. Human error might lead to liability in a way that's not too blameworthy. Extending it to negligence, obviously, is an aspect. I note that in New Zealand, in Canada, in the Canadian, both common law and statutory provisions, it's limited to willful or deliberate conduct. And extending it to negligence without requiring proof of actual damage really flies in the face of negligence law generally.
Okay. Can I just quickly ask the difference between negligence and recklessness in this context?
Yes. Look, tort normally doesn't really have that gradation. It's more familiar to the criminal law to have those gradations. But I suppose we felt that a high degree of recklessness or recklessness may be where somebody is aware that what they're doing may invade privacy, but they really don't care. Okay. They advert to the fact that there's a real risk of invasion of privacy, but they don't care.
Indifferent to it.
Yes, they're indifferent to it. Whereas negligence can arise where somebody just didn't turn their mind to it at all, and they should have, but they didn't.
Understood. Yeah. Okay, thank you very much, Professor.
Thanks, Senator Scarr. Senator Shoebridge.
Thanks, Chair, and thanks, Professor, for your continuing engagement 10 years on.
Yes, that's right.
You really are here for the long run.
Well, as it's turned out.
Yeah. And we're grateful for it and for your continued engagement. I think you discussed with Senator Scarr that you broadly support the drafting, but it's really it's subsection 7.3 and 7.4 where you take issue. Is that a...
Yes.
Yep.
Okay.
So, and subsection 7.3 says if the defendant adduces evidence that there was a public interest in the invasion of privacy, the plaintiff must satisfy the court that the public interest was outweighed by the public interest in protecting the plaintiff's privacy. That's where, in your opinion, it starts to go astray, isn't it?
I just don't think it's well worded.
Yes, partly because this isn't just, it's not just an evidentiary battle. Public interest is often considered not just as fact, but as a question of law. Do you want to describe that?
Well, to us it's a matter of judgment as to whether something is in the public interest. I don't think you can prove that it's in the public... I mean, how can you prove that something's in the public interest? To reveal somebody's residential address or something like that. I think it would be very... we couldn't see how it could be a matter of proof on the balance of probabilities that more probably than not it was in the public interest. There are other contexts in which public interest is seen as a matter for judgment. For example, in sub judice contempt, where the court is considering whether the media have published information which would have a tendency or a likelihood of interfering with a fair trial, one of the issues, will be whether or not there's sufficient public interest in the revelation of the material to outweigh any risk. So it's a judgment which the court brings rather than...
And in that case, if it was about perhaps a scandalous political development, there may be a public interest in the broader community having an understanding of what the political scandal is. But how do you produce evidence of that? Do you knock on the doors of a representative group of the public and have them say that they actually found it helpful? I mean...
Yes. Look, this was something on which we had a lot of toing and froing, I have to say, in our final recommendations. But I think there was great concern, particularly amongst privacy advocates, that too much of a burden was being put on claimants or plaintiffs, and that the defendants could just sort of sit back and leave it to the plaintiffs to show everything about their case. And, of course, remembering that this hurdle of public interest is instead of a defence of public interest. So, it's something which obviously we felt needed to be brought right up front. And it'd be quite appropriate that if there are facts which ought to be brought to the attention of the court, and if the plaintiff hasn't done so, then the defendant may bring those to the court. I mean, perhaps that's pretty obvious saying that anyway, but it's just recognising that the defendant doesn't have to, it may not need to. It may be blindingly obvious that this is a matter of legitimate public interest.
And And in your recommendation, you set it out at the bottom of page 3 and the top of page 4, the difference between your recommendation and what we find in the bill.
Yeah.
But rather than me try and boulderise it, did you want to articulate the differences?
Yes, our suggested compromise, which of course goes back to the ALRC recommendation at the bottom of page 4 of our inquiry, was the court may only determine that the plaintiff has a cause of action if the court is satisfied that the public interest in the plaintiff's privacy outweighs any countervailing public interest. A defendant may adduce evidence that there is a countervailing public interest that outweighs the plaintiff's interest in privacy. So we want to put this up front because we don't think it should be like a defamation case, where in a defamation case the plaintiff proves that they've been defamed. That's it. They're entitled to a remedy, although now there is a serious harm requirement, which has modified that importantly. But they're entitled, they can say, I'm entitled to success unless the defendant, on the balance of probabilities, can prove a defence. In our design, the court must consider any countervailing public interest up front before the plaintiff can go ahead or can succeed.
The plaintiff has, this is probably a term that creates more confusion than clarity, but has the persuasive burden, if you like. The plaintiff has to persuade the court that the public interest in their privacy outweighs whatever countervailing public interest the defence has presented, and the defence can put evidence of that countervailing public interest before the court.
We don't say that the plaintiff must persuade the court. We say that the plaintiff only has a cause of action if the court is satisfied. So both parties will have to use persuasion to the court as to whether or not the public interest outweighs the privacy interest.
So you say at the top of page 4, the Act should also provide the plaintiff has the legal onus to satisfy the court that the public interest in privacy...
Okay, so perhaps I...
and I think it should read outweighs any... You see that the Act should also provide that the plaintiff has the legal onus to satisfy the court that the public interest...
Sorry, I've lost you where I've said that.
Just check up on this is your submission. Bottom of page 3, there's a table in mine.
Yeah, that's the clause of the bill, but our suggested clause is at the bottom of page 4.
So I have a table which on the left-hand side has ALRC recommendation.
Yes. Oh, I see.
And on the right-hand side has clause 7.3 of the bill. And that table goes from the bottom of page 3 to the top of page 4. And on the top of page 4,
oh yes, I see.
ALRC recommendation, it says
the legal onus to satisfy the court that the public interest that should be outweighs any countervailing public interest. Yes, you're quite right. So in fact, our compromise is not as strong as that. We're leaving it to the court.
Yeah. So but
partly because I think the whole issue of onus is murky as to whether you can have an onus about something which is a judgment.
But then we have this really unusual provision in the bill, now going back to the 2024 bill. We go to subsection 4, which I think in talking about the evidence that can be presented for the purpose of the test in sub 3, gives a non-exhaustive list of the types of evidence that can be presented. But you question what is the purpose of subsection 4 in your submission?
I more question subsection 3, I have to say, because in subsection 4, the differences really are more...
I'm just going off your submission, and again, it's the top of page 5.
Yep.
You say clause 7.4 is also with respect not appropriately drafted. While it sets out a non-exhaustive list of matters of public interest, it does not state in terms that these may be taken into account by the court when satisfying
yes, that's
itself
right.
under clause 7.3.
Yes, that's right. Yes,
Yeah.
that's right. Because if we redraft clause 3,
Yeah.
then I think subclause 4 needs to be redrafted as well.
You say it relies on the inappropriate drafting of clause 7.3.
Yes, that's right.
Yeah.
On the if part, yes. So if clause 7.3, if clause 7.3 is redrafted, then so should clause 4, clause 7.4.
Yeah, it should. Clause 7.4 might be more appropriately drafted as saying these are the kinds of public interest, a non-exhaustive list of the kinds of public interests the court can take into account when considering the test in 7.3.
Yes.
And you say that one of the things that should be included that has been excluded is also artistic expression.
Is also
artistic expression.
Yes, that's been excluded.
Can you see any explanation for excluding artistic expression?
No. No, there is no explanation.
Yeah, and just to be clear, a live example of that in terms of where artistic expression has been sort of a live political context is a portrait of a well-known WA mining magnate where Gina Reinhardt took great exception to a portrait and suggested it was, inappropriate and unflattering. But the question of artistic expression can often be a quite live political and or legal debate, can't it?
Well, we certainly thought that artistic expression needed to be itemised as an important aspect of freedom of speech and freedom of expression in many different contexts. I mean, plays, films, novels, books, and so on. There may be cases where there's some sort of intrusion, but it's something that has to be balanced. I mean, I suppose the television program The Crown is an example of artistic expression that delves into private lives.
To be even more topical. But you have a kind of simple redrafting proposal, and I'm going here from the bottom of page 4 of your submission, that table.
Yeah.
You say a redrafting of clause 7.3 would be the court may only determine that the plaintiff has a cause of action if the court is satisfied that the public interest in the plaintiff's privacy outweighs any countervailing public interest.
Yeah.
And then probably as a separate element, a defendant may adduce evidence that there is a countervailing public interest that outweighs the plaintiff's interest in privacy.
Yes.
That would be a clear step through for a court, wouldn't it?
I think so.
But the current drafting says if the defendant adduces evidence there was a public interest, then the plaintiff must satisfy the court.
Mm.
And that seems to sort of it starts backwards. Is part of your concern about that? It doesn't clearly state that the court must be satisfied of a positive public interest as a kind of prima facie element in the
course of action. Yeah.
And there may well be circumstances where a defendant doesn't necessarily adduce evidence, but makes a submission based upon
the evidence that's before the court,
based upon perhaps the plaintiff's own evidence.
Yes.
And in this case,
yes,
the defendant may choose not to put anything into evidence, but may say, well, on the plaintiff's case,
yes,
there's clearly a public interest because they have tendered the publication.
Yes.
And the publication may prove a public interest. But on this drafting,
you couldn't
get started.
That's right. Now, I mean, there is an argument that under reasonable expectation of privacy, that public interest may have an administration of government and all those sorts of things, law enforcement, that it has a role in determining whether somebody has a reasonable expectation of privacy in the first place. However, on this current drafting, I think it's lacking that protection for public interest.
It's also not clear if the defendant may put certain evidence in about one aspect of the public interest, but it's unclear from my reading of clause 7.3 if the defendant could then rely upon other submissions or other elements of public interest that they hadn't put evidence in. On one reading of 7.3, they couldn't.
Yes, that's right.
That seems perverse as well.
I think it should be a matter for argument before the court, and
if you're talking about something as nebulous as public interest, limiting it only to what there's express evidence of, rather than the ability of a court to infer or form a judgment on, potentially makes it a very, very low threshold for a plaintiff to overcome, because unless the defendant can produce persuasive evidence of each element of the public interest, the defendant may have no argument.
That's right. I think it's an example of how, words really matter in legislation, and perhaps the intent was to put what the ALRC had recommended into other words, but I don't think it's
your suggestion
worked.
Is reform 7.3, rework 7.3 is the way that you've articulated at the bottom of page 4, top of page 5, and then amend 7.4 to be an inclusive, a non-exclusive list of the types of matters of public interest the court could take into account.
Yes.
And if that happened, this would meet the kind of, this would meet your recommendation that you put forward a decade ago, broadly.
It would, as you pointed out, and as we've pointed out ourselves in our submission. Recommendation 9.3 of the Law Reform Commission report did say the Act should also provide that the plaintiff has the legal onus to satisfy the court that the public interest outweighs any countervailing public interest that is raised in the proceedings. So I'm departing from that and saying I think a better way is to say the court should be satisfied, and it seems to me that that's a
Could I give you the opportunity to consider that on notice, and if you wanted to
sure.
look at the only other thing I'd ask you to look at is the media organisations seem to have some pretty compelling arguments about the narrowness of the definition of journalist.
Yeah.
And a journalist organisation, and they gave one example would be if the AAP, which is a newswire, produces a journalistic piece of work and then licenses it to a variety of other organisations, whether or not they would be covered by the exemption.
Yes, we have thought about that. I mean, we feel that because of the fault element, it is arguable that the people who are just putting it through under licence may not have the relevant fault element. I'm just not quite sure about that, because presumably there is some editorial control going on here, because the outlets don't publish absolutely everything that the AAP puts out. They make a selection. So I just need to think about that, actually.
Yeah, that's why I'd appreciate it if you could take that on notice and respond.
Yeah.
Thanks, Senator Shipridge. And thank you. I just have a couple of questions, if I may, before we run out of time. Thanks for your submission and obviously for your work over all these years. I wanted to ask, I had a question as well about the limitation around intentional and reckless, and I think you'd given some advice on that, and maybe we'd taken part of that question on notice for Senator Scarr.
Sorry, could you just repeat that? What was that one?
Yeah, sorry. I had a question very similar to Senator Scarr's about the limitation in the statutory tort in being intentional and reckless conduct only at this stage, and whether you thought that was appropriate or not.
Well, it is a contentious issue. It was a contentious issue. As has been pointed out several times today, in the last 10 years, since we did our report, there's been enormous concern and very many serious data breaches, and people are very concerned about data breaches. As we say in our submission, we feel that the better way to deal with data breaches which have involved a breach of the Australian privacy principles is to incorporate a remedy under that Act rather than trying to extend this. Personal information and private information are not the same thing, and there are many reasons why there should be direct remedies for people who have been affected by a data breach because an entity has not complied with the Australian privacy principles.
And to that end, I think your submission notes that a direct right of action is needed for people in those situations where there's been a data breach that's essentially been hacked by a third party. And that's, sorry, I think you were going to that, but I just wanted to understand that that's the proposal from you and Professor Rolfe around how to deal with those situations where there's a third party involved.
Yes. Well, I mean, obviously, if you could find the third party and if they had any assets, it would be worth suing them, because if they hack into a database, then they clearly have, intentionally invaded people's privacy and collected information and misused it. But the problem is that, of course, we're hard-pressed to find them, let alone sue them. So the aim really is to put more regulation and requirements on the entities that collect information and do not have up-to-date security and those sorts of things. We feel that's better looked at under data protection laws, which is really what the Privacy Act has been, rather than the tort. Invasion of privacy, does, and this has been the case again in Canada, the UK, elsewhere, invasion of privacy really does involve an affirmative act rather than just negligent failure to look after something.
Right. Okay. Yeah. And that's why because you support the way that the tort has been drafted, to the point where it's sort of the ALRC made the recommendation around having a tort of serious invasion of privacy. But from what I understand, I don't want to put words in your mouth, that's a positive step forward. And there's also a need to have some protections within the Privacy Law Act itself as well for these other types of breaches that may not be covered by the tort.
Yes, absolutely. And I think that's proposed. I'm not a data protection expert, but I think that's proposed in the second tranche of reforms. We also, in our report, did actually talk briefly about the small business exemption, which I know has come up today. And in the end, we didn't make a recommendation there. We did put a proposal in the discussion paper, but didn't really go any further. But we felt that the small business exemption certainly needed to be looked at. We thought the Productivity Commission, having a look at the costs, it is, as has been pointed out, just so important. And I think at the time we had a discussion with the UK Data Protection Commissioner, who told us all about the different levels of data protection principles that apply according to the size of the business. And I think, as your small business representative today was talking, not all the privacy principles are relevant or appropriate for small business, but some are. We did look at that. But
And in referencing an exemption for small business and looking at that, you're referencing an exemption from the privacy law,
yes,
not the tort.
Not the tort, no, we can't see any.
You go.
Sorry.
I think we're on the same page.
Yes, I mean, look, it's hard to see when a small business should legitimately be deliberately invading someone's privacy or misusing private information. I mean, one of the examples given today was about real estate agents who might have a lot of quite confidential information, like letters of reference and payment history and all those sorts of things. I think a lot of that would be confidential information, but certainly it ought to be regarded as private information, which needs to be properly looked after. Of course, it might have been handed over consensually, and it may be relevant, obviously, to somebody actually leasing a property or something like that, quite legitimately.
But the tort deals with, as you suggest there, there's an intention behind the serious invasion.
Yes.
It's not an accidental.
No, it's certainly not
the wrong person.
It's certainly not accidental. No, it would not. It would not cover that.
And to that end, did you also pick up on the discussion we were having about employee records? I'm not sure if
Yes, I'm sorry. I really didn't follow that.
That's okay.
I didn't really see there how that could be involved with the statutory tort. I mean, I was trying to think of examples.
Yeah. Well, the suggestion was that employee records should be exempt from the serious invasion of privacy tort, and I also was struggling to understand where there would be a need to be exempt from the intentional invasion of someone's privacy based on that data. I don't know if that's come up before, but it's with you or in the work that you've done.
No, it hasn't.
But I can't see a reason where that would be applicable.
I won't promise to take it on notice, but I'm certainly interested to think about that and perhaps to talk with an employment lawyer about that. But I mean, for example, if an employer was to deliberately go and obtain confidential medical information or something like that, well, for a start, that would be a misuse of confidential information, so there'd already be a breach of equitable obligations. There'd probably it might be in breach of contract. There could be all sorts of breaches already. So I suppose you might have an example of somebody going and snooping. I mean, there was a case in Canada, Jones and Sy, but it really wasn't about employee records. It was about one where one employee snooped on the records of another employee who happened to be her partner's new partner or something like that. And that was the basis of the Canadian case. But that's about employees snooping on each other rather than about the employer being somehow liable.
Could the employer be reckless in that situation to have allowed it to happen?
Oh,
yeah. I mean, sorry to interrupt. You answer Senator Shoebridge's question, and then we have to go to.
Look, I think this was the context was in a bank, and I think most banks and like universities or anywhere also subject to rules about when you can access information about other people, when you can't, and it's a breach of that. I mean, it could well mean vicarious liability on the part of the employer if it was in the course of employment. That would probably be a better way of approaching it than trying to prove that the employer had recklessly somehow failed to secure the information, I think.
And there's, I know we have to finish in a moment, but there was a case that was brought to the committee's attention where an employee of a company was accessing private information, allegedly of someone that they knew personally, but that wouldn't involve employee records. That's the company would require.
Well, I think that is snooping. I think that is snooping into intrusion in a way which may well be actionable under this tort if it was proved.
Yeah. Okay. Well, it'll be interesting to see the case law develop, hopefully, if the bill is passed. So thank you very much for your contribution, not just today, but of course over the last many years. We're almost there, I think, maybe. Thank you very much for your time. The committee is about to suspend for a short break, and we'll be back at 4:15 Canberra time for our last session of the day. Thanks, everyone.
you.
And I can now welcome representatives from the Office of the Australian Information Commissioner joining us via video conference, the Attorney General's Department and the Australian Human Rights Commission via video conference. Thanks for taking the time to speak with the committee today. Information on parliamentary privilege and the protection of witness and evidence has been provided to you and is available from the Secretariat. I remind senators and witnesses that the Senate has resolved that an officer of the Department of the Commonwealth or of the state shall not be asked to give opinions on matters of policy and shall be given reasonable opportunity to refer questions asked of the officer to superior officers or to a minister. And this resolution prohibits only questions asking for opinions on matters of policy and does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. For the Hansard record, can you please state your full name and the capacity in which you appear today? We'll start with the colleagues in the room and then go from there.
So Nathan Whiteman, I'm the Director of the Cybercrime and Child Abuse Policy and Engagement Section in the High Tech Crime Branch in the Attorney General's Department.
Parker Reeve, Assistant Secretary, High Tech Crime, Attorney General's Department.
Celeste Moran, First Assistant Secretary, Integrity Frameworks Division, Attorney General's Department.
Catherine Fitch, I'm the Assistant Secretary of the Privacy Reform Task Force in the Attorney General's Department.
Virginia Jay, I'm a Director in the Privacy Reform Task Force in the Attorney General's Department.
Wonderful, thank you. And joining us online, Mrs. Finlay.
Thank you, Chair. Lorraine Finlay, the Human Rights Commissioner with the Australian Human Rights Commission.
Thanks very much. And Ms. Kind.
Thank you, Chair. Carly Kind, Privacy Commissioner at the OAIC. Apologies, is my video cutting in and out or can you see me okay?
It's pretty good.
Great, thank you.
For the moment. Thank you. Do any of the organisations have a brief opening statement before we go to questions, of which I think we will have a lot? So if we could keep them brief, that would be great. Attorney General's Department?
Yeah, we do, Chair. It's very short and then we can get to questions.
Thank you.
Thanks. The Privacy and Other Legislation Amendment Bill is the next step in updating Australia's privacy law framework. A comprehensive review of the Privacy Act undertaken by the Attorney General's Department between 2020 and 2022 made 116 legislative and non-legislative proposals. The review arose out of recommendations by the Australian Competition and Consumer Commission in its 2019 Digital Platforms Inquiry. The review process involved extensive stakeholder consultation, hundreds of written submissions and detailed meetings. It also considered recommendations relating to privacy made by the Australian Law Reform Commission in 2008 and 2014, including a model for a statutory tort for serious invasions of privacy and a wide range of other sources. The Department is very grateful for the strong engagement that we've had throughout the review process. We realise many issues are contested, and this is reflected in the submissions received by the present committee and the evidence given today. The government has said that the Privacy Act is not fit to protect Australians in the digital age. The government published its response to the review in September 2023, and it agreed in principle to the vast majority of those proposals, 106 out of the 116. In March 2024, the government conducted a consultation process which supported the enactment of a statutory tort as an additional remedy for doxing alongside new criminal offences. The elements of the tort have been carefully calibrated. They work together to fill an established gap in privacy protection while setting an appropriately high threshold for action. It is designed so that it would not be engaged by trivial matters or routine information handling activities. The criminal offences targeting doxing also deliver on a commitment made by the Prime Minister following the National Cabinet meeting held on the 1st of May 2024 to address family and gender-based violence. The introduction of standalone offences reflects the wide-ranging, serious and enduring harm that doxing can cause to victims. The government is implementing its privacy reform agenda in a measured and considered way. In 2022, the Privacy Act was amended to significantly increase penalties for serious or repeated privacy breaches and provide the Office of the Australian Information Commissioner with enhanced enforcement and information sharing powers. This bill implements a first tranche of proposals from the government's response to the Privacy Act review, ahead of further work towards a second package of reforms. The Attorney General has stated publicly that the Department will develop the next tranche of privacy reform for targeted consultation including draft provisions, in the coming months. We have commenced work towards this. The department will continue to work with entities including industry, tech organisations, small businesses, the media and civil society, as well as experts in academia and peak bodies. This is intended to avoid unintended consequences and ensure the right balance is struck between protecting people's personal information and allowing it to be used and shared in ways that benefits individuals, society and the economy. Noting the government's broad reform agenda, the department hopes to be in a position to begin consultation on draft provisions prior to the end of the year. The final make-up and timing for any second package of reforms will be informed by this consultation and is ultimately a matter for the government. We understand you've got limited time and are happy to take questions, Chair.
Thanks very much. The Australian Human Rights Commission, do you have an opening statement, Ms Finlay?
Yes, thank you, Chair, and it is very brief. Good afternoon. We'd like to thank the Legal and Constitutional Affairs Legislation Committee for the invitation to give evidence at this public hearing, in addition to the written submissions that have previously been provided by the Commission, both to this inquiry and additionally the April 2023 submission that was provided to the Attorney General's Department Privacy Act Review. When he introduced this bill into the Parliament, the Attorney General stated that the Privacy Act has not kept pace with the adoption of digital technologies. We agree. That is why we are disappointed that despite having agreed or agreed in principle to numerous recommendations set out in the government response to the review report, only a relatively small number of those reforms are present in this bill. Most notable is the absence of a fair and reasonable test, which would serve to strengthen privacy protections in the modern era. For the Privacy Act to serve its purpose and protect the privacy of all Australians, the federal government needs to implement all of the accepted recommendations. While we recognise the importance of doing this in a measured and considered way, it's also important to do so in a timely way. As such, we would call on the government to publicly set out a timeline for implementing the remaining recommendations from the review report. Having said that, we do note that the reforms that are contained within this bill will, in our view, make a positive difference towards improving privacy protections for all Australians. The right to privacy is a cornerstone human right which underpins freedoms of association, thought and expression, as well as freedom from discrimination. The introduction of a statutory tort, improvements in transparency about the use of personal information in automated decision-making processes, the introduction of a children's online privacy code, and reforms that target doxing are all welcome reforms that will help provide additional protection for the right to privacy at a time when the digital environment has eroded privacy in a seriously harmful way. Ensuring strong protections for privacy is not only a matter of upholding fundamental human rights, it is also essential to building public trust and confidence in the digital economy. The Attorney General is correct that the Privacy and Other Legislation Amendment Bill 2024 is a significant step forward for Australian privacy law. But it is only a first step towards updating our privacy laws to be fit for purpose in the digital age. We look forward to answering any questions the committee might have about our submission. Thank you.
Thanks very much. Commissioner, do you have an opening statement?
Thank you so much, Chair, if I may. And many thanks for the opportunity to appear today. I've said a number of times that the proposed amendments to the Privacy Act are an important first step in achieving privacy reform in Australia, but they are only a first step. I won't recap what my colleagues have already said in terms of the scope of the current bill, but from the perspective of the OAIC, we believe it will fundamentally contribute to the range of regulatory levers we have as an effective regulator and enable us to respond effectively to privacy harms and emerging threats in a strategic and proportionate way. And to that end, we very much support the proposals that are contained in the bill. However, beyond those proposals, the development of the next tranche of the Privacy Act reforms is urgent if we are to keep ahead of the privacy threats and advancing skills of malicious cyber actors. And in that regard, I'd like to highlight very briefly two matters where we believe this committee has the opportunity to assist in this process. The first is with respect to the definition of personal information. As you know, the government response agreed in principle to amending the wording of the definition in order to provide additional clarity as to what information is covered by the Privacy Act and to address overly narrow interpretations of the definition. We feel strongly that taking forward this proposal as a matter of priority would greatly expand our ability to be an effective regulator within the current environment. The second element is the fair and reasonable test, as Lorraine mentioned. And I think if there has been a central theme to the OIC submissions in relation to the Privacy Act, it has been about the introduction of this positive obligation on entities to ensure that their collection, use and disclosure of personal information is fair and reasonable. We think that this would be a really novel provision, a way to raise the general standard of personal information handling across the economy, and would address the current power imbalance inherent in the existing framework by shifting the responsibility to businesses and organisations to proactively consider the impact that their data handling practices may have on individuals. So to conclude, I think the bill before you now is a really important first step in strengthening Australia's privacy framework, and we wholeheartedly support it being passed. But we would also recommend, as a matter of urgency, that the amendments to the definition of personal information and the introduction of a fair and reasonable test be progressed alongside that. Thank you so much.
Thanks very much. We'll go to questions now, and with your indulgence, Senator Scarr, Senator Shoebridge is going to leave us very shortly, so I might hand the call to him for the brief amount of time that he's with us, and then we'll have plenty of time to ask questions after that. Senator Shoebridge.
Oh, yeah, thanks, Chair, and thanks, Senator Scarr. Does the Australian Human Rights Commission agree with the proposition from the Privacy Commissioner that indeed amending and extending the definition of personal information and putting in place a fair and reasonable constraint is urgent work?
Yes, Senator, and we have referred to this in our initial submission to the Privacy Review and consider that is something that should be progressed.
Well, indeed, I mean, it could be progressed this year because the scope of those amendments is well known. They've been discussed ad nauseum in one form or another for over a decade. Now would be a good time, wouldn't it?
We would agree, Senator, and we would say that obviously while public policy requires consultation, there has been consultation on this point. As you said, it is something that has been discussed for a lengthy period of time, and while we certainly understand the need to proceed in a measured and considered way, we would say there is also a need to proceed in a timely way, and we would like to see a clear timetable in terms of when that reform and others will be progressed.
Yeah, well, I might ask the department, why isn't it in this bill? Why don't we have the extension of the definition of personal information as the government's accepted in principle? Pretty much every credible submission has said should happen. Why aren't we doing it?
Thanks, Senator. The department does recognise the importance of the two reforms that the commissioners have mentioned, the fair and reasonable test that was proposed in the Privacy Act review and the extended definition of personal information. We think that they both clearly do assist in providing an upgraded baseline standard for personal information. The government at this stage has committed to progressing the remaining agreed in principle proposals, of which those were both two, in a second package. However, the department has heard the submissions made over the course of today about not just from the commissioners but other people appearing, and we're happy to raise the matter further with government. The only additional point I'd make, Senator, is that this first tranche bill was really intended to be to address areas where reform had been identified as urgent and can be progressed largely without a direct or significant regulatory direct impact on entities. And the reason for that, I think, is the government seeking to balance an uplift in privacy protection with a reasonable and proportional impact on entities. And in our consultations to date, several stakeholders have made clear that they would welcome the things that directly impact them being progressed in one group.
But you're doing it in two groups.
So I think, Senator, as I said, the first tranche that's represented in the current bill are largely things that don't directly and significantly impact on regulated entities. So I'd draw attention to increased powers for the Office of the Australian Information Commissioner, emergency declarations, etc.
That's a pretty extraordinary proposition to say that the reason we've got what we've got in this bill is because you don't want anything to impact on regulated entities. That's a pretty extraordinary position for the government to adopt if this is the only meaningful privacy reform. You'll do everything except for anything that impacts on a regulated entity. I mean, that surely hasn't been your ambition, has it?
No,
Don't
Senator.
do anything that actually changes anything.
No, Senator, not at all. But what I would say is that the government has made clear that it does seek to do another tranche of reform, and that in certain cases that requires further consultation on the detail of draft proposals.
But I mean, I didn't mishear you. You've said that you want to make sure that there's nothing in this package of reforms that's going to impact on a regulated entity. Who gave you that direction?
Senator, I might just add.
Who gave the direction?
Well, that wasn't a direction from government, but I think that it's that the first tranche of proposals to which the government agreed in its response to the Privacy Act review were agreed proposals, and then the government has agreed to consult further on a second tranche.
Well, perhaps this might throw some light on why we have reform that excludes any impact on a regulated entity. Who amongst you have seen the, I think it's the ACIL Allen report on privacy? Who amongst the witnesses here have seen it?
Yes, I have, Senator.
Yeah. Well, why isn't it public, Ms Fitch?
Senator, the government is highly... it was something that was prepared primarily for the purposes of informing government decision-making. The government has been clear all along the way that it is seeking to be very careful in calibrating reforms to strike the right balance between impact on business, proportionate impact on business, and an upgrade in protection in privacy. And it is... that's... primarily what I've got to say about that.
No, but why can't the Parliament see it in order to better understand the ambition or not and the scope of these and the impact of these changes? Why isn't it public?
So, Senator, I think what Ms Fitch has said is that it was one input into government decision-making processes around the response to the Privacy Act review, and then how the government would decide to take these things forward. And so it's being considered in that context.
Yeah, but perhaps I didn't explain my question clearly. Why hasn't it been made public? The fact that you relied upon it and it was useful is a compelling reason to make it public, not to hide it. Why isn't it public?
Well, Senator, we can take that on notice and come back to you.
Well, whose report was it? Was it a Treasury report or was it a report for your department? Whose report is it?
It was conducted under a consultation arrangement contract with the Attorney General's Department.
Well, was it in consultation with Treasury? Was it provided to Treasury? Did Treasury have input into it?
We had consultations with Treasury along the way. It was an independent report by the consultant.
So who made the decision not to publish it? Was it you, Ms Fitch?
I think we haven't given evidence to say that there's a decision being taken one way or another. I think it's under consideration by the government as part of the decision-making processes the government undertakes.
Could you table a copy of it now, please?
We don't have a copy, Senator. So
can you provide a copy to the committee?
We can take that on notice, Senator.
Has it been published?
Not that I'm aware of, Senator.
When was it drafted? When was it provided to you?
To the best of my recollection, it was finalised in June of 2024.
All right. So there's been a decision, at least not to publish it to date. Who's made the decision not to publish it to date? Because there have been multiple requests from from third parties, from stakeholder groups for it to be published. Who has made the decision to date not to publish it? Was it you, Ms Fitch?
I have been the decision maker in one relevant freedom of information request at the first instance, and that was made on a range of grounds, including what I deemed to be valid exemptions under the Freedom of Information Act.
Well, could you provide a copy of your decision on that FOI to the committee?
I think that's publicly.
Well, decisions often aren't made publicly available in terms of disclosure log obligations. We would take that on notice, Senator, and see if there is something we can provide.
So we can't see why you didn't provide it, can't see the report, can't see why you didn't provide it.
No, Senator, I'm not saying you can't. We just have to look at it to consider if there are any other privacy obligations in relation to who the applicant was, that sort of thing. So I'm not saying we can't provide it. I'd just like to take that on notice to have a good look at the decision and make sure that there's nothing we would be providing to the committee that we aren't able to.
I'd ask you to take on notice a review of Emeritus Professor McDonald's evidence and her submission in relation to the particularly clauses 7.3 and 7.4 of the proposed serious invasions of privacy. She seemed to have a number of quite credible critiques of the current drafting. Did you have any quick response to Professor McDonald, and I think it was also Professor Rolfe's submission? If you haven't, you can take it on notice.
We were listening, but we were also on the move up here. So I'm just looking down to my colleagues to see if there's any immediate responses.
But there are, thanks, Senator. There's, we're aware that, and we will come back to you further on notice, but we're aware that Professors McDonald and Rolfe made suggestions that, I think they did say the tort largely reflected the ALRC model with a few key departures, and I suspect that's what you're referring to. I think there are some conversations which we had with civil litigation experts and so on, which led to the approach that was ultimately reflected in the bill in terms of how the public interest balancing test is represented in the bill, but we can come back to you in more detail about that.
I think Professor McDonald had some very real concerns about putting in place some kind of evidentiary onus, limiting it purely to questions of evidence when she thought there was equally questions of law, and in a potentially very limited way in which 7.3 operated. So if you could respond to her evidence on notice, I'd appreciate that.
We can do that.
I just quickly have a question of the Human Rights Commission. You set out in your submission concerns about doxing and the need for a public interest, some kind of protection for public interest communications on doxing. Do you recall that, Commissioner Finlay?
Senator.
Yep. And indeed, you're not the only organisation to have concerns about the potentially broad scope of the doxing provisions. But of course, have you had a chance to look at the submission from the Australian Christian Lobby?
No, unfortunately I haven't, Senator.
Well, could I ask you on notice to turn your attention to some quite disturbing propositions in the submission from the Australian Christian Lobby? One is in relation to a social media post from on Twitter from an entity that begins with @Celine V, where on Twitter they shamed and doxed a primary school teacher, showing images of the teacher, identifying where they worked, which school they worked at, and attacking her for running a queer support group in her primary school. Could I ask you to consider on notice if you agree or otherwise with the Australian Christian Lobby's view that there was a public interest in that? The other is,
Certainly, Senator.
The other is a another deeply troubling and offensive post from an entity described as Billboard Chris, attacking Teddy Cook, who's on the World Health Organisation's advisory panel on guidelines to transgender health. There, the Safety Commissioner identified some appalling elements of that post, being the misgendering and insulting of Teddy Cook, and equating of transgender identity with mental illness. Again, the ACL seems to think there's a public interest defence in that. Could I ask you to review that as well and see how you think if or any public interest elements might be considered in a case like that?
Yes, Senator, we're happy to do that on notice.
And do you... of course, there are media commentators, largely from the right, who seem to think that public interest is only in relation to attacking transgender people, attacking people who identify as LGBTIQ, and seem to think that there should be some licence to have attacks on that part of our community and put it under the guise of public interest and debate. Do you have a view about that?
Senator, I would say more broadly, we don't see those attacks as being limited to any one particular side of politics or group of politics. Rather, it's a concern more broadly in terms of striking that appropriate balance between ensuring the protection of a doxing offence, but providing a public interest, a doxing offence, but providing a public interest defence that will allow things like public interest journalism to proceed in a way that's appropriate. So I would like to take those examples that you've given on notice, because we do refer in our submission to the concerns that we have around those issues. And again, it is striking that right balance between ensuring that the legislation is strong enough to capture the behaviour that we do think needs to be captured to protect people and their privacy, but also ensuring that it doesn't stifle freedom of expression, noting that in the examples you've given, there can be quite different opinions about where that line should be drawn. So we don't underestimate the challenges in striking that right balance in legislation, but we do think in our submission that there is importance in ensuring legitimate public interest purposes are accommodated. But I'll certainly take the question on notice in terms of the specific examples that you've raised.
Well, you say it's not political, but indeed most of this argument has been deeply political, because indeed I think what started this most recent round of reforms off was the release of information about a certain creatives groups that were agitating on the issue of Israel and Palestine, and the same interests that desperately want to defend the kind of posts that I took you to in the Australian Christian lobby were viciously attacking and want to criminalise the sharing of that information. So it is highly political, Senator, isn't it? It's highly politicised.
When I said it's not political, I didn't mean in the sense of broadly is it political, in the sense of it's not limited to left or right in terms of politics. It's a problem across the spectrum, and that's why we do need legislation to strike the right balance to ensure that we're not making decisions based on views that we may agree or disagree with or any one particular political issue, but we actually have a legislative framework in place that will cover all of those types of issues and make sure that human rights protections are extended to all Australians.
Well, then, to assist in balance, then I might ask you also on notice to also provide your response in relation to that incident, the one that has set off this most recent round of proposed reforms that might allow for that.
Was the doxing based on the WhatsApp Creatives group?
Indeed.
Certainly, Senator.
And thank you, Chair. I really appreciate it, but I don't have time. I have a flight.
You're welcome, Senator Shoebridge. Senator Scarr, you have the call.
Thank you, Chair, and thank you to the witnesses for appearing today, and I acknowledge the great deal of work that's been done, obviously, and commend all members of the department who've been involved in what has been, no doubt, a very time-consuming process. I just wanted to ask a few questions first in relation to process. So we received the Law Council of Australia's submission today, and they refer to previous submissions they made where they encouraged exposure drafts of the legislation to be provided. So I just wanted to get, and I can see movement at the station, I just wanted to get for the record, get down the consultation process that occurred in relation to the different schedules. So there's Schedule 1, the privacy reforms, and I think that has been through a pretty extensive consultation process. You've then got the Schedule 2, serious invasions of privacy, and then Schedule 3, doxing offences. So firstly, in relation to Schedule 1, was there an exposure draft provided?
Yeah. Thanks, Senator. There wasn't an exposure draft of Schedule 1 of the bill per se, but the contents of Schedule 1 closely reflect proposals which were consulted on heavily throughout the Privacy Act review, which was undertaken, I think, as you know, between 2020 and 2022, and then received hundreds of submissions from a broad range of sources following that as well.
Okay. Then moving on to Schedule 2, serious invasions of privacy. Interested to know what obviously the Australian Law Reform Commission looked at the issue some 10 years ago, approximately.
Yes.
In the context of answering that question, I was somewhat surprised when the Australian Industry Group noted when they were giving testimony earlier today that they were, and I think they said surprised, to see the statutory tort appearing in this bill. And I did ask them questions in relation to consultation in relation to the statutory tort, whether or not there'd been any consultation over the last immediate period, say last 12 months, in relation to the statutory tort. And I did note, Ms Moran, I think in the opening statement you did refer to the statutory tort. So I was keen just to get on the record from the department's perspective, the consultation process that's been undertaken in relation to the statutory tort.
Thanks, Deputy Chair. It's similar to what Ms Fitch just said in relation to Schedule 1. The history is probably slightly longer in terms of the ALRC's 2008 report, the ALRC's 2014 report. The Digital Inquiries report from the ACCC recommended a statutory tort. The Privacy Act review also recommended a statutory tort. We then did a consultation process on the government's response to the Privacy Act review, which included the recommendation for a statutory tort. As part of some roundtable consultations in March of this year in relation to doxing, the statutory tort was raised in that context, and it was primarily in that context that it was seen as a complementary part of the doxing offences, and so that's been an additional consultation process.
And Senator, just to add to Ms Moran's answer, that was not just roundtable processes, that was a call for public submissions on privacy and doxing undertaken between the 11th and the 28th of March, and the department received, I think it was 97 submissions, the majority of which are published on our department's website in relation to that, and a key feature of those discussions was the statutory tort.
And just in that respect, Ms Fitch, was it, you said a key feature of those discussions was the statutory tort. Was it the statutory tort in the context of doxing, or was it the statutory tort as a standalone issue, if you understand what I mean?
I mean, it was raised in the context of doxing, but the submissions were, some submissions were broader than just the doxing context.
I'm trying to get to the bottom of why the Australian Industry Group were surprised in their own words, and it could well be because they interpreted the consultation simply in the context of doxing. I don't know, but thank you for that. COSBOA in their submission referred to, and I'll quote, this is from page 3 of their submission, COSBOA also requests that the Attorney-General's Office grants public access to the cost-benefit analysis, so continued consideration can be given to the benefits of maintaining and perhaps expanding the small business exemption to the small businesses between $3 million and $10 million that face the same significant challenges in complying with the full breadth of all 13 Australian privacy principles. That reference to the cost-benefit analysis is, did the ACIL report that Senator Shoebridge referred to, did that include a cost-benefit analysis of that nature? Is that the cost-benefit analysis that COSBOA has requested?
Yes, we would say that that's the same.
It's the same?
Same thing.
Okay, I just wanted to square that away, thank you. Just some quick, easy, low-hanging fruit. ABC and SBS both raised concerns that as publicly owned broadcasting organisations, they might not be considered media organisations for the purpose of the Act. The mere fact that they raise the concern would indicate to me that maybe the drafting needs to be tweaked. Do you have any response to that?
Senator, was that specifically in the context of the offence, or
No.
or more broadly?
That was in relation to Section 80KA, is that right?
What I'd say, Deputy Chair...
Yeah, it was that section.
We will have a look at it.
Can you have a look at that?
It came up in the context of the NAC legislation from memory, so it's an issue that the department's aware of. I don't think we contemplated it in this context, but we heard the evidence today and can have a look at it for you.
Thank you. We heard from our friend the Professor, who was involved in the Australian Law Reform Commission process and gave very helpful evidence. And in her submission, she talked about how Clause 7, 3 and 4 of the tort have evolved from the Australian Law Reform Commission proposal. How did that occur? What was the thinking behind that evolution? Why the tweaking in wording? I noted you referred to getting evidence from civil litigation experts. To what extent did that justify a change in the wording?
Senator, it's a reasonably technical question, and I think we've agreed to give some more information in response to Professor McDonald's evidence on notice. But essentially, I think it largely boils down to the fact that who is best placed in a civil litigation context to identify public interests which might apply. And there might be, I think we thought in the course of working through with drafters and others how to construct it, that there might be instances where somebody seeking to defend an action is better placed to identify relevant public interest factors which a court should consider.
Okay, but you've taken that on notice, so if you can come back to us on that. And also, if at the same time when you're looking at the Professor's submission, the Professor gave quite strong evidence in relation to querying the journalist exemption and the law enforcement agency exemption, and again gave evidence to the effect the Australian Law Reform Commission dealt with that in a somewhat different way. So interested to know the reasoning underpinning the way that the bill's been drafted. Is that possible to take that on notice and provide us more fulsome response?
It is, and I think, Senator, I'd also add that we've been watching the evidence given today and would note that a diversity of views has been expressed on those two issues. But yes, we'll take that on notice for you.
Okay, thank you. In relation to the Children's Online Privacy Code, the Interactive Games and Entertainment Association expressed concern about the use of the words likely to be accessed by children, and they proposed targeted at or directed to children as the relevant test as to whether or not an organisation fell within the purview of the code. What was the reasoning behind using the former words likely to be accessed by children?
I think, Senator, one relevant consideration, and my colleague might have some detail to add here, but the UK Age-Appropriate Design Code, I think, uses a similar construction, and the UK Information Commissioner's Office guidance outlines what is meant by that. So what's meant by likely to be accessed by children, and it sort of provides some guidance that I think many organisations would be familiar with. In our bill, currently the subject of this inquiry, it also provides factors relevant to whether a service is likely to be accessed by children, such as the nature and content of the service, whether it has a particular appeal, and so on. So I think we thought that was a clear and relevant construction under the circumstances.
Okay, so those words, from your perspective, define the category, or at least assist to define the category of organisations that be covered.
That's right.
Okay, understood. We've had the usual, I call it usual, argument in relation to the application of disallowance processes in this context. As I understand it, APP codes generally are disallowable instruments, but this bill provides that a code which is adopted as an emergency measure should not be subject to disallowance. Is that correct?
That's correct, Senator.
Okay. Have there ever been any APP codes disallowed?
I think definitely not that we're aware of. I think there's been 3 created under the provisions in the Privacy Act, and we're not aware that they've been disallowed.
So, what has activated the concern of the department, what's activated the concern that the Parliament wouldn't act responsibly and assess these codes as it assesses previous codes, and the scrutiny processes of the Parliament should simply be allowed to work in the usual course? What are the exceptional circumstances which justify a code adopted in emergency circumstances not being subject to parliamentary oversight?
Senator, I'd probably point to 2 things. I think the bill provides exemptions for disallowance for temporary APP codes and also emergency declarations and data breach declarations, and there are 3 instances where prompt action and certainty is required on the part of entities. So I think particularly in relation, well, for all 3 categories, but particularly in relation to the emergency declarations and the data breach information sharing declarations, we would expect that people be able to rely on the contents of that immediately. Temporary APP codes can only exist for a maximum of 12 months, and I think so similarly it's important that they could apply in situations like a pandemic or some sort of temporary emergency type situation, and again certainty is critical from soon as they're allowed.
So Ms Fitch, there were numerous concerns raised in relation to instruments that were not subject to disallowance during the pandemic, were not subject to parliamentary oversight, instruments and regulations that had a material impact on the rights and liberties of individuals. Why couldn't the Parliament take all that into account in terms of exercising its important disallowance processes?
Really, just to ensure that entities would have certainty in relying on the provisions of a temporary APP code in such a circumstance.
Okay. Ms Finlay, do you have a view on that? The exclusion of codes which are adopted in emergency circumstances being exempted from disallowance processes of the Parliament?
It's not something that we've specifically turned our minds to in this context, Senator, but we'd be very happy to take it on notice if you'd like some considered views.
Sure, if you could. The AMA...
Oh, sorry, Senator, I just did think of one other relevant consideration there. I think that temporary APP codes would generally be designed to be more contained than an average APP code. I think that's another relevant consideration.
Yeah, I mean, the only thing I wanted to add to what Ms Fitch said is we haven't taken lightly the kind of considerations you've put to us in terms of the disallowance issue, noting the kind of certainty required in emergency situations. We felt like it was a relevant consideration for the bill. There are safeguards built in, which Ms Fitch has mentioned, around the timeframes that the emergency codes can apply for and who they can apply to is also contained. So I'm just repeating what Ms Fitch has said.
But Ms Moran, all of those matters could be considered by a scrutiny committee, and as you'd be aware, the scrutiny process typically involves the committee engaging with the relevant department with respect to any scrutiny concerns, and quite typically those scrutiny concerns are addressed through useful amendments to delegated legislation or through enhancements to explanatory memoranda, etc. Isn't that the case? I don't want to put you in a difficult position. I'm a member of the Scrutiny of Delegated Legislation Committee, so I'll always fearsomely assert the role of the Parliament in terms of disallowance processes, but I understand your position. In relation to the doxing offences, Ms Finlay, if you could perhaps first, if I could give you an opportunity to outline the concerns you have in relation to the scope of the offence.
Well, I should say, Senator, and this refers both to our submission in relation to this legislation and the specific submission we made in relation to the consultation process that was undertaken with relation to the doxing offences. We are in support of legislation that addresses the issue of doxing, and we do see the need for enhanced protections with respect to that. However, the issue that we've raised in relation to the particular legislative proposal that's before this committee is the need to ensure that doxing laws don't unreasonably capture public interest whistleblowing and journalism. So, in our view, including a provision in the bill that expressly protects the release of information for legitimate public interest purposes helps to ensure that we're strengthening the protection for freedom of expression while we're also still effectively addressing the harms caused by doxing. Now, some of that will already be captured with the current fact that the offences only apply where a person engages in the conduct in a way that reasonable persons would regard as being, in all the circumstances, menacing or harassing towards those individuals. But we do still see an advantage in expressly spelling out that public interest purpose exception, particularly to ensure that whistleblowing and journalism is sufficiently protected.
So, Commissioner Finlay, as usual, you anticipated my next question in your answer, and that which was going to be, why aren't we protected in that regard because of the use of the words menacing or harassing? Can I turn the question on its head and say there are people who perhaps present themselves as citizen journalists who perhaps do have malintent and could potentially use such an exception to try and avoid the intent of the legislation. How do you address that concern if you put in this proviso? Happy for you to take that on notice.
I will take that on notice, if I may, Senator. However, just to say initially, we recognise there is a need for careful drafting in all cases involving public interest exceptions, because there is that question about where that line should be drawn. Yeah. We say that including a legitimate public interest purpose would help to strengthen freedom of expression while still protecting against the harms of doxing. But certainly it isn't a simple solution, and we recognise that there are challenges in terms of striking that right balance. So that is something that would need to be addressed in the drafting.
Okay. If I can ask...
Give you a little wind up, Senator Scarpet. You have another questions if you want.
Okay, well, I might just ask one further question, and I'll ask a few questions on notice if I can.
Yes, happy to do that. I've just got a few to get through, sorry.
Yeah, no, that's fine. So then turning to the department, the Law Council of Australia, and you might not have had a chance to read their submission, it came in today.
No, I have read it,
sorry?
I have read it, Senator.
Oh, you
yes.
have? Oh, you're efficient, Mr. Reeve, as usual.
That part of the submission, Senator.
Sorry?
That part of the submission, at least.
Oh, okay, thank you. So in their recommendation 18, they were calling for guidance as to what constitutes menacing or harassing. From your perspective, obviously you made a decision that there was sufficient guidance, or there wasn't a need to provide further detail as to what constitutes menacing or harassing. So I was just interested to know the process you went through to come to that conclusion.
No, certainly, Senator, and thank you. So I think, as you would be aware from our discussions in the deepfake sexual material bill context, the concept of menacing and harassing is well established in the criminal code in existing section 474.17, which is the use of a carriage service to menace or harass. Those provisions have been in place since 2004. They are routinely prosecuted through the courts. I think between 2019 and the end of 2023, the CDPP prosecuted about 200 matters under those provisions. They were considered by the High Court in Monash in 2013, including considering the meaning of those terms. So, I mean, to menace or harass involves conduct that is threatening or repeatedly vexatious to such an extent as to cause, and I think we've said this out in the explanatory memorandum, it would cause a person to fear for their safety or limit their ability to go about their daily life. It is a serious threshold, as you would expect for a criminal offence attracting a high maximum penalty, and appropriately so. And that goes to why we have not included a defence of the kind suggested in the offence. Yep. I think, as we've set out in the explanatory memorandum, the objective requirement that a reasonable person would consider the conduct to be menacing or harassing, that is, involving threats or vexation, etc., is such that legitimate conduct would not be captured by the offence in the first instance, and the inclusion of a defence then would actually provide a permission, an authority, a licence for people to engage in what is quite harmful behaviour.
Okay. Understood. Yeah, understood. Thank you. So then just quickly, if I could ask you to take on notice, there were, and I know there are philosophical differences in terms of the competing interests, but I'm particularly interested for you to take on notice in response to the Australians' Right to Know coalition. They made a number of recommendations where they referred to technical matters in relation to the definition of journalistic material, in relation to other limitations, protection to a publisher who retains a journalist as an independent contractor, for example. This is on pages 5, 6, 7 of their submission, and also in relation to the concerns they raise in relation to protection of sources. If you could take those, which I consider really technical issues, to make sure the ambit of the exemption works perhaps as intended, if you could take that on notice. And similarly, if you could take on notice, again, what I'd refer to as the technical recommendations of the Law Council of Australia. I'm just interested, and it doesn't have to be War and Peace, I'm just interested to know your consideration in relation to the drafting process. You could well have considered these matters, but in particular, recommendations 2, 3, well, we'll say 2 to 17, just to make it easier, but not War and Peace. I'm just, if you've got short responses to them, that would then assist me to close out those issues in terms of providing my comments in relation to the bill. And lastly, the AMA made a submission, the Australian Medical Association made a submission, and obviously we care about the health of all Australians, and a lot of the topics they covered were along the lines of disclosure of, say, my father and grandfather's health history with a view to assisting in the provision of health services to me as a patient. So if you could maybe, again, I'm not looking for War and Peace, but how the bill responds from your perspective to those issues.
We can do that, Deputy Chair.
Thank you.
Thank you.
Thanks. Thank you, Senator Scarr. I'll just start off with questions to the department, and then I'll go to the agencies that we have with us today. Really quick, straight off the bat, this has been brought up with other witnesses today. but the Australian Industry Group and some other submitters have suggested that the automated decision-making provisions are broader than what was proposed in the government response to the Privacy Act review. What's the position on the difference and the rationale behind it?
Thanks, Senator, for the question. My colleague Ms Jay will answer that one.
The Privacy Act report proposed that privacy policy should set out the types of personal information that would be used in substantially automated decisions which have a legal or similarly significant effect on an individual's rights. That wording was drawn from similar wording used in the European Union's GDPR. The bill has applied that transparency requirement to decisions which could reasonably be expected to affect the rights or interests of an individual. The application of that transparency requirement to decisions with significant effect on an individual's interests, in addition to rights, was in recognition that rights do not have the same application in Australian law as in Europe, which has a more developed rights-based framework. In Australian law, the concept of interests covered the types of similarly significant effects it was anticipated that the new requirement should cover, i.e. the provision of benefits under an Act or the denial of significant services or support.
Okay. It's helpful still on automated decision-making provisions. Some submissions have suggested that they shouldn't overlap with proposed mandatory guardrails for AI in high-risk settings. Could you explain how the provisions in the bill around automated decision-making complement the proposed mandatory guardrails on AI in high-risk settings?
Chair, I can start. We've obviously been working very closely with our colleagues in the Department of Industry, Science and Resources on their AI policy work. We see the ADM provisions in our bill working together with the work that DISA are doing in relation to AI and to ensure the safe and appropriate use of AI. They are slightly different concepts, as I'm sure the committee is aware, as well as the work that DISA are doing within the Attorney General's Department as well. We are undertaking a broader automated decision-making process in the context of administrative law. And so, as much as possible, we're building together these things along with working with the DTA in relation to the standard that they've just produced and that will apply to government agencies in relation to the use of AI by government departments. So that's the kind of high-level picture, which is there are a couple of different things in relation to either AI policy or ADM that are going on across government. We are very closely linked in with those different pieces of work to ensure that they're complementary rather than disparate. I'll just see if Ms Jay wants to add anything to that as well.
Yeah, of course. The AI guardrail options paper is looking at addressing the adverse impacts on the use of AI in high-risk settings. The Privacy Act reforms are intended to provide transparency about automated decision-making using personal information which significantly affects individuals. And the significant difference is that the transparency requirement would apply to decisions with both significant beneficial and adverse impacts, as the purpose of the reform is to provide transparency. And as Ms Moran mentioned, the scope of the privacy reforms is broader as it applies to all types of automated decision-making and not just AI, in that while some automated decisions use AI, not all automated decisions use AI. That's right.
Okay, thank you. That's helpful. On another topic, we've had a discussion with some witnesses today and some submitters, and I'm sure this came up during the consultations that you undertook, that there should be a requirement for a serious harm threshold for the tort of serious invasion of privacy. And that would essentially require plaintiffs to prove damage for the privacy tort. Can you explain the rationale behind not having a threshold of damage to be proven? And were these recommendations, or how does that align with the recommendation of the ALRC?
I'm happy to kick that one off, Senator. So I think in this respect, the privacy tort in the bill is consistent with the model that ALRC recommended in that it doesn't include a serious harm threshold. It does only apply to serious invasions of privacy, though, and I guess primarily, and I think other witnesses have given evidence to this effect today, recognises that the harm suffered by a serious privacy invasion may often be emotional distress rather than actual damage. Requiring proof of actual damage would prevent damages being awarded for the significant distress and mental anguish which may be caused by a serious invasion of privacy, but isn't generally considered under law as actual damage.
Okay. The other thing that came up with some of our submitters earlier on today was the exemptions for enforcement intelligence agencies. Can you explain why there's a specific exemption for law enforcement and intelligence agencies rather than relying on the defence?
Thanks, Senator. Chair, I guess the main difference between and rationale for including exemptions rather than just offences or relying on the public interest balancing test itself is that it makes it clearer on the face of the Act that for the tort that at an earlier stage that a broad range of entities are not captured. So that would intend to indicate there's no need to begin an inquiry into these matters at all, and for those entities to even raise a defence. And I guess that's ultimately directed at not wasting time and resources either of the litigants or of the courts.
One other one that's come up as well. You said you'd look into the ABC and SVS. Being excluded as media organisations around emergency declaration. I had a question here about that, but you said today that you're going to have a look into that based on the evidence we got today.
Yeah, I mean, Chair, we will. I mean, I think our intention is that they are covered, but I suppose in the context that the Deputy Chair raised it, we're happy to take a look at it and ensure that that is the case, noting that it's been raised in evidence today.
Great. And then probably finally for the department, given the time, I just, Senator Shoebridge asked you about the impact analysis. That's what I understood him asking you about when he was asking about the report. Just to explain, because it's not a usual process that we would necessarily always be familiar with, an actual impact analysis required when the Office of Impact Analysis undertakes that inquiry and then also decides when it's going to be released. Like, can you actually just walk us through that process? Because I think that we've missed that step in the conversation.
Thanks for the opportunity to outline that in a bit more detail, Chair. That's right. The Office of Impact Analysis under the standard process has a range of requirements and requires certain information, a very strict regime of requirements, I think, which are publicly available, but requires certain information about the impact of proposals the government intends to take forward to be published on its website at the time once firm decisions have been taken about those measures. And so there is, I think, a broad understanding that position in relation to reform proposals that it's relevant to has not been reached in this particular case.
Right.
But of course the government has always intended to comply with the Office of Impact Analysis standard requirements that are outlined.
And so, just so I understand and it's clear, especially for our report, the impact analysis that's been conducted hasn't been released because it relates to reforms that the government hasn't decided to bring forward in this bill.
That's largely correct. Yes, Chair.
All right. I will just sort of try to skip through some of these questions that I have for the Information Commissioner. Apologies for being short on time, and sorry for my voice. I have my toddler's RSV, which seems to just be like a reoccurring theme the last month. Your submission, Ms. Kine, refers to the importance of acting on implementing the fair and reasonable test, and we've talked about that a little bit with other witnesses as well. And modernising the definition of personal information. Why do you consider that those two, I guess, parts of the reform are particularly important? And as I understand it, their personal information definition has been foreshadowed as part of Tranche 2, I think. Isn't it? Well, I guess the question for you is how would you like to see that brought forward?
Thank you, Chair, and my sympathies for your RSV. As someone who lives with multiple toddlers, I can definitely relate. Thank you for the opportunity to address that, and I'll do so as quickly as possible given the time. I think the rationale for the two provisions is slightly different with respect to the definition of personal information. This is an area on which there has been some legal uncertainty for some time in the aftermath of a case, Privacy Commissioner and Telstra, in which left some legal uncertainty about the definition of personal information. And so we would see that would be a clear fix to take away that uncertainty, aid the regulated community in being clear about what their obligations are, and aid our office in unqualified enforcement with respect to the kinds of personal information that might not instinctively be classified as personal information, but which would relate to an individual, as that broader definition proposes. With respect to the fair and reasonable test, we see that as a much more substantive provision that would change and also level up the nature of the obligations in the Privacy Act, commensurate with the kinds of harms and challenges we see, particularly in the digital economy. At the moment, the Privacy Act regime really focuses on the collection of personal information as the relevant process to regulate and control. And what the fair and reasonable test gives us is a way to also try to ensure that the ways in which personal information are being used is consistent with community expectations and in the interests of individuals. And so we think that that's really the linchpin of bringing Australia's privacy regime into the 21st century, as it were. We understand that those two provisions are slated for Tranche 2 of the reforms, and we support that. I wish only to provide my support for bringing them forward more urgently if that's something that government is minded to consider, because we see them being so essential.
Thanks. I'll just ask you, if you can, to take the next question on notice, given the time. I've got two questions. It's about the development of codes. The Business Council of Australia, I'm not sure if you've seen their submission, but they've made some recommendations about essentially requiring you as the Commissioner to collaborate with certain representatives or entities when developing an APP code. And again, they have some recommendations about what should be required to be taken into consideration when developing the Children's Online Privacy Code. I wondered whether perhaps on notice you could let the committee know what process you would normally go through in developing a code, because I would have imagined that those things that are being recommended by the Business Council of Australia are part of your process anyway, but perhaps if we get that on notice, we might be able to look at those two ideas together.
Yes, I think your assumptions are correct, Chair, but I will certainly take that on notice.
Thank you, Ms. Kine. I think that's all the time we have, unfortunately. We're sort of stretching the friendship with our broadcast friends. So thank you very much for all being here today, and thank you for all of your work, your ongoing work, which has just started, it sounds like, but has a little bit way to go, but this is a really good step forward. So thank you very much. That concludes today's proceedings. The committee has agreed that answers to, I'm assuming that the committee has agreed that questions on notice at this hearing should be returned by close of business Monday, the 4th of November. We apologise for the short turnaround time and thank you for your assistance. I want to thank all witnesses who've given evidence today to the committee and also thank Broadcasting and the Secretariat. Thank you, Deputy Chair, for your assistance today, and I declare the hearing adjourned.